Okay. Welcome to the initial public hearing of the inquiry into Budget Estimates 2022-2023. I acknowledge the Gadigal people of the Eora Nation and the traditional custodians on the lands on which we are meeting today. I pay respects to elders past, present and emerging and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respect to any Aboriginal and Torres Strait Islander people joining us today. I welcome Minister Kevin Anderson and accompanying officials to this hearing. Today, the committee will examine the proposed expenditure for the portfolios of land and water, hospitality and racing. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. The proceedings are also being recorded and a transcript will be placed on the committee's website once it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. All witnesses in budget estimates have a right to procedural fairness according to the procedural fairness resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. Minister, I remind you when the officers accompanying you that you are free to pass notes and refer directly to your advisors seated at the table behind you. Finally, could everyone please turn their mobile phones to silent for the duration of the hearing. All witnesses will be sworn prior to giving evidence. Minister Anderson, I remind you that you don't need to be sworn as you've already sworn an oath to your office as a Member of Parliament. For all other witnesses, I ask that you each in turn state your full name, position, title, agency and swear either an oath or affirmation, the words of which have been provided for you. So we'll begin with our first witness on our left, Mr. Leon Walker.
I, Leon Walker, Deputy Secretary, Homes, Property and Development, solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
I'm Melanie Hawes, Deputy Secretary for Crown Lands and Local Government, solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Anthony Keon, CEO of Hospitality and Racing. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
James Michael Bentley, CEO, New South Wales Water Sector. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Andrew George, Chief Executive Officer of Water New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by myself shall be the truth, the whole truth and nothing but the truth.
Philip James Crawford, the Chief Commissioner of the Independent Casino Commission, and I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. I might just ask people, the others, to step up one at a time.
Darren Cleary, Managing Director for Hunter Water Corporation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Rock Sherrill, Managing Director of Sydney Water Corporation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Grant Edwin Barnes, Chief Regulatory Officer for the Natural Resources Access Regulator. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Ingrid Emery, Executive Director of Project Interfaces and Program Management at Water Infrastructure New South Wales within the Department of Planning, Environment and Water. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you.
Steve Griffin, the Chief Executive Officer, Greyhound Welfare and Integrity Commission. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Jennifer Hickey, Chief Executive Officer of Cemeteries and Crematoria, New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Yeah. According to my list, we've got everyone done. So today's hearing will be conducted from 9:30am to 5:30pm, and we are joined by the Minister for the morning session from 9:30am to 12:15pm with a 15-minute break at 11am, and in the afternoon we'll hear from the departmental witnesses from 2 to 5:15pm with a 15-minute break at 3:30. And during these sessions there'll be questions from opposition crossbench members only, and if required an additional 15 minutes is allocated at the end of the morning and afternoon sessions for government questions. So we thank everyone for their attendance today, and we'll begin with questions from the opposition.
Thank you. Morning, Minister.
Morning, Mr Beach.
How are we?
Well, and yourself?
Minister, do you still intend to merge the 4 Crown land managers, Crown cemetery operators that are currently under administration under the One Crown banner into one single operator that will operate all of Sydney cemeteries?
Thanks for your question, Mr Beach, and this is a very sensitive and important issue when it comes to taking care of loved ones when they have passed and ensuring... Quite hear that? Put that over here. It's a very important issue, particularly when it comes to taking care of loved ones when they are at their most vulnerable point of their family, when they are looking to bury a loved one. The development of cemetery space in New South Wales was under threat, hence the reason why a report and inquiry was undertaken in terms of finding new land to ensure that we had adequate burial space in New South Wales. And at this point in time, work is still being done, consultation is still being had with religious and faith-based organisations to ensure that we get that balance right. So the government has not made a decision on the operating model yet.
So do you still intend to merge the sole remaining independent Crown cemetery operator, Catholic Metropolitan Cemeteries, into the new single One Crown arrangement?
Well, Mr Veach, those discussions are ongoing, and as yet the government hasn't made a decision on the operating model in terms of One Crown.
I guess what everyone's concerned about is are you intending to privatise the Sydney cemeteries?
Mr Veach, what we are focused on is ensuring that we develop and have significant space, and it's now a really important part of the government's focus to ensure that we have enough land that we can take care of those who pass well into the future. That's why the report was initially instigated. So we haven't made that decision.
You are or you aren't going to privatise them, Minister?
Mr Veach, we haven't made a decision in terms of the model yet.
Okay, so that could be a yes for privatisation of Sydney cemeteries.
Mr Veach, we haven't made a decision yet.
You said that the consultation's ongoing, Minister. What's the time frame?
Well, significant work is being undertaken, Ms Hughes, and we would like to continue to progress those discussions. They are very complex, they are very detailed, particularly in relation to faith-based organisations, because each one is unique and each one needs to be respectful in terms of their cultural approach, as you would expect. Each religious-based organisation, faith-based organisation, have specific rights and internments when it comes to burials.
I'm well aware of that, Minister. I'm asking if you have a time frame that you are interested in coming to a conclusion, in drawing this process to a conclusion, in making a decision. Do you have a time frame?
It takes time, Ms Hughes. It is a complex process. The government has not yet made a decision on the operating model.
And when is that decision likely?
Mr Hughes, that process is ongoing, and the government is very keen to ensure that they get it right to cover all of those aspects that we're just talking about.
Yes, and you made the announcement suddenly, and you shocked a range of religious groups as a result of it, and I understand that it needs to be done slowly and carefully, but we are interested in, is there a time frame for this coming to a conclusion? Surely you have an idea in your mind of when this is going to be drawn to a conclusion.
It's a very complex process, Ms Hughes, as you've rightly pointed out, but the government has not yet made a decision on the operating model.
Okay, can you say if you will do it before the election?
Ms Hughes, again, discussions are ongoing in terms of One Crown and what that looks like.
Don't need to keep repeating the same answer, Minister. I'm interested to know whether it will occur this year.
Again, Ms Hughes, it is a very complex process. Rather than rush the decision, there is a lot of moving parts to ensure that we get it right, and we respect cultural organisations. So that process will continue, and when we land in the right spot, then we'll be in a position to make further announcements, but the government has not yet made a decision.
Okay, and you're setting the parameter for these discussions. Can you rule out today that you will privatise One Crown?
Ms Hughes, those discussions are ongoing, and the government has not yet made a decision in relation to the operating model of One Crown.
I want to be really clear, Minister. I want to give you the opportunity. This is an issue that is causing serious concern in the community, that the reason why your government announced the merging of these particular trusts is in order to privatise it. Can you rule that out? Can you give the community that undertaking today?
It is a serious issue, Ms Hughes. That's why the search for space has now been made state significant. So we are very keen to ensure that those around the table are being heard, being respectful, and culturally this is a very delicate situation. So we are making sure that we are doing the right thing. We will land on the right position, and we'll make an announcement when we finalise the operating model of One Crown.
Okay, but I'm just giving you one final opportunity. As you finalise that operating model, will you rule out a privatised model?
Ms Hughes, the government has not yet made a decision on the operating model of One Crown.
So Minister, then you haven't tasked Ms Lee Shearer, who's the administrator, with preparing the cemeteries for privatisation?
That's not my understanding, but I will ask my Deputy Secretary to provide further information in relation to the operation of One Crown, the way it's moving forward, and your question.
Thank you.
It's pretty straightforward. Either you have or you haven't tasked Ms Shearer with that job.
The administrator, Ms Shearer, has been tasked with overseeing the operation of the 4 Metropolitan Crown Cemetery operators. She's focused on working to identify and realise efficiencies in ensuring the operators work well together. That is the extent of her remit at this point, to manage the 4 operators that have been placed under administration.
And does that include preparing them for privatisation?
I have had no such discussion or instruction. She is managing the 4 entities that have been placed under administration.
Minister, you met with Ms Shearer, according to your ministerial diaries, on the 23rd of March. Is that correct?
If that is in my ministerial diary, which they are on public record, Ms Hughes.
Did you discuss privatisation with Ms Shearer on that date?
No, we did not discuss privatisation. We discussed a range of things, particularly ensuring that we kept the focus on looking after those most vulnerable in our community at that particular time, plus the search for new space.
Okay, but did you instruct her in her way? I mean, we've just heard that her job is to ensure efficiencies. Did you instruct her to say privatisation is not an option or privatisation is an option? Did you discuss either of those with
Ms Hughes? I've just indicated the discussions were particularly around the search for new space, which is a priority, the reason why One Crown was set up, and we talked about looking after those most vulnerable in our community at their time of need when they need to bury a loved one.
Minister, I just want to, so Ms Shearer's appointment under the Crown Lands Management Act, you actually haven't appointed Ms Shearer herself. It's her private company, Leader Investments Proprietary Limited, as the administrator of the 4 Crown Land Managers, Crown Cemetery Operators. Is that correct?
That's correct.
Yeah, and under clauses 82, 83 and 84 of the Cemeteries and Crematoria Act, as the administrator of the 4 Crown Land Managers, Crown cemetery operators, Leadar Investments and Ms Shearer are subject to a number of statutory requirements around care and diligence, around not improperly using their position to gain advantage, around not improperly using information they may obtain while acting in the position to gain advantage. Is that correct?
If that is the operational component, and I will confirm that with the Deputy Secretary, Mr Beach.
Ms Shearer was appointed on the basis of her experience in the sector and in the role of administrator. If there are specific questions about the terms and conditions of the administration appointment, I'd probably need to take those on notice. I don't have them all to hand here today.
I note that according to ASIC records and the directors of Leadar Investments Proprietary Limited are Ms Shearer and her partner, Mr Darren Shearer, and that the company is owned by another private company called Lee Shearer Proprietary Limited, which is owned by Ms Shearer and Mr Darren Shearer personally. So I guess what I'm asking here is, do you agree, Minister, that this means the statutory requirements I've just mentioned apply to both Leadar Investments and to Ms Shearer as a director of that company, as it's ultimately the beneficial owner of the company? Would that be correct?
Mr Veach, I will ask my Deputy Secretary to provide further information in relation to that.
So Ms Shearer is operating within the remit of an administrator, of being the administrator for these entities. If there are specific concerns, questions, I might need to take that on notice. I don't have the full terms and conditions of her appointment to hand today.
Okay, all right. Mr Chair, I'd like to hand up some documents, if I could, for the Minister. And there's a copy for each member of the committee too. I'll just wait for those to come around.
Sure. Thanks, John.
Yeah. Now, Minister, as you look at those documents, you'll see that they are drawn from ASIC. Can you think of any good reason why Leadar Investments Proprietary Limited, private company of Ms Shearer, the administrator, ultimately owned and directed by her, would have recently registered business names relating to the operation of cemeteries and crematoria in Greater Sydney?
I've just seen these documents, or been received these documents, Mr Veach, so if you would give me some time to read them and then I can comment appropriately if you wish.
I'm happy to give you a minute, but really, is there any reason why that would occur?
I can't answer your question at this time. I'd need further information in relation to that question, Mr Veach, but I'm happy to read these documents then, if you wish.
Well, perhaps we can explain what's in the documents to you.
Sure. Yeah. So what you'll find, Minister, there's a document there from ASIC for a company that's been registered in the name of Ms Shearer, Leadar Investments Proprietary Limited. The name of the company is Greater Sydney Cemeteries and Crematoria. There's also a further registration. Have you got those, Minister?
I'm just working my way through those documents at this point in time.
Let's be clear, this is the person that you have charged with leading the One Crown process, has registered a private company with the name of Sydney Cemeteries and Crematoria. Are you concerned by that, Minister?
That's new information to me at this point in time, but I will, as you heard earlier from Ms Hawes, that Lee Shearer was appointed for her expertise in being able to conduct this particular process, but I will ask...
But Minister, do you think it's appropriate? This is the administrator that you've appointed to One Crown for the purposes of managing the cemeteries and crematoria in Sydney. We've asked you questions about whether or not they're going to be privatised, and the administrator has registered companies, private companies, clearly titled Sydney Cemeteries and Crematoria in their own name. Is that appropriate?
Mr Veach, I'll ask Ms Hawes to respond.
Well, no.
You don't know whether it's appropriate or not, Minister. This is a question. I mean, I can't ask the public servants for opinions. I can ask you for an opinion. Do you think that is appropriate, Minister?
Mr Veach, I've just received these documents and I'll take that question on notice and further investigate them. I'm happy to take the time to look at them now if you wish, but I'm happy to take them on notice.
Minister, seriously, this is a pretty straightforward question. Is that appropriate for the administrator in light of the terms upon which the administrator, and under the Act that you're responsible for, they make it clear around what the administrators can and can't do. One of them is about using information for their own purposes. Is it appropriate, Minister, for these companies to have been registered in the name of Ms Shearer when Ms Shearer, her company, are the administrators of the very same cemeteries and crematoria that she's responsible for?
Mr Veach, I'd need to get further detail and a full briefing on that before I can provide an opinion for you on that, so I'm happy to take that on notice.
The Minister, and members of this committee will know, I quite like reading ministerial diaries. It's something I take quite seriously, as one of your former ministerial colleagues discovered. On the 23rd of March, as my colleague Ms Hughes said, you met with Ms Shearer. Did Ms Shearer flag with you her intentions at that meeting to register companies in the name private companies?
Now, as I've outlined earlier, Mr Veach, that when I met with Ms Shearer, we talked about the complex process that needs to take into account in terms of faith-based organisations and the search for new space.
Well, maybe we need to ask Ms Hawes, were any of these approved?
This is new information, and I'd like to take the time and also to have the ability to have a discussion with Ms Shearer. There may be a range of reasons to do with the operations of Rookwood. I don't have that information to hand, so I'd prefer to take that on notice before we potentially infer that there are things amiss which may not, which is arguably not the case.
Can you see
this
those?
is new information.
These are currently vested in the responsibility of the Minister. The administration, via the legislation and the administration of acts, these are currently publicly owned. They're vested in the responsibility of the Minister. Why would an individual who is the administrator on behalf of the Minister be registering companies clearly with the names Greater Sydney Cemeteries and Crematoria and Sydney's Cemeteries and Crematoria? And that registration took place on the 4th of April, a handful of days after you met Ms Shearer, according to your diaries, Minister.
In relation to those discussions, Mr Veach, it was about the complex process of providing new burial space and the search for new burial space. So this information has just been brought to light, and I'll need a full briefing and further information to be able to provide a response to you. And I'm happy to take that question on notice.
Can you think of any reason why Ms Shearer would have for registering such business names for use by her private company?
Veach, again, that information has just come to light, so I'm happy to get a full briefing before I can provide an opinion in relation to why that was set up.
Do you believe that the actions of Ms Shearer may indicate an intention to breach the statutory requirements of the Cemeteries and Crematoria Act around not gaining advantage?
Mr Veach, again, I will need a full briefing in terms of the information that has just been provided in relation to the document that you have just set up.
So, Minister, if you're going to get a briefing, when?
Mr Veach, that will be as soon as practically possible, Mr Veach. But in terms of what, to come back to your original question and the discussions that we have had, privatisation has not been part of those discussions. So in terms of my view, we won't be privatising One Crown, but in terms of this particular document that you've just furnished me with, and again, it's new information to Ms Hawes as well, we'll get a briefing before I can form an opinion.
Yeah, it's all very well for you to say it's not part of your plans, Minister, but let's just look at the timeline. Ms Shearer met with you on the 23rd of March. A week later, she registers, or slightly longer, she registers a private company with the same title that would be running these organisations. This would be a dramatic shift in government policy. Can you confirm that you did not direct her to do this?
Ms Hughes, the discussions were around the need for more cemetery space and that complex process of looking after those most vulnerable in our community. We did not discuss privatisation.
And you did not discuss the need to set up a private company to administer these existing trusts. Is that correct?
No.
That was not part of your discussion with Ms Shearer?
No.
Okay, can you rule out your office discussing that with Ms Shearer?
I'll take that on notice.
Perhaps you might want to confer with your staff behind you to confirm that this was not a direction provided by your office.
Not to my knowledge.
Okay. Ms Hawes, are you the person in the bureaucracy that's responsible that Ms Shearer reports to?
Well, she's appointed as administrator, so there is a relationship, but she doesn't report into me in that traditional sense as a line manager.
Okay.
She's the administrator for the 4 operators. There may be a range of reasons why Ms Shearer secured that name in her remit as administrator, and I don't want to make comment on that in this forum, but we will take on notice any questions you may have about that.
I'd just like to be clear though, Ms Hawes, you and no one in the department provided her with the direction to set that up?
No, I did not.
So, Minister, how do you feel about Ms Shearer freewheeling and setting up private companies that are linked to her own private interests when she is supposed to be acting in the public interest as an administrator of One Crown?
Ms Hughes, the government's focus is clearly on looking at the operating model of One Crown and development of more land space as we search for land. And it's a complex process. Ms Shearer has done a great job, in my view, in terms of the complex nature in which this environment presents itself. And the document that you've just presented, as we said, we'll get a brief on that, and we will ultimately form an opinion, but I can't do that at this point in time. I'd like further information in relation to that.
It is complex. It is incredibly delicate, as you said at the outset, that we are dealing with people's loved ones and their burials, which is incredibly delicate and difficult. And yet the person that you have charged with this seems to be going around behind your back, behind the bureaucrats' back, and setting up private companies.
I don't think that's the case. I think that she secured the name for Rookwood, which she is the administrator for, but we'd like the opportunity to confirm that. I don't think it's the case that there is an assertion here of freewheeling in a personal capacity. I think it's in relation to her remit as an administrator. So we'd like to take that on notice and get back to you.
So can you explain then why the holder name is her personal company?
Well, she has a personal company, but she was appointed as an administrator because of her experience in the sector.
So it's okay then for the private company to register these names when they're the administrator on behalf of the government?
That's an assertion you're making. We want to...
I'm asking the question, is it okay for that to happen?
I'm not making a comment on that because I'm not even clear that that is the case. I understand your concern and we'll look into that and come back to you.
If you can provide that back to us today, I think that would be quite helpful.
Thank you. I'll pass to Ms Hurst, then Ms Boyd, then Mr Field. Yeah, I'm sure.
Good morning, Minister.
Good morning.
I just wanted to start with some questions around greyhound racing. Exactly how much money was allocated to the greyhound racing industry in the latest New South Wales government budget?
In terms of funding that's been allocated to the greyhound racing industry, Ms Hurst, we provide funding in relation to capital grants, and part of the reform of the greyhound racing industry committed $30 million in conditional capital grants to improve animal welfare, including initiatives to improve safety and track facilities for greyhounds. And at this juncture, around $11 million has been spent on providing that welfare initiatives to ensure that tracks are continually upgraded.
Sorry, Minister, so the total number of money that was allocated to the greyhound racing industry in the last New South Wales government budget was $30 million in total?
That's not what I...
That was my question.
Yes.
My question was how much money was allocated to the greyhound racing industry in the last New South Wales government budget in total?
That was your question, but my answer in relation to funding for greyhounds is $30 million in capital grants. So in relation to funding, that's... How
much money from the New South Wales government was put forward to the greyhound racing industry in total?
$30 million for the capital grants, yes.
Can you also give me a breakdown of how much was actually given to the horse racing industry and the harness racing industry?
Well, in terms of the regional grants, the racing for the regions for thoroughbreds, there was $67 million allocated to Racing New South Wales, and they have worked up a statewide project plan to upgrade facilities right across the regions, including right across regional New South Wales. So $67 million has been allocated in that space.
So it's 67 in total for both horse racing and harness racing?
No, there was a separate budget bid for thoroughbred racing that came out of the budget process.
So how much in total was given from the New South Wales government budget towards horse racing and towards harness racing?
So in terms of what came out of the budget for both, I will take that on notice so I don't mislead you, but in terms of Thoroughbred racing, there was $67 million, which is the racing for the Regions Fund.
Thank you. And can you also confirm on notice that the total amount that was given to the greyhound racing industry was $30 million?
Well, no, the $30 million, Ms Hurst, was part of the Capital Grants Fund that the New South Wales Government has committed. Yeah.
Okay, but I'm just double-checking that that is the total amount of money that was given to the greyhound racing industry as part of the New South Wales Government budget?
No, that $30 million was part of the Capital Grants Fund that was not given in this last round of budget. It was a sum of money that was given to greyhound racing.
That's fine, but my question is, how much money from the New South Wales Government budget was given to the greyhound racing industry? And if you don't have that number on hand, if you could please take it on notice.
Sure. But just by way of background, Ms Hurst, the point of consumption tax, which I'm sure you're familiar with, is part of that process where funding goes to those three codes. So, but just to be clear, I'm happy to take that on notice for you and come back to you.
Thank you. And what about tax exemptions? Was there tax exemptions given from the New South Wales Government to the greyhound racing industry or the harness and horse racing industry in the last budget?
Now, in terms of if you're talking tax, it revolves around the point of consumption tax. Is that what you're referring to, Ms Hurst?
I'm just referring to general tax exemptions across the board because we've had a lot of animal protection organisations that are very interested in this space, and when they're looking at the New South Wales budget, it's not clear exactly the total amount of taxpayers' money that is going towards those racing industries and what kind of tax breaks in total are going to those racing industries. And I was wondering if we could get any kind of really clear figures that the public can then use to understand and have some more transparency around what tax breaks is given to these industries and what tax money is given to these industries as a total figure.
I'm not sure that tax breaks is the right word, Ms Hurst. What happens is that the racing industry generates about $3.3 billion for the New South Wales economy and sustains more than 27,500 full-time jobs. And outside of recent funding commitments, it shows how valuable this industry is to the New South Wales economy, and 2% of total taxable non-wagering revenue will be provided to the industry. But commitments from the introduction of the point of consumption tax, and that's where they get their funding from, includes that 2%. So Thoroughbreds in the 2021-22 period, that delivered more than $47.8 million to the three codes, and that was split up.
Sorry, Minister, I'll just take you back to the question. So the question was around what tax exemptions are given to the industry. And so the question that's coming from a lot of groups that are working in this space is, are there tax exemptions given to these industries, and what are they and for how much?
Well, the funding methodology for the racing industry in New South Wales across those three codes, Treasury has the primary responsibility for wagering and taxation, so that's a question for Treasury. And that led to the implementation of the point of consumption tax and the dividends that go back to those three codes. So it would be a question for Treasury in terms of tax exemptions, but the point of consumption tax is the main source of funding for those codes.
Okay, so you're not aware of any tax exemptions. I want to ask about the Greyhounds as Pets program. In April this year, the project ran a story on the failings of industry rehoming organisations and the number of greyhounds that are rejected or refused to be taken on by the rehoming organisations for reasons as small, reported as a broken toe. As the Minister for Racing, do you find this acceptable that the industry rehoming body is actually rejecting greyhounds for rehoming reasons such as a broken toe?
Ms Hurst, if you've got specifics in relation to that, then we would be very interested to take a look at those. But I think there is a very good story to tell in terms of rehoming of greyhounds.
Sorry, my question, Minister, with respect, was: do you find it acceptable that the industry rehoming body that is funded by the government is actually rejecting animals, such as having a broken toe?
Well, I'm unaware of the operating procedure in terms of the rehoming bodies, and if there is an injury to the dog, you would expect that the greyhound would receive the appropriate treatment, which they would and do.
Sorry, and who would they receive that treatment from if the rehoming organisation is rejecting them?
Well, it's not a case of rejecting the dog. I think that, Greyhound Racing New South Wales and the Greyhound Welfare Integrity Commission do a very good job in ensuring that the rehoming pathway for retired greyhounds who are exiting the industry is very clear. And
so what happens to the dogs if they've got a broken toe?
So we'll have to stop you. We'll have to go to Ms Boyd now and then.
Thank you, Chair. Just on that line of inquiry then, I'm also aware of this happening on a regular basis, but also GAP refusing to take back greyhounds that they've placed and putting the onus on those who have sort of opened their homes to a greyhound to euthanize a dog. Are you aware of this refusal by GAP to take back dogs that have been inappropriately rehomed?
Not sure of your question, Ms Boyd. There was a little bit in that right at the start. Can you just be clear in terms of, are you talking about euthanasia? Are you talking about rehoming? I'm just not quite clear.
Are you aware of GAP refusing to take back dogs that have been placed with people and then are being brought back?
You're saying that the dog has gone to someone and then
brought back because the dog
Greyhound
has
as Pets program.
Yeah, perhaps the dog has a behavioural issue or there's some other issue with the dog, and then the GAP basically says too bad.
Yeah, no, I'm unaware of that.
Minister, recently a Greyhound Racing New South Wales participant was charged with 27 serious offences by GWIC and was disqualified for a total of 30 months. The charges that were found to have been made out included failing to provide information on the location of over 37 greyhounds, providing insufficient kennelling and whelping facilities, lying to officials and on official documents. The GWIC decision gives details that are incredibly grim about so many puppies being killed, squashed, neglected, not taken to the vet when they should have been, etc., etc. This same person has recently had a DA approved for what was previously an illegal greyhound housing and breeding facility by Port Stephens Council. How can that be? How can a person within the industry who has had those sorts of charges against them then receive approval for another intensive greyhound boarding and training facility? Does that make sense to you, Minister?
No, it doesn't make sense to me, Ms Boyd, and I think that the Greyhound Welfare Integrity Commission have done the right thing. We have zero tolerance for any form of animal abuse or mistreatment in terms of the welfare of the greyhound racing industry, and we've come a long way over the last couple of years to rub those people out of the industry, and they don't belong, shouldn't belong, and the 30-month suspension of this particular gentleman, obviously the Greyhound Welfare Integrity Commission are doing their job, and as they should. So in terms of that application for further training facilities, I'd like to ask Mr Griffin, who's from the Greyhound Welfare Integrity Commission, who's familiar with this case, to provide further information in relation to that last bit of your question.
Yeah, and I'd like to know specifically why there's no rules for council to have to consult with GWIC before they approve something like this.
Yeah, thanks, Minister. Well, the latter part of your question is a matter of government policy, but regardless of the DA approval, I can assure you that the participant under disqualification will not be permitted to run a Greyhound facility regardless of being given DA approval by that council. So the council aside, you certainly will not be permitted by the Greyhound Welfare and Integrity Commission to run a Greyhound kennelling facility at that location.
So presumably then he will set that up and have it all ready for when his suspension is lifted or his disqualification is lifted and then is free to again be responsible for hundreds of Greyhound puppies?
A participant who's disqualified has to reapply at the end of their disqualification period. There's no guarantee that they'll be reissued with the same licence and registration.
This is a person. This is a person who has been in the greyhound racing industry for over 20 years. They were part of the McHugh inquiry, admitting to euthanizing dogs without taking them to a vet. They have a long history, and they were referred to by other people as a bad apple within the greyhound industry. And yet this person has, until quite recently, been a person still in the industry. How does that happen? How did this person not get disqualified a long time ago?
Yeah, there was some suspension of the participant back in 2020, but there has been I agree that the actual process has been protracted in relation to these 27 charges, not on behalf of the Commission, but by the fact that due process needed to be applied, given the participants' alleged ill health during the period that we're taking the prosecution through. But I can assure you, at the end of the day, all of those factors Ms Boyd will be taken into consideration, particularly the historical factors, once that participant applies for re-entry to the industry and after the period of disqualification.
At the end of the GWIC decision, it does say, I'm trying to find the bit, that in mitigation of penalty, the applicant, the particular person's experience in the industry, including the large number of greyhounds bred and reared at his property, was taken in as a mitigation of penalty. How does that work? Why is his experience in the industry, given his particular history of neglect of puppies in particular, how did that mitigate his penalty?
Yeah, that's based upon precedent and based upon feedback from the Racing Appeals Tribunal and precedent cases that, as the controlling body, were required to take on board in the context of making the decision, the participants' length of time in the industry and their volume of greyhounds that they've had in their care during that time.
Thank you. And sorry, just Minister, are you prepared to take on this issue, this disconnect between a council DA being approved and, at the moment there being no requirement to go to GWIC? Are you prepared to take that on as a policy issue and speak with your counterparts in local government?
Well, we take all animal cruelty issues very seriously. Greyhound Welfare Integrity Commission, as Mr Griffin has rightly pointed out, is paramount. Once it leaves the industry, it's part of a local government act, but it does concern me, and I would expect that the Greyhound Welfare Integrity Commission would provide all information required to the local government authority in that regard in terms of any particular greyhound racing facilities into the future.
Mr Field.
Thank you, Chair. Good morning, Minister. I want to move on to water if we could. The Environment and Heritage Group, in advising Minister Griffin on the recent amendments to water sharing plans to include floodplain harvesting rules, stated that they considered the proposed encatchment targets to be too low, do not consider the long-term health of environmental assets and do not support the water management principles in the Act. Can you explain why you think the rules for floodplain harvesting comply with the priority of use provisions set out in the Water Management Act?
Well, thank you, Mr Field, and this has been an issue that's been kicking around for quite some time, particularly in relation to bringing floodplain harvesting under the compliance and the rules that are required within the TAPE. Significant work has been done on floodplain harvesting, and we believe that, while some may think the targets are never high enough. Others believe that they are.
I'm not asking for a belief, Minister. I'm asking for you to explain how the rules comply with the principles, water management principles in the Act. This can't be a subjective test, clearly. It's a statutory obligation.
Mr. Field, the process has concluded and the water sharing plans have been made. There's been advice from the department, and it is lawful and is consistent with the principles.
What's that advice?
Act.
The fundamental test in regards to water sharing is set out in the water sharing plans is that the sharing of water, in the Act, is that the sharing of water from a water source must protect the water source and its dependent ecosystems, and that sharing or extraction of water under any other right must not prejudice those dependent ecosystems. So explain to me how you've made the judgment that the rules for floodplain harvesting haven't prejudiced dependent ecosystems, because that's certainly the advice of EHG.
Well, Mr. Field, the advice from the department is that it is lawful.
What's the advice? What advice?
It is consistent with the principles of the Water Management Act.
Is that advice published?
And the Environment Minister, Mr. Griffin, has provided concurrence. So they are in place now. They are lawful and within the principles of the Water Management Act.
I'm sorry, Minister, I'm not going to take your word for it, because ICAC found that the department historically has failed to deliver on the principles of the water sharing, on the Water Management Act. So can you please provide the document that lays out how you're fulfilling the priority of use provisions of the Water Management Act?
Mr. Field, I'll take you back to the ICAC report on water manners. It released its report into water management issues in November 2020. It found no findings of corrupt conduct. I
wasn't suggesting corruption. It found you hadn't complied with the requirements of the Act.
Mr. Field, if I can reiterate, I don't know how clear.
In fact, it described a lengthy history of failure in giving proper and full effect to the objects, principles and duties of the Water Management Act. Minister, can you explain how the rules for floodplain harvesting meet the requirements of the Act?
Mr. Field, that process has concluded. There has been significant work done in this particular space, and I know you like to play games in the upper house with this, but when I travel around regional New South Wales in relation to floodplain harvesting, it is consistent with the principles of the Water Management Act, and how? There is concurrence.
Show me how.
There is concurrence from Minister Griffith. So in terms of this particular process, the water sharing plans in relation to floodplain
because you said so, and because Minister Griffin said so, is not an answer to the question, Minister. Minister, in response to ICAC, you undertook, or the government undertook, to do a Section 10 review. Are you aware of what a Section 10 review is?
Yes, I am, Mr. Field.
What is it?
Mr. Field, I'm not going to get into the detail in terms of...
Okay, so the Section 10 says the Minister is to ensure that the work and activities of the department are reviewed at intervals of no more than 5 years for the purpose of determining whether they have been effective in giving effect to the water management principles of this Act. When was the last Section 10 review done?
Mr. Field, I'll have to take that on notice, but...
has this government ever done a Section 10 review?
I can't make it any clearer for you that it is in the principles of the Water Management Act, and Minister Griffin has given his concurrence, and the advice from the department is that it is being made lawfully. So I don't know what you don't understand about that.
Publish the advice that shows or describes how you think the rules for floodplain harvesting are consistent with the water management principles of the Act.
Mr. Field, I'm sure that through the SO52s and the games that you've been playing upstairs, you would have that information. So please, you will have that information.
Okay, well, let's go to the SO52. Let's go to the letter from the email from Dan Connor to Dr. Bentley on the 11th of February, where he's describing pathways forward for floodplain harvesting. This is after the disallowance late last year. He describes downstream flow targets. One idea could be to include rules to prevent floodplain harvesting access when there are downstream critical human and environmental needs. Strangely enough, that looks like it's about trying to meet the requirements of the Act. At the end of that section, he says, it will strengthen the case that the Minister is taking reasonable steps to comply with the Act. A legal challenge on these grounds is considered likely. Why would he think there's a legal challenge likely?
Well, Mr. Field, as you know, water in any space is very, very complex. So when you introduce a particular rule, for us it's a very challenging situation to be in. You've got to find that right balance. We believe we found the right balance in terms of they are consistent with the principles of the Water Management Act, and they've been lawfully made. So that's the position they're in now. We're cracking on with making sure that we ensure healthy rivers, healthy farms, healthy communities, and that floodplain harvesting is now being carefully managed, and the metering systems that are being rolled out across the state, I think the Murray-Darling Basin is in a good position with the work that's been done, significant work that's been done. Floodplain harvesting was the last unregulated water take, and that has now been brought into line, and we're cracking on with ensuring we have healthy rivers, healthy farms and healthy communities.
Thanks, Chair.
Thank you. I'll pass back to the opposition.
Thank you. Thank you, Minister. At last budget estimates in March, you would not commit to publishing a public response to the now retired Commissioner Bush's report or evaluation on the Crown Land Management Act 2016 implementation. I see on the website, the Department website, you're now going to consider his recommendations as part of the 5-year statutory review of the Act that doesn't start until at least July 2023, which is 2 years after Commissioner Bush's really good work. Why are you not providing a separate and timely response to the comprehensive evaluation report provided by the then Commissioner Bush?
Mr. Beach, thanks for your question. Look, I think Crown Lands have been doing a very, very good job in relation to making sure that we look after those lands right across New South Wales, and particularly the trusts that manage those lands. They are volunteers, and we thank them for their service, and we're doing everything we possibly can.
They all participated in Commissioner Bush's evaluation, and they did so in good faith. So the longer you push out the government's response, aren't you breaching that faith with all those really hard-working trusts you just spoke about?
No, not at all. Look, I'd like again to reiterate and take the opportunity to thank Professor Bush, who took the evaluation of the Crown Land Management Act 2016 and the guiding role that he played in bringing to life the strategic directions outlined for Crown Lands in 2031. He did do a good job.
He did a very good job.
And that good work is now being taken up and being progressed thoroughly, and I think we're in a good space in Crown Lands under the direction of Ms. Hall.
If it's such good work, Minister, why are you taking so long to respond to his findings?
Well, in the early days of the 10-year strategy and the initial 3-year action plan, they were looking at better ways, as there always is a continuous improvement exercise process, and some of those options are being taken into consideration now. I'll ask Ms. Hawes if she'd like to further elaborate for you, Mr.
Thanks, Minister. We recently launched our first implementation piece under the state plan. It takes forward a number of the themes that were covered in Commissioner Bush's report, including better access to information for communities who are interested in Crown Lands. We launched a pilot of reforms to commercial leasing for marinas, which involved a close partnership with one of the former members of the task force. The work is heavily switching into implementation mode, and the other recommendations that came through from that report are being considered as we prepare for our statutory review, which is obviously a really important opportunity to think about improvements to the legislation.
Yeah. As someone who spent a fair bit of time on my feet talking about this legislation in the New South Wales Upper House with my then opponent, the Honourable Noel Blair, I've got a fair interest in this. The Commissioner's role was a significant part of the debate. It's a really critical, that work was critical. People from all sides of politics wanted that work to be done. Commissioner Bush, we all applaud his appointment. He did a very good job. And I think we all agree that he did a very good job. I can't see why you're saying some of the recommendations are underpinning, the others will wait until we commence the 5-year statutory review. That review isn't starting until 2023, Minister. Like, by then, the excellent work of Commissioner Bush will have started to date, surely.
No, not at all, Mr. Veach. 2023 is only a few months away, so significant work has been done on the back of Professor Bush.
Compared to when Commissioner Bush handed his report in?
We are approaching 2023, and there's significant work that's already been done as part of the recommendations of Professor Bush, and Ms. Hawes and her team under Crown Lands are doing an exceptional job, and there are many, many highlights, and part of that is looking at what we do need to do with partnering with councils and local Aboriginal lands councils to look at housing opportunities to address the critical social and affordable housing crisis in New South Wales. Like, we're working proactively with councils to open up unused Crown land and repurpose Crown land. So
the Commissioner's role and that very good report. The statutory review, as you would appreciate, Minister, it focuses on bigger questions around the Act. since its commencement, Commissioner Bush's role was his review was slightly different. It was around the implementation. So why? I just can't understand why you would, if you've already started responding to some of the recommendations, as Ms Hawes has said. Why are we not doing all of his report in one go? Why are we not saying, okay, where's the public response from the government to the recommendations on that very good body of work?
It is a big body of work, and you're right, Mr Veach. To roll it all out in one hit would take significant resources, and we are ensuring that Crown Lands is continuing to meet their strategic plan objectives. And I'll ask Ms Hawes if she'd like to elaborate a little bit further on some of that work.
Thanks, Minister. And I think it's important to note that many of those recommendations are live and being implemented on the ground right now. The reforms to leasing, reforms to enhance the way we broker cut through on Aboriginal land claims and have negotiated outcomes with Aboriginal stakeholders, improvements to customer service. Part of the thinking that the task force and Commissioner Bush really pioneered was about step reforms that will lift the performance of the whole agency. And those things, they are certainly not sitting on a shelf. They are live, they're being implemented on the ground, and any remaining residual recommendations from that work will be picked up in our review of the statute, which has already commenced. We're not waiting for 2023, we're already planning for that now.
So Minister, a part of Commissioner Bush's work was around communication. Got the report, people don't know what the government's doing with regard to these recommendations. So we hear today that there is some work being undertaken. Surely if communication was an issue, wouldn't we communicate as government what you were doing? Wouldn't the government say, actually, you know, we've got to tell people what we're doing here rather than let people don't know. They engage in this process, Minister, in good faith, and they actually don't know what the government's response is. So we find out today that some things are being undertaken. Communication then must still be a problem because you haven't communicated with people, Minister, what is happening to each of the recommendations of Commissioner Bush.
Well, I think that communication process is underway, Mr Veach, and what we are doing is cracking on with is getting onto the front line work and providing the communities that we serve across the region of New South Wales that have touch points within Crown Land, the information that matters to them, whether it be through marinas or whether it be through reflections, holiday parks or...
But have you told them what you're doing with Commissioner Bush's recommendations?
I'll just check, and pretty sure we are.
So we do have very active communication with all the previous task force members. We launched our action plan in a public way. It's online. We have recently refreshed our website because, to be frank, it was a little dated and clunky, and now it's much more accessible for people. We regularly update stakeholders on the progress that we're making with our state plan.
So now, the report, as you and I both agreed, was a really good body of work by Commissioner Bush, and he's highly respected. Why are we not appointing a new commissioner?
I don't think we need a new commissioner, Mr Veach. I think the work that's being done by Crown Lands, and obviously Professor Bush did a great job. I think you've got to continue to look at professional organisations and evaluate their progress and what they need to do to deliver the services and outcomes of our communities. I think the model that we've got now under Ms Hawes here is achieving those strategic outcomes with the plan going forward. Crown Lands are doing a great job. We're seeing a lot of progress in a lot of different areas, and particularly up, and I'll just highlight just on the North Coast, when we talk about immediate actions, we are able to do this great work like open...
Yeah, but the Commissioner, this is about the Commissioner's role. I'm not...
Yeah.
Okay, but...
We don't need it.
You don't, so it's now changed. You don't need the Commissioner. Have you conveyed that sentiment to stakeholders across the state who are still ringing all of our officers saying they haven't replaced Commissioner Bush? When are they going to replace Commissioner Bush?
Yes, that communication in terms of what Crown Lands is doing on a much broader scale is certainly out there. Ms Hawes and her team are doing a great job.
Have you told people, quite simply, you are not going to replace Commissioner Bush? The role is you feel the role is no longer required. Have you told people that?
Well, in terms of, I haven't had any personal questions or requests in relation to what are you doing with the Commissioner, but Ms Hawes may have received some.
Look, it's okay. I'm going to chew up time with my colleague here, and we work to a clock, so if you don't mind, I'll leave it there, but thank you.
I wanted to come back to this issue of the Sydney Cemeteries and Crematoria, the registration of this new private company by Ms Shearer. I wanted to ask you, Minister, are you concerned by this particular... Well, sorry, no, let me say this. If the cemeteries were to be privatised, would you be comfortable with the current administrator taking a financially profitable role or having a financially profitable arrangement with a new privatised operator? What's your opinion on that?
Ms Hughes, I'll take you back. I said earlier in my testimony that the government has no intention, to my knowledge, and I'm the minister responsible for privatisation. The discussions that we've had with Ms Shearer are all in relation to the search for new space. It is now state significant. So in terms of the document that was presented by Mr Veach earlier, we will get advice on that and come back to you with a more formal response when we are briefed, but I'll ask Ms Hawes if she would like to add anything further.
Thank you. My understanding is that it's the registration of a business name, not a private company. So we will take on notice the questions you have raised about that, but that is something that Ms Shearer has been clearly actioning in the capacity as an administrator. If there is a further decision to further amalgamate the 4 operators, that would be accompanied by the appointment of a board.
Okay, but Minister, are you concerned? I understand that it might be the registration of a business name, but a private company is a very different operating model for our cemeteries than is the current arrangements under a trust. There are very different obligations, there are very different rules. Even if there is a board, there are very different rules on members of a board of a private company versus members of a board of a trust. Are you comfortable with that kind of arrangement and with Ms Shearer progressing that kind of arrangement by registering a private business name?
Well, Ms Hughes, my dealings with Ms Shearer have been all around progressing One Crown. And the document that you've provided and Ms Hawes has provided further commentary for you. My view is that we will continue to progress trying to stand up the model of One Crown. The government has not yet made a decision, and if there are other further matters in relation to Ms Shearer and the document that was produced earlier, we'll come back to you with further clarification on that this afternoon.
So why then, Minister, if One Crown wanted to register, if it was One Crown and not Ms Shearer that wanted to register those business names for the operation, why didn't they do it through one of the existing 4 operators like they did for the One Crown business name when it was registered?
Well, again, Ms Hughes, the discussions that we've been having as a government with Ms Shearer are looking to progress One Crown and looking to land on an operating model so that we can provide the
Minister,
security.
You're not answering my question. My question is that when One Crown, the business name, was registered, it was done through one of the existing 4 operators. Why wasn't that done? Why was this registration process done by a private company and not through one of those existing trusts?
Well, again, Ms Hughes, I wasn't party to those discussions back then, but I'm sure that Ms Hawes would be able to provide you further information if you need it.
It's something that we'll ask the administrator. The administrator has a degree of independence in that role and is not here to answer the question, so we'll take that on notice.
Do you believe these actions may indicate an intention to breach the statutory requirements of the Cemeteries and Crematoria Act around not gaining advantage?
Ms Hughes, again, my dealings with Ms Shearer in relation to providing the services that loved ones want across regional New South Wales. I've not had discussions with her in relation to the matter that's been brought forward.
My question's not about the discussions you've had with her. My question is about the perceived or it may be an intention to breach the statutory requirements that govern Ms Shearer's activities. She is not allowed to gain personal advantage from doing the work that she's doing, and yet she's registered a business name through her private company, a private company that I understand she and her partner own that undertakes also landscaping opportunities. Minister, are you concerned about Ms Shearer breaching her statutory requirements?
Ms Hughes, as we've said, we will get further clarification and briefings on that document that you've brought forward, and we'll have that information for you in relation to Ms Shearer's intentions and what that document represents later this afternoon.
Let me be very clear. After the lunch break, we are expecting a considered response from the department about these perceived conflicts of interest and how they are being addressed. Now, do you think, Minister, You've had a chance to look at the documents now. You've had a chance to digest them. Do you think that these indicate plans on the part of Ms Shearer to gain a personal advantage?
Again, Ms Hughes, the documents were presented to me this morning. We'll have those discussions with Ms Shearer and get an explanation as to why she went down that pathway. Ms Hawes will do the same, and we will come back to you this afternoon with further information. Ms Hawes would like to further comment.
Just to be clear, it's a registered business name at this point, and my understanding is that it's been transferred to Rookwood, so there is no personal interest, but we will clarify this.
When was it transferred to Rookwood?
I'll need to get that on notice.
Are you able to provide
this afternoon, hopefully, yeah.
Excellent.
Absolutely.
Okay, on the date in which it was transferred?
This afternoon.
Okay, thank you very much. Minister, would you be concerned if Ms Shearer had made an agreement with another party that involved the purchase or the operation of any future privatised Sydney Crown cemetery operators?
Ms Hughes, the hypotheticals in relation to the intentions of Ms Shearer, my dealings with her have been about standing up One Crown, working through those complex issues, particularly around finding further ground so that we can provide further burial spaces for people to bury their loved ones into the future. So we'll have that information for you in relation to Ms Shearer's intentions later this afternoon.
This is very important, as you say, because there is an extreme shortage of space, and there is no doubt that we are going to run out of space. But this goes to the integrity of the person that you have appointed to administer these trusts. And you spoke earlier about Ms Shearer's expertise in the area, but yet here we see Ms Shearer is registering private business names without any assistance, without any direction from you or from the department, and we are deeply concerned about this. What is the expertise that you talk about that you are comfortable with Ms Shearer resting on taking these decisions?
Well, my understanding, and I'll ask Ms Hawes to further elaborate in a moment, but that appointment predates me in terms of her expertise in terms of administration. But she clearly demonstrates qualities that are able to bring together very complex, very delicate, culturally sensitive, faith-based organisations to try to find a way forward in
How has she
relation
done
to
that previously?
One Crown.
Can you explain that, Minister?
So yeah, I will ask Ms Hawes
Minister,
to
I'm
do that.
asking you about your discussions with Ms Shearer about why you are confident that she is the best person to do this. What's her previous experience that's done
the
this?
discussions, again, the previous experience that predates me, but the discussions that I've had with Ms Shearer relates to that very complex matter of standing up One Crown.
Ms Hawes?
Yep, thanks. So Ms Shearer is an independent appointment as an administrator. She doesn't report to me, and the decision to bring her on was prior to my current portfolio. What I will say is that what I know is that she was interim CEO for Rookwood and had strong standing in the sector as someone who understood the different faith-based groups and had experience in the internment industry, and that was a part of the decision, obviously a strong part of the decision as to her suitability for the administrator role.
So can you explain, Ms Hawes, and I understand that predates you, but why, if it's her specific experience, that her private company was appointed as the administrator and not she herself?
We're conflating that. She is operating as an administrator, and if there are anything substantiated in the things you're raising today, of course we would look into that. But she's registered a business name, and my understanding is that has been transferred to Rookwood. It's got nothing to do with her other interests.
No, but my question to you, Ms Hawes, is if she is the one that is undertaking the role as an administrator, why is it that her company was appointed as the administrator, and a company that I understand also trades as a landscaping design business?
I'll take on notice the specifics of her appointment, but your question was about why was she selected for the role, and my understanding was that it was her prior experience in the sector.
That was my previous question. My next question was, why was her company appointed? Why wasn't it her in an individual capacity, when my understanding is that the company also trades as a landscaping and design business?
I'll take that on notice because I'm not privy to the specific rationale, but I'll get that back.
Thanks very much, Ms Hawes.
And that information will be back after the lunch?
Hopefully, yeah.
Yeah, that would be
I'll do my best, yeah.
Really good if you get that back to us at the start of our second. Minister, I was just talking about internment. I will talk about the proposed internment industry scheme, but particularly as you would be aware, this relates to rural and regional councils. So you published in June that the Cemetery and New South Wales has sensibly dropped the perpetual maintenance of cemeteries capital fund provisions that were the draft version earlier this year. However, it still treats regional councils who operate cemeteries exactly the same as private operators. Now, Minister, someone from the regions, you would know, why are we recognising the councils are fundamentally different to private cemetery operators? Why aren't we doing that?
It's a good question, Mr Veach, and thank you for asking, particularly in relation to councils in regional New South Wales, and not only in regional New South Wales, but the renewable internment rights right across New South Wales. And just
causing some angst.
Beg yours?
It's causing some angst.
Yeah, it is, and you're right. That's why we're making sure that we're trying to get it right going forward. And as you know, renewable internment rights entitle a person to 25 years when it comes to looking at finding a space for their loved one into the future. Look, New South Wales, at this point in time, we are working on looking up and working with councils and addressing their issues in relation to the costs, particularly around maintenance going forward. It's a body of work that we are aware of and we are moving forward on.
I think my time's up, guys.
Thank you. I might start before I pass to my Deputy Chair. Minister, I might start with the Yarra Lake Trust, just to recap your memory. There were some concerns around failure to lodge financial returns and produce accounts for around a decade, and then the former minister committed to doing a review, which we found out last estimates was done by Deloitte, and your department was expecting that report within a couple of weeks of estimates. Has that report been delivered?
Thanks, Mr Banasiak. And my understanding is that report has been delivered, and I can ask Ms Ross for further details if she wishes.
Yes, thank you. So the board has been re-established. The report was delivered. It had no substantiated findings of anything inappropriate or improper, but we do have a new board. It held its annual general meeting in July, and a strong part of that meeting was making it very clear to the new board that they're required to complete the annual report for 2022, and that's due in October.
Okay, how much did we...
We're on to a new start with that board.
Are you able to table that report for the committee to have a look?
It hasn't come... The Deloitte report?
Yes.
I think we previously did provide that, but I can
No, last estimates you said you were waiting for it in a couple of weeks.
Yep. Yeah. We can certainly provide some elements of it. I'm not sure if there's anything that's sensitive in there on a personal identifying way, but absolutely.
I'd happily accept that you do it to identify any personal information, that's fine. How much did we pay Deloitte for this report?
I'd need to take that on notice. I don't have it to hand, and it was quite some time ago.
Okay. How many people were interviewed or consulted by Deloitte to produce this report? Was it just the one person who was the subject of concern?
No. They were looking at the records and the information held by the board members. I don't know exactly how many people they interviewed because the process was quite some time ago now.
Okay. Can you take that on notice? Also, perhaps take on notice how far back Deloitte did go in terms of unpresented financials to establish that there was no substantiated findings?
Can do, but we do have annual returns for 2017 and 18 and the 2019 years. So it was really the 2021 that was missing, and the new board has been, set up and clearly made aware of the need to
they had missing financials for over a decade, so I accept that there was 2017, 2018, 2019, but that doesn't excuse 2015 and back.
No, we can take that on notice, but I also do note that many of the Crown Land boards are volunteer-based. And that has been a factor in the past in terms of getting them up to speed with more contemporary reporting requirements as legislation's changed. They are volunteer-based boards in many cases.
Like any not-for-profit association, they're all volunteer, but they still do have a legislative responsibility to follow Incorporations Acts and Associations Acts. So, if any more information you could get on that would be great.
Certainly.
But just on that, Mr Banasiak, what Crown Lands do is they do work very closely with trusts and volunteers to ensure that they have all of the information required, that they are upskilled in terms of their obligations and requirements. So that's part of what Crown Lands is doing in terms of looking after those volunteers who do put their hand up and say, yeah, we'll work with you on these particular areas.
Yeah, sure. Look, I accept that this may be an exceptional case where things have gone a little awry over the time. Minister, can I just turn quickly before my time runs out? Can I start looking at the Sustainable Diversion Limit Adjustment Mechanism projects? We delved into a fair bit of this last time around, but you were aware of the annual assurance report from December last year, which sort of indicated that pretty much all of New South Wales projects are at risk of not being completed by 2024. They're at extreme or severely high risk of not being completed. You're aware of that report by the Murray-Darling Basin Authority?
Yes, I am. Yep.
Does that concern you?
It does concern me, purely because I don't believe that it's taken into consideration all of the good work that has been done in relation to, again, it comes back to the overarching, Mr Banasiak, excuse me, that I work under is healthy rivers, healthy farms, healthy communities. So when you look at the work that's been done around SIDLAMs, you look at the off-farm efficiency program, you look at some of the connecting river country work that's been done, the Northern Basin Toolkit, to ensure that we're getting enough water in the system to meet the needs.
Minister, I'm not denying that work's been done, or in your description, good work's been done, but it seems that the good work hasn't necessarily delivered good outcomes in terms of progressing these projects. As we outlined in estimates last time, many of them are still stuck in design phase, and we are 18 months away from a 2024 deadline. And for the benefit of the committee and Hansard, what happens when we hit that deadline and those projects aren't delivered? Where does the water come from?
Well, New South Wales has done the heavy lifting when it comes to the SIDLAM projects.
That's not my question, Minister. Where does the water that has to be saved come from if we can't deliver those projects at the end of 2024? It comes from farmers, doesn't it? They cop it again in the net because the department's dropped the ball.
No, I don't think...
Potentially has dropped the ball. If we don't get these projects, where does the water come from?
So the water will come from a significant number of measures, and I think, Mr Banasiak, are you referring to buybacks when you say it comes from farmers? Well,
what other option do you have? You had to meet those water-saving targets. If you don't deliver those projects, where does the water come from? So the water... It doesn't... You can't click a finger and make it appear out of nowhere.
What I think we need to take into consideration here is the broader concept of water recovery and making our rivers healthy right across the basin, from the north right through to the south. Now, whether that be through the rescope SIDLAM projects, the Better Barker, Better Bidgie, whether that's the off-farm efficiencies, or whether that's looking at the better way that people are managing their water, it's something that we are very, very focused on. I'm asking for the Basin Plan to be reviewed. I think that the numbers, the volumetric number that was set 10 years ago, doesn't reflect the environment that we are now in. We went through how many years of drought, so those numbers are based on this state going through significant drought. So the work that's being done, the volumetric number doesn't represent the heavy lifting that New South Wales has done, and it's something that, Mr Banasiak, it's a good point you raise. It's something that I will be raising at the next MINCO in October. I'm asking for more time on the plan. We won't meet that deadline of 2024. That's why we need flexibility to take into consideration the work that's being done to recover water, to ensure we have healthy rivers, healthy farms and healthy communities.
Thank you. We'll pick that up.
Thank you.
Bless you.
Minister, we were talking before about the industry rehoming body rejecting greyhounds for rehoming for reasons like a broken toe was reported on the project. What happens to the greyhounds that are rejected by the industry rehoming body?
Look, I'll have to take that on notice, Ms Hurst, but I can tell you in terms of the numbers in relation to rehoming...
I'm not looking at the number that they've rehomed. What I would like, though, is maybe a percentage of the dogs that GAP has actually rejected. If you don't have that on hand, I'm happy for you to take that on notice.
Yeah, I will take that on notice, but what I would also like to pass comment on, particularly in relation to the rehoming numbers, those numbers are strong. They are strong. The amount of work that is going into rehoming greyhounds, particularly right across New South Wales, and you yourself, Ms Hurst, would, when you move around, you will see more and more greyhounds as pets being walked on the street. So
and how much of those is coming from the industry rehoming organisation, and how much is that being done by private charities external to that industry rehoming body?
So the rehoming policy is working well. It is working.
Sorry, the question was, how many of those greyhounds? You talked about a number of greyhounds that are living in people's homes as companions. How much is coming from the industry rehoming body, and how much of that work is being done by private charities like Greyhound Rescue, for example?
Well, I think it's the heavy lifting has been done by everybody, Ms Hurst. Everybody plays a part when it comes to looking at what they need to do to protect greyhounds when they exit the industry. So we're seeing more and more greyhounds. We're seeing the farm that Greyhound Racing New South Wales is looking to implement.
And I've got some questions on that, but I just want, you did mention that, there's a lot of heavy lifting being done by these other charities outside of the industry rehoming body. Do those charities get any New South Wales government funding to help the amazing work that they're doing that you pointed out?
I'll have to take that on notice, but I can come back to you on that.
And I also wanted to know what it would cost per dog on average for GAP to actually rehome them. So in other words, on average, how much does it cost per dog to rehome from the industry rehoming body? And I'm happy for you to take that on notice if you need to.
Yeah, thank you, Ms Hurst. Look, we've got some numbers here, and I was just tracking them down, particularly in relation to rehoming. The numbers are solid. They are.
Sorry, I haven't asked anything about rehoming.
But I'd just like to update you in terms, because I know you've got an interest in rehoming, and that's
my interest is in the number of dogs that are being rejected from the industry rehoming body, and where those dogs are ending up, and who is helping to fund the rehoming of those animals.
Sure, I'm happy to take that on notice, but I just would also like to place on record the good work that's being done and the numbers of dogs that have been rehomed privately by an owner or a trainer, particularly in relation to the years 2020-21. So, there was 1,448 greyhounds that were rehomed, and that's a significant number.
And what's that as a percentage of the entire number of greyhounds that would be coming out of the industry in that year?
Well, we can take that on notice, but in terms of those that are retired for export, 0, accepted by another animal rescue or adoption agency, 477 accepted as greyhounds as pets. So there was 339 greyhounds that have entered people's homes across New South Wales, and that's a good thing. And we are seeing more and more of those dogs enter into that environment.
Minister, what sort of government oversight is there on the Greyhound as pets program? Is there some kind of annual reporting or inspections or protocols, or is it a self-governing body?
Just to provide some context for you, Ms Hurst, in relation to that particular process. So a greyhound, and significant work has been done by GWIC in terms of tracking, and this comes down to tracking the greyhound through its life. And what happens is...
I understand the process of that.
Yeah, so they are tracked right from when they are whelped all the way through, and in fact...
So my question was just in regards to the GAP program, so Greyhounds as Pets program, and I'm just wondering what sort of government oversight is there specifically on that program rather than on greyhounds generally?
So once a greyhound leaves the racing industry per se, it then crosses over into another jurisdiction, which is local government and the prevention of cruelty to animals. So while they are still microchipped, they are then into that system where they can
But you're suggesting that any greyhound that ends up in the GAP program would then no longer be under your portfolio. Once they're in the GAP program, that would go under local government?
Once they go into private ownership, they then come under the...
and that includes GAP, the Greyhounds as Pets program?
There might be some transitional requirements there, Ms Hurst, that I'm happy to provide that information for you. Ms Hurst, if you like, we can provide that answer for you. Mr Griffin from Greyhound Welfare Integrity Commission.
Thank you.
So any greyhound that's in the custody and control of Greyhounds and Pets program is still a registered greyhound. It's not taken off the New South Wales Greyhound Register until we place it on the Companion Animals Register.
Which is that transition we were just talking about.
And so are you aware if there is any kind of annual reporting, inspections or protocols that is done on that body, given the concerns that were raised by the project around the number of greyhounds that are being rejected by that program? Is there any government oversight on that particular program, particularly given that it receives government funding?
I'm not aware of it receiving government funding per se. My understanding is the industry sets aside money for the Greyhounds as Pet program from its own revenue streams. But essentially, the Commission, we oversight in terms of the rehoming numbers, and the Minister's referred to a few just a while ago. In answer to your original question about the percentage that Greyhounds as Pets actually place, it's about a third of those 1,400 greyhounds that rehomed. But they do provide financial support to other other pet rehoming organisations. They fund them to de-sex and do dental work for those greyhounds.
Do you know how much funding they provide to other rescue groups, or can you take that on notice?
My understanding is somewhere in the vicinity of around $750 to $900 per greyhound that they provide.
So is that for every single greyhound that they reject taking, that they would then give the charity $750?
It's not that they reject. No, it's the fund that they provide to those other rehoming organisations to actually do the de-sexing and the teeth cleaning. That's a requirement before they rehome the greyhound privately.
Thank you.
Thank you, Chair. Morning, Minister.
Good morning, Ms Fairman.
Minister, given the scathing evaluations by Infrastructure Australia, Infrastructure New South Wales and the Productivity Commission, and the reluctance of the federal government to fund the Dungowen Dam project, do you think handing out Get Dam Ready guitar picks at the Tamworth Country Music Festival was a little premature?
Ms Fairman, in relation to water security for Tamworth, the Namoi Regional Water Study clearly outlined that Dungowen Dam was the best option. We are proceeding and committed to providing water security to Tamworth.
Minister, the Namoi Water strategy said
highlighted
Dungowen Dam was the best option.
So Dungowen Dam was included in those options.
Are your advisors telling you that, or have you read the strategy yourself?
In relation to the regional water strategy, as well as the executive summary of the business case, which we furnished to you, Ms Fairman, it clearly outlined, particularly in the executive summary of the business case, that Dungowen Dam was still the best option to provide that water security.
So had you read the business case by the time you were handing out those guitar picks, the Get Dam Ready guitar picks at the Tamworth Country Music Festival? Had you received the business case by then?
Ms Fairman, what we have done is looked at all of the information that has been
Had you received the business case or not, Minister,
not at that
before
point.
You handed out the Get Dam Ready guitar picks? Had you read the business case that essentially said that the cost-benefit analysis ratio was 9 cents for every dollar spent? Like an appalling cost-benefit analysis. Terrible. Had you read it?
Ms Fairman, in terms of the cost-benefit analysis, you're putting a price on people having water security in regional New South Wales, and I think that's disgraceful. This is a city of 60,000 people that nearly ran out of water in 2019, where we were bucketing water to try to keep the environment alive. It looked like a lunar landscape, and you're trying to stop
Dungowen
people.
Dam, no, because we have the business case now, the business case summary, and essentially the business case summary doesn't really say, does it, that the new Dungowen Dam and pipeline, it doesn't really say that it's the best option.
It says it is the preferred option in terms of going forward because the other options are unreliable, and I will take you to those
It doesn't say that the other options are unreliable.
It does. It does say that the best form of option will be Dungowen Dam, increasing your water supply. One of those options would be a pipeline from Lake Keepit, and I know you're familiar. And if you'd like to come to Lake Keepit, I'll take you there in the middle of the drought where there was.
So I do have it in front of me, Minister. That's okay. I don't need to do that. Thank you. I do have it in front of me that I've got the business case summary here, and it states that the increased urban reserve, and this is about Chaffey Dam, right? So basically the Infrastructure Australia stated that the increased urban reserve option was underscored in the strategic merit test. This is in relation to the business case, and suggests it would actually be the more effective option to secure Tamworth's water supply. That's Infrastructure Australia. And then in the business case summary, it states that the increased urban reserve does not deliver on the same level of performance nor levels of performance consistent with the target benchmarks. But I put to you today, Minister, that Dungowen Dam option in this business case also failed the same benchmarks. Didn't it? Like if you look at the benchmarks and the way in which this was analysed, Dungowen Dam failed it as well. And then it seems as though, like in the summary, somehow Dungowen Dam appeared as the best option.
Well, it
but
is
not
the best
according
option.
to the actual
It is the best
analysis.
option. I will take you back, Ms Firma, to the urban reserve that you talk about in Chaffey Dam. Let's be clear what that urban reserve means. That means holding more water in Chaffey Dam for the town supply, taking water off farmers. That means all of the water that would be allocated to farmers to grow their crops, to create the jobs.
I'm glad you're talking about farmers.
That's right.
Because,
that's right, because
Minister,
you want to shut them
the
down.
investment decision behind finding the best option to provide water security to the people of Tamworth, it's not about that, is it? It's about irrigators in the Peel Valley. Which one is it?
Well, let me tell you that farmers in the Peel Valley would completely disagree with you. This is a much broader scope in terms of providing water supply for this city and the broader region. So when you talk about an urban reserve, you want to shut down the farming community, you want to shut down the irrigation, you want to shut down the lucerne industry in the Tamworth Peel Valley, which provides jobs, which provides the food for cows and cattle and sheep, which go to our abattoirs, which provides in excess of around 1,500 jobs. So you want to shut down the farming sector.
With Dungowen Dam,
is that your intention?
With Dungowen Dam, Minister, I'm asking questions to you.
I'm asking
the questions to you. So with Dungowen Dam, are you saying essentially that you're happy to subsidise Peel Valley irrigators? You're happy to basically subsidise them at the expense of the taxpayer and the people of Tamworth, who are going to have to pay more for Dungowen Dam? Because essentially what this is about is security for Peel Valley irrigators, isn't it? It's not about security for Tamworth.
This is for the future growth, the regional economic development of Tamworth, a growing city that has a population projection of 100,000 years to come. You are basing this on providing no water for growth whatsoever. You want to shut down this city. You want to shut down farmers. I ask you to come to Tamworth in a town hall meeting. Tell them you don't want us to have more water. I come from Tamworth. I lived through the drought, and you want to put a pipeline from Lake Keepit to Chaffey Dam, you want to pipe dust, 0.09% of water in Lake Keepit. And Chaffey Dam still had 14% while we did the hard yards. That community did the hard yards while you had your tap running in North Sydney in your greening space environment. This city was running out of water. People were desperate. That city looked like a moonscape. We did the hard yards, and you don't want them to have clean, fresh running water. Come and tell that to the people of Tamworth.
We'll come back for more questions later.
But I can go get coffee.
We can.
Yeah, go downstairs.
Is that what happened?
Yeah.
Reward for good behaviour.
Okay, after that brief break, we welcome everyone back and we go straight to the opposition for questions.
Thanks very much. I've got some documents that I'd just like to provide to the Minister and perhaps to Ms Hawes as well. Can you just give one to the Chair? Minister, I'm coming back to this question about the ASIC registration of the name Sydney Cemeteries and Crematoria. Now, it was the evidence that was provided to us this morning was that this name has been transferred to Rookwood. Now, I've checked just before the break. In fact, you'll see at the bottom of the page there, it says that this was a document that was printed at 10:45 this morning. Indeed, that was when it was accessed from ASIC's database. This name is still registered to Leader Investments. It is not with Rookwood Cemeteries. Can you please explain why that is the case?
Thank you, Ms Housos, for your question. As we said earlier, that this is new information to us, and we will get a full brief in relation to the activities that Leader Investments are undertaking, and we will come back to you later this afternoon with the information as we would understand it. But I'd ask Ms Hawes if she has anything further that she would like to add.
We are trying to get some further information to provide the committee this afternoon. The advice I had was that the intent is certainly to have it transferred to Rookwood. Whether it's actually been transacted, I'm not clear at this point, but I will get that clarified for this afternoon and take anything on notice if we need to follow up and get further information for the committee.
Okay, so let's just be clear though that that's a change in answer from what we received this morning. We told that it had been transferred. We went and checked.
That was my understanding, but it was new information presented to me with 5 minutes to scramble. So my apologies, and we do intend to completely get to the bottom of this and give you the correct answer.
And Ms Hawes, I in no way want to say that you're misleading the committee. I just want to say that it's different. That initially we were told
my understanding was that it had been transacted, but it may not have finally completed. But the intent is certainly that it's a transferred name. But I will take that on notice so that we do provide completely up-to-date information.
Okay, so let's just turn the page. So we've got, first of all, we've got Sydney Cemeteries and Crematoria. Next, the next business name that is registered is Greater Sydney Cemeteries and Crematoria. Again, this is to Leader Investments, which is the private company that is owned by Ms Shearer and operated by herself and her partner. To be clear, the registration and the renewal date is the same on each of these. This is it's the 4th of April for Sydney Cemeteries and Crematoria, and then it's the next day, the 5th of April, Greater Sydney Cemeteries and Crematoria. Ms Hawes, perhaps you can provide us on notice with why it's taken so long to do the transfer.
Yeah, happy to. As I say, Ms Shearer is the administrator, so I can't really speak for her acting in the remit of that role, and I wouldn't want to. We will certainly look into it now that it's been raised with us and get the committee the up-to-date understanding of where those business names are.
So, Minister, I'm just going to turn you to page 3 of the document that I've provided you with, which is that... which is the current details for the ABN listed. Now, this is the ABN for Rookwood General Cemeteries Reserve Land Manager. That is the organisation that is charged with running Rookwood. Now, you'll notice underneath there are a number of business names that are listed. One of them is One Crown Sydney Cemeteries. The second one is One Crown. The third one is One Crown Cemeteries. So you can now see, Minister, that this is a fundamentally different approach to the one that on the first 2 pages, where these business names have been registered to a private company linked to the administrator that you have appointed.
So again, Ms Housos, until I get a brief and a greater understanding of the actions undertaken by Leader Investments, then I will be able to provide an opinion for you. But we will get the information in relation to the activities of Leader Investments and come back to you with clarification this afternoon.
But Minister, you can see these documents show that it has been a fundamentally different approach. This is not being done under the auspices of Rookwood, under the way that they are currently operating. This is being done by a private company one of the people who runs that private company has been appointed by an administrator by you, and instead of registering these organisations, they were registered months ago, Minister. Nearly 6 months ago they were registered. They've been sitting there under the auspices of this private company instead of sitting under Rookwood, which is where they should, as they should on the third page. Do you understand that, Minister?
Thanks, Ms Hughes. Again, we will get clarification for you in relation to the activities of Leader Investments and their intentions. From where I sit as the Minister responsible for Crown Lands and looking at providing that additional burial space under One Crown and looking to stand up the operating model. It is not my intention, and I have no intention, and the government at this point in time has no intention to privatise One Crown. So in terms of the intent of Leader Investments, we'll get some clarification on that, as we said earlier today, and we will come back to you this afternoon as to the reasons why.
Okay, but Minister, you said that this appointment predated your time, is that correct?
That's correct.
Okay, but you renewed Ms Shearer as the administrator, isn't that correct?
That's correct.
On the 28th of May?
I'll have to check that date to confirm that, Ms Hughes.
Oh, it's the 28th of May till this year until the 27th of May 2023. Does that sound about right,
but I can triple check that. I would not want to mislead you.
So what checking did you do before you reappointed the administrator?
So on the basis of the experience that Ms Hawes had outlined earlier, and it was the recommendations that Ms Shearer be reappointed to continue the work that she had undertaken and looking to stand up the operating model of One Crown and continue those discussions, and her experience, obviously the previous appointment predated. I had no preconceived predisposition to change the course of progress in relation to looking after those most vulnerable in our community, and she was reappointed.
Okay, but Minister, you signed off on the reappointment, and the experience that you talk about was that she had spent 1 year and 3 months as the interim CEO of Rookwood General Cemetery. 1 year in the role, she's reappointed for another year as your administrator, and you didn't do a check on the 27th before signing off on her reappointment on the 28th of May that just 6 weeks earlier she had registered these private business names in her own private company instead of doing them, as we see here on the third page, under the auspices of the Rookwood General Cemetery's Reserve Land Trust. What checks did you take, Minister, before you signed off on that appointment to even a basic check on ASIC would have told you that this is what your administrator that you just reappointed to the role was up to while she was supposed to be administering the trusts of cemeteries in this state?
Ms Hughes, we will, as we've stated earlier, get further information and be briefed on the direction and the plans and the reasons and understanding as to why Ms Shearer has gone down this path, and we will come back to you later this afternoon.
How much is Ms Shearer being paid in her role as the administrator?
Oh, I don't have that in front of me, but I can take that on notice.
Can you provide that to us this afternoon?
Yeah, of course.
How much she's being paid for the previous year of her appointment and how much she's slated to be paid for the next year of her appointment? Oh. Minister, what checks, I'm going to ask you again, what checks did you do before you appointed Ms Shearer? Did you do even a basic ASIC or company check on what her private business was up to while she was administering the fund?
Ms Hughes, as I stated earlier, the recommendations, particularly in relation to progressing the standing up of the operating model of One Crown and working with those faith-based organisations, particularly in relation to the culturally sensitive nature of this particular project, Ms Shearer had carriage of that issue, and it was recommended, and there was no predisposition or anything that was brought to my attention as to any red flags there, but having that document brought forward this morning, we will come back to you this afternoon with clarification.
So just to be clear, Minister, though, you got a brief from the department that said we recommend that you reappoint Ms Shearer, and you did no other checking. And part of that brief did not involve a check of what her private company that you were appointing to this role had been doing whilst she was already the administrator.
I was going on the advice and the briefings and the fact that she was undertaking this work. She was right in the middle of trying to do what she'd been asked to do in terms of standing up One Crown, and that work was ongoing. The recommendation was to reappoint, but in relation to what you're saying there now, Ms. Hughes-Sauce, and the document that you have produced, we will get further clarification in a briefing for you.
But Minister, it was your signature that reappointed her to this lucrative role. It was your signature that said, yes, she could continue the work for another 12 months. Did you do any additional checking other than the fact to say, I've got a brief here that says, yep, we should keep her going? What were the KPIs that you were looking for if she was going to be implementing your policy over the next 12 months?
As I do on many occasions, I act on the advice and recommendations that are brought before me, and on this case I acted on that advice and recommendations and the work that was being done, particularly around, and her experience, Ms Shearer's experience has been highlighted again by Ms Hawes, but I'm happy to ask Ms Hawes if there was any indication that there may or may not have been something that we were unaware of at that time.
I respect Ms Hawes, and I'll have some more questions for her this afternoon. But Minister, I'm interested in what KPIs you had before you signed off on her reappointment.
Look, I'm happy to provide information to you, but I act on advice and recommendations from the departments and information that's been brought forward to me, and the recommendation and advice was that, and I was unaware of any issue that may or may have affected her reappointment, and she was reappointed.
Okay, I understand that you were acting on the advice. What were the KPIs for her? What were the things that she was required to do in order to get this reappointment?
I act on the advice of the department, particularly
Minister, you can't just say I act on the advice. What was it that was the basis for the recommendation? Why did you put your signature on the bottom? Do you remember what was in the brief?
Were there KPIs?
So Ms Shearer's appointment was predated to my appointment, and
No, Minister, you reappointed her to the role. I can table the gazettal where you reappointed her to the role. It's on you, Minister. She might have been in the role already, but it was well within your rights to appoint someone else.
I'm just providing some clarification.
What was the basis for you appointing Ms Shearer?
I'm just providing some clarification, Ms Hughes. So Ms Shearer's appointment predated my appointment as Minister. When the recommendation advice came up, the process of standing up One Crown was already well underway, and there was nothing to say that she should not be reappointed. In fact, there were glowing reports in terms of her work, and the advice, as recommended, was to reappoint.
Minister, I'm glad you spoke about taking the advice, heeding the advice of the public servants. I'll just take you to another issue now around Tarana Estate in Austral. Earlier this year, you advised the Legislative Assembly, and I quote, "I am pleased to inform the House that the New South Wales Government has facilitated a solution with Sydney Water that will avoid sunset clauses being activated in the Tarana Estate land purchases. Sydney Water is working with the Tarana Estate developers to fast-track a temporary solution for those land purchases." Well, Minister, as you would be aware, the developers refused to install the interim solution. So I'd like to know, what do you say to the residents of the Tarana Estate in Austral who are still waiting for their houses to be built due to consistent delays from Sydney Water? Why do they have to wait until June 2023?
Look, it is a challenge, Mr Veach, and thank you for your question. We've been working with Sydney Water to look at what options are available to them to ensure that they are able to progress and get those services delivered, particularly around sewer. And I'd like to ask the CEO of Sydney Water to provide further updates on the progress in the services.
I'm going to raise this with the CEO this afternoon. This morning, we just get some limited time with you as the Minister. So, essentially, the government's failed the people of Tarana Estate, have they not?
Work is being done with Tarana Estate. There was significant concerns, particularly around the size of the development and the scope of the development and the distance that, and you'll hear further more technical this afternoon, Mr. Veach, but in terms of the distance that part of that development was being progressed from the services that were available at the time. So that work is being done. An offer has been made and negotiations are at foot with the developer, and we understand now that the developer needs to engage with Sydney Water to progress those options that Sydney Water are putting forward.
Are you going to meet with the residents out there, the people who are involved in this unfortunate set of circumstances?
Well, at this point in time, this is a matter between the developer and Sydney Water, and those discussions are ongoing. Now, my understanding again, Mr. Veach, is that
what are your
the developer now
Sydney
needs...
Water then? What are you saying to Sydney Water? As the Minister, what are you saying?
We're saying that they need to look at every option available to them to fast-track what they need to do to provide those services. Now, my understanding is that options have been put to the developer, and I'm happy to ask the CEO of Sydney Water to provide that clarification for you now if you wish.
No, this afternoon will be fine. Sure. Thank you. I've got the Minister this morning. So, Minister, wherever you go in New South Wales, there's a housing crisis. These people are trying to build a house and they've struck an impediment. Are you saying to Sydney Water to date this has been unsatisfactory and it needs to be resolved ASAP?
Yeah, the CEO of Sydney Water and I have had discussions in relation to the progress of this particular project. There are challenges in relation to delivering those services, and my understanding and expectation that Sydney Water are doing everything they can to facilitate that process. There are challenges. They are talking to the developer, and the developer has been provided with options and a pathway forward, and Sydney Water are waiting to hear back from the developer in relation to those pathways.
Do you have a time frame for that, Minister?
I can get that now for you, Mr. Veach, if you wish, because Sydney Water CEO is right here.
I'm certain we can do that this afternoon, and as long as I can be provided with some sort of time frame this afternoon, that would be good. Minister, the Greater Sydney Water Strategy, or GSWS, was released just recently, August 2022. It's a major piece of work, been years in the making, so and its delivery comes after, I think, a number of delays. Minister, Sydney's pretty much behind in terms of delivering more sources of rainfall independent water. So not a reliance on rainfall. Now, you and I know there is going to be another drought. Like, the rain may be here now, but sure as we can put money on this, there's going to be a dry time. What are we doing? What is the government doing to increase the number of rainfall independent water sources for Sydney?
And you're right, Mr. Veach, and thank you again for the question. The Greater Sydney Water Strategy clearly outlines the process and what options will be needed when we are back in drought. And part of that, for a start, was improving the network by improving the water efficiency and leakage management and reuse programs to save up to $49 billion a year every year until 2040. That's one. So you've got to stop the leaking for a start. Then there's new flexible operating rules around the desalination plant, greater options around treated reuse programs, and I agree, you shouldn't use potable water, water that comes out of your tap, to water your garden or to green spaces or in that space developing those green spaces. So effective stormwater management, the new Aerotropolis is going to be using that methodology about using stormwater. So,
Minister, how does Sydney compare, Minister, with other cities in Australia when it comes to independent water sources, independent of rainfall water sources?
Well, again, Sydney Water will be able to provide that.
Surely these are questions that are exercising your mind, I'm certain.
Yeah, they are, but I was just about to say, Mr. Veach, that Sydney Water will be able to provide that detailed jurisdictional comparisons, but in terms of where we sit, I think Greater Sydney Water Strategy and regional New South Wales as well.
I've got some questions about that too, so Yeah, well, let's keep going.
Thank you. They all look at what they've got to do to be more efficient in terms of our water management. It's a precious resource, and you just heard the exchange about providing more water security for regional New South Wales towns and cities. So Sydney is no different. So to be able to be more efficient, particularly around reusing that water on green spaces, and we're not talking Sydney's drinking water, we're talking outside.
So water security for Sydney, is that a priority for you, Minister?
Water security for New South Wales is a priority, I think, Mr. Beach.
Talk a bit more about that as well.
Yeah.
So there's a mix of potential ways of sourcing water other than rainfall, and one of those things that flagged was recycled water for drinking.
I was about to go.
So recycled water for drinking. Is that something you're going to talk to the community, the people of Sydney about as a part of your greater Sydney water strategy?
There are no plans to recycle Sydney's water for drinking at this point in time.
Okay.
Sure.
I support that, but that's not a party position. That's just my position.
Thank you, Chair. Minister, are you aware that the Natural Resources Commission completed their review of the New South Wales Border Rivers Unregulated River Water Sharing Plan, published in June 2022?
I am aware of that, Mr. Field, thank you.
The NRC found that the plan, and I'm quoting from their executive summary, creates inequities between users, which is inconsistent with the Act. It also found that access rules are not based on an assessment of environmental flow or basic landholder needs. Further, the level of entitlement significantly exceeds the plan's extraction limits. Despite this, assessment of compliance with these limits has not been undertaken to determine appropriate available water determinations, creating considerable risk that planned environmental water may be extracted. When will the government respond to this review and implement recommendations to fix this mess?
Firstly, Mr. Field, I'd just like to let you know, and I'm sure you do as well, particularly in relation to when water sharing plans are changed, they are publicly available on the website. Compliance with water management principles, amending water sharing plans, they are in line with principles of the Water Act.
That's not what the NRC is suggesting here.
Well, the difficulty around water, Mr. Field, is that it's very complex.
Yes.
The balance is trying to find that middle ground.
Can you point to me the section of the Act that requires you to provide balance?
Mr. Field, in terms of getting that balance right, there are always going to be those organisations that don't agree with certain numbers set, and there are those
that would
who
be the
will
statutory body responsible for reviewing water sharing plans in New South Wales. I asked for the NRC to appear at today's hearings. Minister, did you ask them to appear?
I can take advice on that, Mr. Field, if you wish. It's not to my knowledge. That request doesn't come to me.
Yes, well, I confirmed that actually it does come to you through the Secretariat. All requests for witnesses go through the Minister's office. Dr. Bentley, can you confirm, was the NRC invited? No. Who would have made that request? If that request came through to your office, who would have followed that up with the NRC?
Well, I can check with my office if you wish there, Mr. Field, but what's the point of your question?
Well, I wanted to ask the NRC questions about their review. You're making the case that you're compliant with the Act. They're making the case that you're not. I thought it would be an interesting exchange at the very least.
Well, I'm sure it would be an interesting exchange in the bubble of Parliament, but in terms of getting...
Well, I suspect the people of the Border Rivers would be interested in it as well.
Well, I can tell you that the work that we are doing in the Border Rivers and the northern half of the state, and I will take you, Mr.
Can you confirm, Minister, before the end of today, whether or not the NRC, as I had requested, were invited to appear at today's hearings?
Mr. Field, they're not in my portfolio.
They have a statutory role reviewing water sharing plans. They actually aren't in... They appeared at the Environment Minister's hearings. They're not in his portfolio either.
Well, they're not in my portfolio and they were not invited.
So you didn't invite them?
They are not in my portfolio and they are not invited.
That's convenient, isn't it? So how would I engage with the NRC on questions of water?
If you wish to engage the NRC, then please feel free to do so. But can I just bring you back to the Northern Basin in terms of...
Well, no, actually, I'd like to, if you don't have any other answers about that, then I'd like to move on. The MDBA's recent quarterly report, it was May 22, indicated that New South Wales has formally submitted just 2 2 of their water resource plans. I think recent media showed that it's up to 6. Is that still accurate?
I think we're doing a little bit better than that, Mr. Field, in terms of where we're up to. And Mr. Bentley, if you'd like to update Mr. Field in terms of where we're at, I think...
Just on the number to start with, Dr. Bentley, that would be great. It's 8 now. Yeah, we've got 20?
We've got yes, and the plan is to have all 20 in by the end of September.
Right, so they were originally provided, I think, back in 2020. They were handed back insufficient by the MDBA. You'd be aware that the former leader of the National Party, Deputy Premier Troy Grant, said on the 22nd of June that the New South Wales Government's failure to produce water resource plans is, and I'm now quoting, the most critical failure of the Murray-Darling Basin plan to date. Do you have a response to his comments?
Mr. Field, I think New South Wales is doing the heavy lifting, particularly around making sure that we have healthy rivers, healthy...
You're the only state that hasn't had your water resource plans accredited.
Mr. Field, those resource plans, there are now 8 going in. We are confident of having those resource plans accredited, and then ultimately that will set the benchmark for the remainder to go through. But what I'm asking for in terms of the Murray-Darling Basin plan is the fact that there needs to be flexibility, more accurate modelling to highlight the great work that New South Wales has done. Not only achieving just those numbers, but it's about the broader environmental income. And I will add, Mr. Field, the MDBA, the Productivity Commission, the New South Wales Chief Scientist and Engineer, and the Murray-Darling Basin Ministerial Council have all acknowledged the importance of natural resource management interventions, including complementary measures that the heavy lifting that New South Wales is doing to maximise.
Okay, I think that's an entirely different answer to entirely different questions. Some of those recent SO52 documents went to this point. The EHG, again, stated in a document titled Water Sharing Plan Statuses and Issues. The Lachlan Water Resource Plan, which was resubmitted to the MDBA on the 31st of March 2022, EHG is concerned that the submission proposes that under this water resource plan, and I'm quoting now from the plan, I don't think it's on the public record, but this is they're obviously aware of it, and I quote, there is no planned environmental water preserved or protected by New South Wales legislation or statutory instruments based on the Commonwealth Water Act 2007's definition, and the interpretation of Pew undermines the intent of the Basin Plan, protecting the volume and effectiveness of Pew. Do you have any comments on why New South Wales is approaching Pew in a different way and trying to change the definition of planned environmental water?
The discussions are underway in relation to the planned environmental water definition. It's quite different to Victoria. So I've had discussions in relation to a Pew to ensure that New South Wales is not disadvantaged by a definition that would ultimately hinder the outcome that we are looking for in those broader environmental spectrum of healthy rivers, healthy farms, healthy communities. We have a meeting next week to determine and work through the issue in relation to the definition of Pew, and once that is sorted, that is the only point left in relation to working up those water resource plans. So I'm confident that we can work collaboratively and respectfully to land a definition that will be beneficial to all.
Thanks, Chair.
Thank you. I'll pass to Ms Boyd.
Thank you very much, Chair. Moving on to something a little different. Minister, are you aware of the increase in both drink and needle spiking in licensed venues across the state?
I am aware of an incident not so long ago, Ms Boyd, but I will ask my CEO, who has been following this as part of harm minimisation and looking after patrons when they do enter particular venues.
I will, with respect, I'll come back in the afternoon. I just wanted to check you were aware of the issue before I move on, particularly needle spiking, which is quite, it's a relatively new thing. It's quite concerning. From the beginning of this year, we began to see, particularly in in Newcastle, reports of women being spiked in clubs with needles containing a range of different things.
But I do have, just in relation to drink spiking, Ms Boyd, the numbers that I have here, alcohol-related, it's been steady, particularly in relation to looking after patrons and making sure that the role of management in alcohol-related venues, they do take it very, very seriously, as we do. And again, if you have incidences of specifics that we are unaware of, please bring them forward and we'll investigate.
We're hearing of cases where multiple people are spiked, either drink spiking or needle spiking in one night at the same venue, and that no action is taken by the venues after the first case happened to prevent further cases. Does that concern you if there's not a protocol in place for venues to proactively prevent people from being spiked?
I am aware that the Police Commissioner was asked this on Wednesday in relation to this particular issue, but while drink spiking allegations are treated very seriously, they are difficult to prove, as you know. But what I am doing, we are exploring ways to enhance industry guidance and how licensees should deal with patrons that are removed from the premises if there's a reasonable belief that a person's drink has been spiked.
Have you considered having screening measures available to patrons at venues, such as, having free breath, drink, urine test kits for people who think they may have been spiked?
It's a continuous improvement exercise, Ms Boyd, in relation to keeping patrons safe. And as we said, we're exploring industry guidance on how we deal with those situations, particularly when it comes to involving police and the incidents and reporting and responsibilities associated with drink spiking.
Venues in Queensland have been trialling initiatives such as having reusable silicone lids to place over your drink so that there's a physical barrier to, so it can't be spiked as easily. Have you explored the possibility of having a trial like this at selected venues in New South Wales?
Well, again, Ms Boyd, we are looking at options in terms of guidelines, and it's a live issue, and I certainly want patrons to be safe when they enter clubs, pubs and venues in New South Wales. Harm minimisation and the enjoyment in terms of where they go is paramount, so the welfare and safety. So we place a lot of emphasis on that, so we will continue to monitor that. And my CEO and I, Anthony Keon, are in discussions with the industry about, and they don't want that to see, they don't want that occur as well. So we will continue to look at that.
Okay, but will you commit to work with industry and police on this issue specifically so that we get on top of it and we can make these venues safe?
Well, they are safe. They're
not safe if someone's getting spiked.
Ms Boyd, venues, pubs, clubs, hotels, cafes, restaurants focus on patron safety. There are sometimes incidences where this occurs, police are called, and it's a very disturbing problem when that does occur. Every effort is made to make sure that does not occur. So we are looking at guidelines.
The question was, will you commit to work on this issue specifically? Will you take this on as an issue that you'll work on specifically with industry and the police so that we can get on top of it?
Absolutely, as we will with other issues that we work on to keep our people safe when they do venture out and have a good time.
Coming back to greyhounds, you'll be aware that the industry is still breeding 6 times more greyhounds than it can rehome. Breeding in New South Wales has actually increased by 50% since 2017. And the industry and community rehomers simply can't cope with that number of dogs being discarded every year. Will you advocate for New South Wales to introduce caps on greyhound breeding?
No. I won't.
Why not?
What we will do is ensure that the welfare and safety and the monitoring of those pups, or whelping as the industry calls it, when those pups are born, and the tracking of those greyhounds throughout their life. But in terms of that, I will ask Mr Griffin from the Greyhound Welfare Integrity Commission.
And with great respect, I will come back to Mr Griffin. But this is a massive problem. We have, at the moment, GAP's going around and trying to get 400 dog facilities in remote places and things to store these discarded greyhounds. We have 6 times as many being bred as can be rehomed. This is an industry that, since the so-called reforms, has increased breeding by 50%. At what point does putting all of these greyhounds into this limited funnel that goes back into rehoming, at what point do you take action to try and limit that?
I will take you back to your first point, Ms Boyd, where you talked about remotely where they're, what did you say, 500 dogs or something?
Oh, yeah, like in Martindale, 400 dogs in a remote area away from the public eye so that people don't see all of these dogs being discarded by the greyhound industry.
If that's the case, we'll definitely take action on that, and the Welfare Integrity Commission as well as Greyhound New South Wales want people to act appropriately. They are. There is a general culture shift within greyhound racing in New South Wales that people are doing the right thing. Those people who don't do the right thing are not wanted, and they will be found out and they will be removed, as we heard earlier today.
Now, welcome Mr Pearson to the fray.
Thank you, Chair. Thank you, Minister. Minister, I'm sure you'll be thrilled to learn that the Swedish and Norwegian horse racing industry has invited me to go to a horse race meeting in Stockholm and in Oslo, and at those meetings there will be no use of the whip on the horses at all. And this has been the case for almost 10 years in Norway and for about 4 years in Sweden. I've approached Mr Vanderlees from New South Wales to talk to me about the bill that I've introduced, and one of those bills is to stop or prohibit the whipping of horses except in extreme circumstances. Minister, will your government support the bill that I've brought and will be bringing on for debate in October, which will prohibit the whipping of horses? If it is possible to have a legitimate horse race, I mean, that's a question in itself for another day, but if it's possible to have a legitimate racing of horses in these 2 countries for so many years without any consequences of harm or danger for either a horse or a jockey, surely wouldn't your government support a bill to do the same thing? Whipping is whipping, Minister. That's my question.
What's your question, Mr.
Will your government support the bill, which will come before you shortly in October, to prohibit the whipping of horses? Because many experts say that this is an unnecessary act of cruelty.
What we are committed to, Mr Pearson, and thank you for your question, and it's good that you're being invited to go and have a look at other options and other jurisdictions.
Unfortunately, other countries seem to be more willing to talk about these matters than our own state.
Well, we're very keen to talk about welfare because we have a very, very high level of animal welfare to support a responsible, sustainable and competitive horse industry.
We're not talking about competition, we're talking about animal welfare. So whipping a horse for no justifiable reason, would your government allow that to occur? Continue to occur?
So we are talking about welfare, and when it comes to welfare, we have a very, very high standard. In fact, Mr Pearson, you might know that Racing New South Wales was the first jurisdiction to introduce an equine welfare fund, and just recently with the point of consumption tax, further funding was boosted for the equine welfare
but surely,
fund.
Minister, a real measure of turning the government turning its mind to welfare would be to actually do something to prevent unnecessary harm to an animal. So I'm asking, will the government at least seriously consider my bill?
So Racing New South Wales takes very, very seriously the point you make in relation to unnecessary harm to animals, rules and regulations, and you'll see it on the track or whether they're being stabled or any interaction with a racehorse, they are treated with the utmost respect, and the welfare sits at the top of everything that they do. So if anybody is mistreating an animal, they are held to account and the appropriate penalty applied.
You're saying whipping is acceptable?
No, they're your words, Mr. Pearson.
or entertainment is acceptable. I'll just move on to another issue, which is an extremely serious one, has become apparent in the industry. A 2010 study published by the University of Sydney researched the careers, quote unquote, of 146,000 plus thoroughbred horses over 10 years. And although the horses have a lifespan of 25 to 30 years, the median career length and number of career starts for the population were 14.7 months and 10 starts. That amounts to 4.9% of their lives. Do you think it's realistic for Racing New South Wales to be able to rehome ex-racehorses for 95% of their expected lifespan? Because that's the actual, when you crunch the numbers and the time that these animals are trained and on the track and have a career, is only 4.9% of their lives. And then they're spent, unwanted.
So in terms of...
Is that acceptable, Minister?
So, Mr. Pearson, if you could just reiterate those numbers. How long did you say their racing career, how many years did you say? 4 years or something?
So horses have a lifespan of 25 to 30 years by average. The median career length and number of career starts for the population of 146,000 horses was 14.7 months and 10 starts. That was the average. So that amounts to 4.9% of their lives. Really? Is that acceptable?
Well, when I go through a race book and I enjoy the races, I attend a number of race courses and I have a look at horses.
But a horse is only in a race for 4.9% of its life. We're not interested in what you enjoy, Minister. We're talking about the welfare of living beings.
Yeah, but I'm just bringing you back to you quoting numbers there, Mr. Pearson. So I'm looking at those numbers and you're saying 10 starts on average. There are horses that enjoy a long racing career. They are well looked after and some of they have more than 10 starts.
I'm sorry, Minister, but this research over 10 years of 146,000 horses does not support that position.
Well, the last time I checked a race book, Mr. Pearson, there were many, many horses in there who have long careers and many more than 10 starts. They enjoy what they do, and when they are retired, they are then rehomed. There is a very clear pathway to manage the welfare of those horses, and many of them end up in show jumping and enjoy a second career.
How do we measure enjoyment, Minister? Thank you, Chair.
Question for another time. Opposition.
Thank you. Thank you, Minister. I wouldn't mind taking you now to the New South Wales Independent Casino Commission, or NIC, we'll continue to refer to it as. I note that Wexted Advisors has been appointed the independent monitor for Star Casino, and we also note that Kroll were appointed as monitors at Crown. Who is responsible for appointing these independent monitors?
I will ask Mr. Crawford for his comments in relation, so we make sure we get clear line of sight on that, Mr. Beach.
So before you go there, I'm happy we'll probably explore this afternoon a bit more, Mr. Crawford, in detail. So but Minister, you're not sure of the process? Is that why you're going to Mr. Crawford?
No, I don't want to mislead the panel, Mr. Beach. I will ask Mr. Crawford to be clear in terms of that process for you.
So are you? Sorry, Mr. Crawford. So are you not consulted in this process?
I will ask Mr. Crawford. Mr. Veach, I don't want to mislead the Parliament.
But are you consulted? You must know whether you're consulted.
In terms of?
Appointment of these independent monitors. Are you involved at all?
So the independent, what do you mean by independent monitors?
So Wexted Advisors have been appointed the independent monitors for Star Casino. Kroll were appointed as monitors at Crown. I just want to know, what is your role in the appointment process for those independent monitors?
I'm unsure of the independent monitors that you're referring to and the appointment process there. So we'll ask Mr. Crawford just to get some clarity, then we can bring it back to me, and then I'm happy to go down that path for you.
Okay. Very quickly, Mr. Crawford.
Insofar as Kroll's concerned, there's a tripartite agreement. They were retained by Crown and they report to us. So they've got a role in this interim period of conditional gaming that we've allowed Crown to do for the next 18 months, 2 years. In terms of Wexted, they've been appointed by Nick, and they report to us. We started that process some weeks ago because of the obvious issues have been uncovered by Bell, and until we review Bell and work out what we're going to do, we want to make sure we're in there looking at what's happening and getting someone independent reporting back to us, to Nick, and that cost is being borne by Star.
Okay, thank you. Ministers, what's the rationale for the selection behind these independent monitors?
Mr. Veach, my understanding is that they don't come under my control, so that's why I don't want to be vague with you, but I don't have a role to play in that, and I'll ask my CEO to confirm that that's the case.
Yeah, so in terms of the Independent Liquor and Gaming Authority and now the Independent Casino Commission, which comes into effect from Monday, they don't come under the Minister's control in relation to any of their compliance or enforcement decision making. So the appointment of an independent compliance auditor or compliance monitor is purely at the discretion of ILGA or the NICC.
Okay. Is at any point, Minister, are you at any point appraised of this? You mightn't appoint them, but at any point, is there any point in this process where the Minister is told?
In terms of
who was appointed?
We would be advised as per normal process, I would suspect.
You seem very vague.
Well, it's not under my control, Mr Beach. They're independent. That's why I'm not trying to be evasive.
At some point, the Minister must be advised, surely.
Yeah.
Yes, we're advised after the relevant authority makes those decisions, but they operate completely independently. So,
that's okay, but
yes.
I just want to know when the Minister's involved in the process. And Minister, so who was responsible for approving appointment of commissioners to NIC?
So that would be an appointment that would come through Cabinet, and they would be appointed and Cabinet would sign off on those.
So the process is generated through your department and you are the Minister that carries that brief to Cabinet, is that correct?
That's correct.
Yeah, so you have an involvement in that process at some point?
It's an independent process, Mr.
No, but at some point someone's got to take this into the Cabinet room.
That's right.
So you do have a role at some point and then the Cabinet's got to make a decision.
That's right.
Okay. Under the Casino Legislation Amendment Bill 2022, commissioners are appointed directly on your recommendation. Is that correct?
So the commissioners that were appointed, are you talking about now for the New South Wales Independent Casino Commission?
That's it?
Yep. So
Nick.
Yeah, Nick.
Yeah.
So the New South Wales Independent Casino Commission.
So they're appointed on your recommendation?
So the recommendations that were provided to me in relation to those commissioners that were brought up, they were recommended and then taken through to Cabinet.
So you recommend to Cabinet though?
I recommend to Cabinet on the advice of those that have been brought forward.
So under the legislation, as I understand it, you're provided with a list of persons recommended for appointment as commissioners. Can I just get, so who actually prepares the list? Is it...
Mr Veach, I can probably help you out here. So that's correct. There's been new legislation brought in which requires a panel and then a list to the Minister, but there was also transitional provisions put into this legislation that allows the Minister to appoint the existing members of the Independent Liquor and Gaming Authority across to the new Independent Casino Commission.
As a transitional arrangement?
Just as purely as a transition to stand it up on Monday. So the most recent appointments were utilised using that transitional arrangements.
Yep.
And then going forward, any appointments will need to comply with that new legislative requirements, which is a panel to be set up, a list provided to the Minister, which contains more applicants than the vacant roles.
And so how long are those transitional arrangements? What's the time frame for the appointment?
So it's based on their existing appointments to the Independent Liquor and Gaming Authority.
So when that term ends, that ends their term on NIC as well?
That's correct.
Okay. Because as I understand it, I think Stephen Parbury has been appointed, is that correct?
That's correct.
Yeah. And he's already on ILGA, so this is a part of that transitional arrangement.
Yeah, so those new commissioners will now resign from, or have resigned from the Independent Liquor and Gaming Authority with the exception of Mr Crawford, which under the legislation he remains as an ordinary member on ILGA.
Yep.
And their existing terms under ILGA from ILGA have transferred over to the NICC, so whatever their terms were under ILGA continues under the NICC.
And so prior to the appointment of ILGA, there would have been the usual due diligence undertaken around probity checks and the like for the individuals, and that would have been carried across to their appointment, this transitional appointment to NIC?
Yes, that's correct.
Okay. Minister, did you appraise yourself of all this before the recommendations were made to you about this transitional arrangement?
So in terms of those transitional arrangements, Mr Veach, and the recommendations that came forward, they had already had all those checks, as you've just rightly pointed out, and the transitional arrangements were agreed to.
Okay. Now, Minister, a bit earlier we mentioned Bell. I think Mr Crawford mentioned Bell. I think, as I understand, that's with Mr Crawford at the moment. Is that correct? Yeah. Minister, have you received a briefing yet on the Bell report?
No.
When is that to take place? Are you seeking a briefing on Bell?
Look, it's not appropriate for me to comment further, Mr Veach. I haven't received a copy of the Bell review or the report. It's with Mr Crawford and he'll do his due diligence and then it will come to me.
Yeah, I'm not asking you to comment about the Bell report. I understand it. I just want to know, when are you going to be briefed?
When Mr Crawford has completed his processes, and then he will inform me.
Yep. Within the next month, before Christmas.
It's a matter for Mr Crawford in terms of, I'm happy to ask Mr Crawford how long his process will take. I'm not going to rush him. This is a significant piece of work.
I just want to know, though, as the Minister, because at some point, you know, under the Westminster system, this is coming back to your, lap, on your desk. So,
well, I could probably help out there. I have a copy of the report. The other commissioners received copies last night. We're meeting next week, and we're trying to set up a time for a briefing with the Minister. At the moment, I think it'll be Thursday or Friday of next week, but those arrangements are currently being made as we speak.
Okay. Thank you, Mr Crawford. Minister, like the Bergen report, will the Bell report be released immediately after you receive it?
Well, again, Mr Veitch, we will take into consideration the recommendations from the Commissioner and the process and timelines of that report. We don't know what's in it, so I can't comment any further.
But Minister, you can see where I'm going with this. Like the Bergen report, quite rightly, was released pretty much straight away. I think people would be expecting Bell may well be treated in the same manner.
I could probably answer that. Our plan would be to put it up on our website fairly shortly after the ministerial briefing. I would hope by the beginning of the week after next.
Okay.
It'll go on our notice board and be available to everybody.
Just to confirm, if I could, Mr Veitch, that's your call, isn't it, Mr Crawford?
That's correct.
Yep, thank you. Thank you. The Minister, can you provide an update on the status of the new Independent Casino Commission, which recently passed the Parliament? What is this is? I just want to know, when does it become operational? Because there's a process we've been talking about here, but when does it actually become operational?
On Monday.
So as of
this Monday. Monday, the 5th of September.
5th of September.
Yep.
Okay. Thank you. And so, there's a number of workers in the industry. What are we doing here around discussions with workers around job security, protections, etc.?
So in terms of standing up the New South Wales Independent Casino Commission, it will be a standalone independent body. There will be support provided in the transition phase from ILGA and the department, and ultimately Mr Crawford will set that up, and ultimately it will be completely independent and standalone and get on with what it needs to do to keep casinos free from criminal activity in New South Wales.
What's going to happen with the workforce? I guess these current questions.
It's a new workforce.
Yeah. So the current workforce, what happens to they transfer across? Is there all those discussions taking place with the relative workplace representatives and the like?
Yes. They've been occurring for some time now. We've been building up for this in anticipation. So, including other vacancies and other organisational redesign, we're currently going out to market for in the vicinity of about 68 roles, uplifting. We've had discussions with the Public Service Association through that. Through the reforms, we've also been able to convert a lot of temporary roles to ongoing, so added job security, as well as creating additional career development pathways for staff. So it's been a very positive outcome. The NICC will be stood up, as the Minister said, on Monday, so the commissioners are already effectively in place and already working on that. And then once we have the appropriate systems and arrangements in place, the administrative orders will transfer those existing staff over to both the NICC and ILGA as staff agencies.
Yeah, okay. I think I might leave that there. Just very quickly, Minister, I want to just go back to a couple of water questions, and then I'm going to hand over to my colleague. Dubbo, as you would be aware, Dubbo was put on a boil water alert for about a month recently. Do you think it's acceptable that residents in Dubbo and surrounding towns were on boil water alerts for a month?
Significant work was being done to rectify that issue, Mr Veitch, and that also falls in under the Safe and Secure Water Program, where we are providing the 92 water utilities across New South Wales with funding to upgrade their ageing infrastructure, and that includes water treatment plants. That includes water treatment plants.
You mentioned that particular program. Can you just maybe take a notice to get back to us? But I wouldn't mind knowing how much has been spent and how much is remaining in that fund.
Certainly.
And so, how many other towns in regional New South Wales had to go on boil water alerts?
Well, there was, to the best of my knowledge, there was around the Blue Mountains, there were some issues with when roads were damaged and homes were inundated, but by the most part, water treatment plants, particularly up around the northern rivers as well, were placed under extreme duress with flooding. Water treatment plants as well as sewage treatment plants were damaged. So significant work. There was about $140 million provided up north in the northern rivers to help those councils, and Water New South Wales and the department are quickly on any areas that suffer water challenges in relation to the failure of their water treatment plants or their sewage treatment plants.
And I'm saying that towns don't go on boil water alerts because they have to.
Yeah.
From time to time, I understand and appreciate that.
Yep.
So I just very quickly want to go back to this, the probity work that was undertaken around the appointments of commissioners to NICC. I understand we transferred people across from the Board of ILGA. Did we do any new probity checks at that point, or did we just carry over the ones that were previously conducted?
They were carried over from the previous, Mr. Birch.
There were no new probity checks conducted at all?
Those probity checks would have already been in place and they would have already been cleared at the highest level for them to come across.
So, so we've appointed Mr Murray Smith as well as a commissioner for the NIC, is that right? So he's been carried across as a part of the process. I think ILGA might have appointed McGrath Nicol, upon which he is a partner, to conduct probity on Blackstone prior to them acquiring Crown. Did you know that, Minister?
I'll get some detail on that, Mr Veach. That's operational in terms of what needs to happen there, but I'm happy to provide that detail for you if you wish.
Yeah, that would be good, because what I want to know is, in light of that, what probity was conducted on Mr Smith's appointment to the NIC in light of that work which occurred after his appointment to ILGA?
Sure.
So can you see what I'm saying here? We've carried over the probity checks, but there may have been circumstances that have changed people or the way in which people interact in this environment. And did we not do new probity checks?
I can assure you, Mr Veach, that the clear and transparent process and the control measures that is now in place around casinos in New South Wales, particularly obviously with the Star and Bell and Crown with Bergen, and we've also got another inquiry into money laundering. We want to ensure that our venues, including casinos, are free from crime, free from money laundering. That's why New South Wales has taken the most stringent and the highest ground in terms of making sure that we keep our people safe.
Why I'm asking about the probity checks for people who are being appointed to the NIC. That's right, because if you can guarantee, Minister, we haven't got this right, Mr Field is going to be chasing everyone through the hallways of Parliament. So I just want to make sure we got this right. I'm just going to hand over now to my colleague, Ms Hughes.
Thanks very much, Mr Veach. I wanted to come to the Greyhound Racing New South Wales survey. This was a survey that was conducted of its members in November last year. Late last year, sorry. My understanding is you became aware of it during November last year. This was a survey that asked political questions, including the voting intention and the voting intention of individuals and the individuals' views on the party leaders at the time.
I was aware of that, yes.
Okay, when were you first briefed about that?
I can't remember the exact date, Ms Hughes. I think it was about the same time everybody else did. If you've got that date handy, otherwise I can come back to you with when we first found out about it.
Well, no, I've asked you some questions on notice about this. I've done a call for papers on this. My understanding is it was around the 12th of November. I don't think it's the time that everybody else was made aware of it, Minister. My understanding was that you were made aware of it on the 12th of November. How did this notification occur?
Well, I think that in relation to that question, Ms Hughes, I became aware of it when everyone else did, because it was a public survey. People were asking questions, and I became aware when everybody else did.
No, Minister, it was a survey that was sent to Greyhound Racing participants, a survey that was sent by Greyhound Racing New South Wales, and amongst the other questions about the future of the industry, there were some voting intention questions at the end. Do you recall this, Minister?
Yes, I do.
Okay, so in an answer to a question on notice, you said you were first notified on the 12th of November. That would be correct?
If that's the response, then yes, the exact date.
So how were you notified about that?
Well, again, I was notified like everybody else where I received a phone
Minister,
call.
you can't say like everybody else. This was not a public document. This was a survey that was specifically sent to Greyhound racing participants.
Greyhound racing participants are public people, so it was in the public arena, so everybody knew about it as well.
No, Minister, not everybody was aware of it. It was sent to several thousand Greyhound racing participants. Minister, according to your ministerial diaries, you met with Greyhound Racing New South Wales on the 15th of November. Did you discuss the survey at this meeting?
I would have discussed the survey because, like everyone else, it was a public survey. So that was common knowledge that a survey was being undertaken. And if you know the greyhound racing industry, Ms. Hughes, it's a pretty strong grapevine. And when things like that happen, people start talking. And I was notified like everybody else. We were tipped off, and Quick were aware of it, Greyhound Racing New South Wales was aware of it, our participants were aware of it, as my office was.
Okay, and what did you do when you discovered that Greyhound Racing New South Wales was surveying the voting intention of its members despite receiving government funding?
Well, I think we had a discussion with the CEO at the time and deemed it to be inappropriate in terms of operating outside their licence.
You deemed it to be inappropriate?
Well, it just stands to reason it did not fit, I think, the pub test in terms of an organisation like racing doing that. So, yeah, we had discussions with them.
The chair of Greyhound Racing New South Wales is the former National Party Senator John Williams. That's correct, isn't it?
That's correct.
Okay. And what consequences were there for Greyhound Racing New South Wales for this inappropriate action?
They gave the undertaking to me that they had stepped out of line and they wouldn't do it again.
Okay. And that's it? That's the end of the conversation?
That was about it.
Minister, you talk about Greyhound Racing having a pretty strong community, pretty strong grapevine. One of the issues that was obviously raised on this grapevine was the question, or was some rumours saying that Mr Barilaro was being approached to be the new CEO of Greyhound Racing New South Wales. Did you ever have discussions with Mr Barilaro?
With Mr Barilaro about which?
About being the new CEO of Greyhound Racing New South Wales?
No.
Well, another inquiry going on.
Did you ever discuss that possibility with the chair, former National Party Senator John Williams?
No.
Did any of your colleagues approach you to advocate on behalf of Mr Barilaro that he should be the new CEO?
No.
Did you hear these rumours yourself within the industry?
No.
Are you serious, Minister?
I'm serious,
That's
Ms.
your
Hughes.
testimony under oath, is that you never heard of the discussions that John Barilaro wanted to be the CEO of Greyhound Racing New South Wales?
No, not specifically.
So it's your testimony to this inquiry that you heard about a survey of members through the grapevine, but you didn't hear that Mr Barilaro was hunting around for a government job as Greyhound Racing New South Wales CEO.
Particularly, and I will take you back to the survey, the participant survey was sent to the Greyhound Welfare Integrity Commission. I talk with the Greyhound Welfare Integrity Commission and Greyhound Racing New South Wales all the time, and it was raised in that context.
My time's expired.
Thank you. I might go first. Now, Minister, taking you back to my line of question, you said that you were going to ask for more time at the next MINCO meeting. How much more time are you going to ask for to get those projects completed?
What I plan, Mr Benasiak, is to ask for more time to consider.
How much?
Well, that's the discussion that MINCO will have to have.
Have you got a figure in mind? 12 months, 18 months, 2 years?
No,
10
we don't have a figure in mind. What we do have and will be a clear pathway forward to recognise the work that New South Wales has done in keeping healthy rivers, healthy farms, healthy communities, and ensuring there is enough water in the system to meet all of those.
You haven't got past design phase in most of them. You can't say that you've done that great work. You're a betting man. What do you reckon your chances are? Have you checked Sportsbet in terms of what do you reckon your odds are of getting that extra time?
I'm taking the support of New South Wales with me in relation to advocating the great work. And I will just say that the other day we were in Griffith there, Mr. Banasiak, and we had a look at Murray Irrigation. And in terms of the efficiency and the effectiveness of delivering water and the connectivity is quite extraordinary. So over the last 5 years, in terms of efficiency, in terms of better management of water and making sure that the environment is looked after, as well as our farmers and our communities are not disadvantaged. Significant work is done. And the control room at Murray Irrigation, I encourage you, Mr. Banasiak, go and have a look. It looks like NASA.
Okay, I'll just stop you there. Questions taken on notice. In last estimates, I asked around how much money had been allocated, received and then spent for the Beta Barker and Beta Bidgie projects, and we got back that there was 23,977,000 roughly has been spent out of a total funding allocation of 337 roughly million. How much of that 23 odd million has gone to local groups, local organisations, compared to how much has been spent through government agencies, both state and federal?
I would have I'd have to take that on notice, but what I can say, Mr. Banasiak, is particularly around the Beta Barker.
Was it around 180,000 out of 23 million that's been spent on local groups?
No, I'll have to take that on notice, Mr. Banasiak.
Anyone around the table have a rough idea?
I have to ask Mr. Bentley if
we can get you the details this afternoon, but when you're in these phases of the project, they are, our teams are doing consultation and so on. These are not the phases where we're spending sort of money on construction. As you move into construction, they will be heavily dominated by local workforce, but it's not that phase of the project. We have to have our people doing the consultation to be hearing what the public are saying to us.
So, Minister, are you still committed to this concept of co-design and co-implementation?
Absolutely, and that's why the Beta Barker and Beta Bidgie and those Sidland projects, the Yanko Creek and Yanko Offtake and others were re-scoped, because at that time they didn't take into consideration, in our view, the amount of community consultation, Aboriginal cultural heritage and many other environmental factors. So they were re-scoped, that's why they were resubmitted.
Okay. Minister, what's your position and the government's position on the issue of operational and maintenance costs for these projects? Is it your view that it should be funded through the actual funding, or do you think that the users of the system should pay for the operational and maintenance costs? What's the government's position on that?
Under the Murray-Darling Basin Plan, when you look at those SIDLAMs, which is the programs that are funded by the federal government, and this is the challenge.
It's unclear as to whether that funding includes operational and maintenance costs. That's why I'm pushing you on this, Minister. What's the government's position on who bears the operational and maintenance costs for these projects whenever they are completed?
Well, when they are completed and they are operational, this is the discussion that we will have further down the track. The Murray-Darling Basin funds these projects. That's why they do need to be accredited, so they do meet those fundamental basics of healthy rivers, healthy farms and healthy communities.
So you haven't had any conversations yet?
No, I haven't had any conversations yet about that particular ongoing funding, but that's why we want to come to the table, Mr. Banasiak, in a respectful, collaborative way so that we can get the best results for our communities. And I know that many of our regional communities are relying on the fact that they are doing great work. This is why I think
I've only got about 50 seconds left. When do you plan to have that conversation?
We've got a MINCO with all of the basin states coming up in October, and there will be a number of issues that will be raised.
So will you raise the issue of operational and maintenance costs at the next MINCO meeting? Is that what you're committing to here?
There will be a number of areas and issues that will be raised.
Will that be one of them?
Well, I can't commit to that will be part of the package that I take forward, Mr. Banaziak.
Oh,
but
come on, it's not that hard. Just put it on the list.
Mr.
Email it through to the
Banaziak,
agenda.
I'll be carrying forward the best interests of New South Wales when I meet with my Basin State ministers in early October.
Safe environment, tell us here, no one low.
Oh, yeah, we're all friends here. Who am I going to next? Mr. Pearson?
Thank you very much, Chair. Minister, we're going to come back to greyhounds. My first question is that Greyhound Racing New South Wales stated that in 2020-21 report, a total of 1,880 greyhounds were rehomed by the Greyhound Adoption Program. However, GWIC claimed that only 319 greyhounds were rehomed by GAP during that same period. So, Minister, could you please explain what happened to the 1,561 greyhounds missing that are unaccounted for?
Mr. Pearson, can I just ask you, again, apologies, those numbers were just a little confusing. Could you please just, again, sorry.
Okay, so
did you want to go?
Greyhound Racing New South Wales in the 2021 report stated that 1,880 greyhounds were rehomed under GAP, but GWIC statement for the same period states only 319 were rehomed. Can you explain why there's such a discrepancy of 1,561 animals?
No, but I will ask Mr. Griffin, who heads up Greyhound Welfare Integrity Commission, who may be able to provide some clarity around those numbers for you, Mr. Pearson.
Yeah, thank you, Minister. So the numbers that we report are based upon direct information received from participants, and there is that discrepancy you've outlined. Greyhound Racing New South Wales...
Is that concerning to you, such a discrepancy? I mean, it's not 20 animals, it's 1,500.
No, the difference, I guess, in terms of the 1,800 to the total number of 1,400. But Greyhound Racing, or particularly GAP, has advised us that they actually include in their numbers those greyhounds that have been rehomed by private rehoming organisations where they've provided the payment for the desexing and dental cleaning.
Okay, so you believe that that actually explains that discrepancy?
Yes, it does. And I've had more recent discussions with the new CEO of Greyhound Racing New South Wales. We want to do a reconciliation to make sure that the numbers that we're both organisations reporting have been validated.
Thank you.
Mr. Pearson,
it's a bit hard to follow that. I mean, that's not very helpful to the community to have these such very different figures. When clearly one of the main issues with greyhounds is what happens to them once they're injured or can't race any longer. Minister, in respect to Greyhound Welfare Integrity Commission quarterly reports, again, there was another change in reporting when prior to the third quarter of 2021, there was a classification of, quote, euthanasia after a registered veterinarian certified that the greyhound was behaviourally unsuitable for rehoming. But then it changed, quote, euthanasia with a statement that the greyhound was behaviourally unsuitable for rehoming. Minister, could you explain who, therefore, can deem a greyhound to be classified, quote, behaviourally unsuitable for rehoming? Unquote. Should it have to be a vet, or could any Joe Blow make such a statement?
Mr. Pearson, again, thanks for your interest because the welfare and integrity remains at everything we do, and rehoming is very important, and the process to rehome a particular greyhound. They do go through a number of checks and balances to ensure that they are suitable for rehoming.
Has the veterinarian been removed from that necessity?
I will ask Mr. Griffin in a moment to clarify, but there are a number of checks and balances in a process where a greyhound proceeds along to ensure that it is suitable for rehoming. And if ultimately that the greyhound is not suitable, then other pathways are offered. But I will ask Mr. Griffin if he would like to elaborate further.
Yeah, thank you, Minister. There is a rehoming policy that GWIC has established that requires participants who want to rehome greyhounds to make two genuine attempts to rehome the greyhound with GAP and also to a private rehoming organisation. Those greyhounds that are still unable to be rehomed, then there's a requirement to go to a veterinarian to make that assessment that you're referring to, and then they've got to give us 10 business days notice of the intention to euthanise that greyhound. But no, veterinarians need to sign off on any behavioural.
But that is not what it states.
That's because that's not a pathway at the moment. So what the data is referring to there, it's accounting for, I think there was a very small number of greyhounds, I think it was 4, where there's been breaches to our policy.
So, but the way this states at the moment is that a person can make a statement, could be the owner of the greyhound, could be a friend, that the animal has a behavioural problem and therefore cannot be rehomed and therefore it'll be killed.
Yeah, that's not permissible under the policy as it currently stands. So
can you can you please come back to me explaining why there is that discrepancy?
Absolutely, I'll take it on notice. But at the end of the day, I just want to make it quite clear that a greyhound cannot be put down because by an individual participant on their view that the greyhound might not be suitable for rehoming. That has to go through a process that I've outlined, and a veterinarian has to be involved.
So the veterinarian has to do the assessment, you're saying, not just the the killing?
No, sorry, the euthanasia, but we don't allow for a behavioural pathway at present. We are considering it, but at the present, you've got to go through those steps as I've outlined earlier, and only when those steps in the rehoming policy have been gone through can you then lodge a notification of intention to euthanize before that happens.
Ms. Fairman.
Thank you, Chair. Minister, based on your comments before the break, I think it's clear that Dungowen Dam has been selected over other projects because it is the only project that will give security to irrigators, even though it's less effective at providing town water security. So can you confirm that this dam is a $1.3 billion gift to irrigators?
Thanks, Ms. Fairman, for your question, and that's not my understanding that it is a gift to irrigators, as you put it. This will provide water security for the growing city of Tamworth, a town of 60,000
less effectively
people.
Than other options?
Town of 60,000 people that needs that water to be able to provide them with clean, fresh running water like the rest of the state enjoys. This is a city that nearly ran out of water, while other options are being investigated in terms of what that looks like. Dungowen Dam remains the number one choice. The rebuilding or the new Dungowen Dam remains the number one choice of increased water supply.
Minister, if you are so concerned about Tamworth running out of water, why then have you not considered so many other options? The Infrastructure Australia evaluation summary continuously points out the fact that alternatives and non-infrastructure solutions were inadequately investigated or developed. Why have you and your department consistently pursued the Dungowen Dam option at the expense of everything else for 5 years?
So, Ms. Fairman, if you read the summary business case, you will clearly see that Dungowen Dam, a new Dungowen Dam, providing increased water security for Tamworth in conjunction with other options. And one of those is a reverse osmosis plan.
So when Infrastructure Australia states that other options were not adequately explored or developed, non-infrastructure options, all of these other options, do you not believe Infrastructure Australia in what they're saying?
When they talk about not providing water security for Tamworth, I think that they have missed the mark in really assessing the dire situation that this region finds itself in. So other options
It's in a dire situation because for 5 years, so here in the summary business case, back in November 2015, your department was looking at a suite of options for providing Tamworth
Tamworth's water security. Then from 2017, all of those options just get completely forgotten about, completely dumped, and your department focuses for 5 years on this dud of a project at the expense of everything else. So don't you think, in fact, it's your behaviour, your department's behaviour in pursuing this dud of a project over everything else that is actually risking Tamworth's water security going into the future?
When it comes to providing water security for Tamworth, Dungowen Dam remains the single most reliable source for that to occur. There is also
Minister,
an option
that's
about
not what Infrastructure Australia is saying. It's not what Infrastructure New South Wales is saying. It's not what the Productivity Commission has said. The only body that is saying that is, in fact, you sitting there now. Why is it that you are so obsessed with this $1.3 billion project in your own electorate that will not provide as much water security to Tamworth as many other options? It's just for the irrigators in your electorate, isn't it? $1.3 billion of taxpayers' money.
So Infrastructure New South Wales, more broadly Infrastructure Australia, clearly came out and said that Dungowen Dam was not an option because they did not want the city to grow. They did not want the city to expand, to enjoy regional growth and economic development. They said, oh, it doesn't need it right now. So they're saying, oh, no, we don't want regional New South Wales to grow. In my view, that's very narrow-minded. That does not take into consideration the growth that is in regional New South Wales. Why did you not explore the other options? Why has the department, why have you, for years, not explored any other options for water security in Tamworth? Why have you just doggedly pursued Dungowen Dam? So in terms of other options, one of the other options that we are considering is a reverse osmosis plant which will service the industrial area of Tamworth. In other words, the meat processing facilities, where there's in the vicinity of around about 800 jobs to 1,000 jobs there with the potential for growth. What that reverse osmosis facility will do will take the pressure off the town's supply. So they are options that we are looking at. But one of the options was the pipeline back from Lake Keepit to Tamworth. So you would have built a pipeline to dust. Make sense? No. So the other options that are being looked at, as you talked about earlier, was the urban reserve, taking water off farms. So obviously these organisations have no understanding of how regional community works.
Minister, it's increasingly looking likely, isn't it, that Dungowen Dam, the new Dungowen Dam, will actually not go ahead. So over the last, isn't it, Minister? Firstly,
the federal government and the state government have agreed to share the cost of Dungowen Dam. The federal government mini-budget is coming up in October, and we wait to see if there are numbers in the mini-budget handed down by the federal government to support the project.
what happens then? What happens if it doesn't go ahead? You've wasted 5 years. That's the present for the people of Tamworth. Wasted 5 years pursuing this dud of a
Your
dam.
present is a dud project. How disgraceful of the people of regional New South Wales. That's just disgraceful.
We now enter the lightning round. So we have 4 minutes from the opposition, 4 minutes from the crossbench. Your time starts now, Minister.
Thank you, Minister. Minister, I just want to wrap up this issue around the probity aspects of ILGA. As I understand it, Mr Parbury and Mr Smith were already on ILGA when their companies were engaged to conduct work for ILGA. Minister, are you satisfied that all conflicts have been declared and treated appropriately at ILGA?
Mr Veach, to take further clarification on that, I will take that on notice, but those were transition arrangements and all of those probity checks were done. So
No, I'm talking about they were engaged to do work whilst they were at ILGA. Their companies were engaged to do work whilst they were at ILGA. Are you, as the Minister, satisfied that all the required conflicts of interest have been treated appropriately at the board level with ILGA?
Well, that would be my expectation, given the fact that the Commission chair was the chair of ILGA and is now moving on to the New South Wales Independent Casino Commission. So above and beyond reproach in terms of making sure that probity checks were done.
Okay, Minister, what will you do if you discover that the conflicts of interest were not treated appropriately at the board level? This is not you getting involved at the board level. You've just got to satisfy yourself about the conflicts of interest arrangements. What will you do as the Minister if you find out that that was not treated accordingly.
Well, that information hasn't been provided to me, Mr. Veach, so in terms of where we sit at the moment, it's a hypothetical situation.
Are you going to go and satisfy yourself that the conflicts of interest have been dealt with appropriately after you leave here?
Mr. Veach, I am satisfied given the fact that the former chair of ILGA and now the New South Wales Casino Commissioner has acted above and beyond reproach in relation to putting the people around him that he needs to keep this city, our casinos, pubs and clubs free from crime and money laundering. If there is an issue going forward, I'm sure it will be raised with me and then we'll take appropriate action.
But you can see here, Minister, how the perception of what this looks like. So members of the board of ILGA are engaged to conduct work on behalf of ILGA. You've got to satisfy yourself, Minister, haven't you, that all appropriate conflicts have been dealt with appropriately. I'm not saying they haven't, but haven't you as the Minister, haven't you got the responsibility to check, to make sure, to satisfy yourself that they have been dealt with?
Mr. Veach, I'm unaware of any of those issues that you are talking about, and in relation to ILGA and the Commission, then Mr. Crawford has been at the helm of that and I believe has done an exceptional job in making sure that New South Wales is setting the benchmark when it comes to keeping our venues and casinos free from criminal activity.
Thanks, Minister.
Minister, we've only got a few minutes left. I just wanted to quickly ask you about the issue of steel sheet pilings in the Cooks River. Are you aware of this?
I'm not. I will have to take that on notice.
Okay, so there is a small section that requires remediation. All other parts of the river are the responsibility of Sydney Water, but there is a narrow section that has not been remediated that is causing pollution in the river. The Cooks River Alliance have raised the issue. They are currently creating the Cooks River Catchment Coastal Management Program. But this has been going on since 2016. It took 3 years for the planning to decide on the values of before they could even start the planning process. Can you please look into this and can you please come back to us and tell us what is going to happen to ensure that this final part is going to be remediated?
Ms Hissos, we can sort that now if you like with Water New South Wales if you'd like to. Are you aware of Cooks River in terms of... Okay, we'll come back to you with information on that.
Excellent. Okay, and if you can come back after the break, that would be great, but if on notice, that's fine.
Sure.
Thank you. Minister, I've just got a quick question about the horse racing industry. Last month, former New South Wales Racehorse Soviet was slaughtered at Merrimist Abattoir in Queensland. He was only 7 years of age. Given that Racing New South Wales rules are against the slaughter of ex-racehorses, but they have actually failed to save Soviet, is there something that the government can do to prevent the death of horses like Soviet in the future?
That's outside the New South Wales jurisdiction, Ms Hurst, but I can tell you in New South Wales there are rules of racing and in fact...
Yes, as I said, the rules of racing... So well, let me ask you another question. Racing New South Wales has previously stated that they would actually support making it a criminal offence for any thoroughbred horse to be sent to a knackery, even if they've been rehomed to persons outside of racing. Is that something that you consider supporting, given that that was something proposed by Racing New South Wales?
Well, Racing New South Wales have the welfare and integrity of horses, not only while they are in the industry, but if they are aware or get any notification at all of a process where a horse is heading down that path, they will buy that horse back. It is not something that we advocate in terms of
Sorry, my question though, as I said, Racing New South Wales, yes, is against the slaughter of those horses, and that is within the racing rules. But my question is that something that you as Minister would support in regards as legislating it rather than it just being a racing rule?
Well, Racing New South Wales set the rules and the way that they operate. So in terms of the
But Racing New South Wales has also stated that they would actually support it becoming a criminal offence, which would actually fall under your portfolio rather than the racing rules. So my question is, would you support it becoming a criminal offence as publicly stated by Racing New South Wales?
Well, if it falls under a criminal offence, that's another jurisdiction. I'm the racing minister. So what I would need to do is to ensure, as Racing New South Wales does, the ultimate welfare and integrity and the process of making sure that horses are looked after, and if they are then going down a different path where criminal activity may or may not occur, that then sits with another minister and with obviously the police.
So are you saying that for it to become a criminal offence in New South Wales that it would fall under the Minister for Agriculture rather than under your ministerial portfolio? Where are you saying it would fall?
I'm saying I'm the racing minister and welfare and integrity in horses, particularly working with Racing New South Wales, sits at the top of everything we do. So Racing New South Wales has very, very strong rules and regulations in relation to...
So, Minister, if it's not your responsibility to make it a criminal offence, who would it fall under if it's not the Racing Minister?
So in terms of the treatment of horses and other animals, including those
not the
retired
treatment,
from-
we're talking about a criminal offence for slaughtering the animals.
Yeah, those that are retiring from, if there is an issue in relation to animal cruelty, it's covered by the Prevention of...
I'm not talking about an issue of animal cruelty. I'm talking about making it a criminal offence for a thoroughbred horse to be sent to a knackery.
That doesn't happen in New South Wales now, and Racing New South Wales...
Well, that's a racing rule, but as we know, there are situations where that is failing because it's simply a racing rule. Racing New South Wales has said that they would support it becoming a criminal offence rather than just an industry rule. And my question is, would you support it as the Racing Minister becoming a criminal offence?
Racing New South Wales has very strict rules in place, Ms Hurst, as you well know, in terms of making sure that they track animal welfare, and particularly when horses do leave the racing jurisdiction, they then go on to other eventing areas.
You wouldn't support it becoming a criminal offence as stated by Racing New South Wales and their desire for it to be a criminal offence?
I'm the Racing Minister, so in terms of making sure that we take care of all things racing, and if Racing New South Wales want to pursue other avenues, then that's something that they will look at, but they are continuously
But that's something that you are open to considering in the future.
That's something that Racing New South Wales are continuing to work on in terms of the welfare and integrity of horses in the industry.
Racing New South Wales isn't required to publish quarterly reports of deaths and injuries, whereas the greyhound racing industry is. In interest of greater transparency within the industry, would you support mandatory publishing of deaths and injuries at the end of each quarter in the same way we do with greyhound racing?
The reporting in terms of racing injuries and associated events, Racing New South Wales have welfare and integrity and work health, place safety at the foremost of everything they do, Ms Hurst. So
my question is not about work health and safety. My question is about, so the greyhound racing industry reports deaths and injuries of animals, and Racing New South Wales does not. And I'm just wondering if you would be open to looking at the same mandatory reporting within Racing New South Wales as the greyhound racing industry.
So in terms of the greyhound racing industry, when the major reforms came through, that was set up to ensure that greyhound racing had the highest integrity, hence the Greyhound Welfare Integrity Commission. So Racing New South Wales has that same level of integrity.
That concludes questions on ready to go?
Been practicing.
Thank you, Mr Chair. Minister, I just want to visit an earlier line of questioning from the opposition regarding cemeteries. Could you just confirm for the committee that there are actually no plans to privatise cemeteries in New South Wales?
That's correct, Mr Martin.
And Ms Hawes, has the Minister ever mentioned plans to privatise cemeteries with you?
No.
Okay, thank you.
Thank you.
Is it?
That's it.
Comprehensive. All right, that concludes our time with the Minister. We thank him for joining us this morning.
Thank you.
We will now return at...
Yes. Thank you.
Okay, welcome back to this afternoon's session. We'll kick off with questions from the opposition.
Good afternoon, everyone. Ms Hawke, did you want to...
Yeah, thanks. I understand you wanted me to run over some of the questions that were brought up this morning.
Yes, I think you indicated you wanted to, you had some new information. Or...
Thank you. So there were a number of questions asked, some of which we took on notice. The question about the administrator reserving the names of Greater Sydney's cemeteries and crematoria. The advice I have is that we will be able to evidence that there was, from the outset, an intent to have them transferred to Rookwood, and that is being actioned presently, and we'll provide that documentation on notice to the committee.
Okay.
Thank you.
Thank you. Mr Crawford. Good afternoon. Hello. This morning you mentioned that both casino operators are paying for the independent monitor, but who was responsible for selecting that independent monitor? I just want to make sure, was it ILGA?
Insofar as Crown's concerned, there was consultation with the Crown looking at a number of options, and the ultimate option was, because they retained them, was Kroll, and there's a tripartite agreement. Basically, they provide us and meet with us and provide us with information pursuant to that agreement. In terms of this monitor, Wexted,
yep.
That's just our own expert there. We received, obviously, the evidence. There was public evidence from the Bell inquiry, and by the time we get the Bell inquiry, and we want to obviously have a look at what the inquiry in Queensland's going to reveal, we want to make sure that whatever operating systems are in place, we want our own team there keeping a close eye on what they're doing down the Star. So that we appointed Wexted.
Yeah, okay, righto. So it's essentially two different circumstances.
Quite different, yeah.
Yeah, okay. And you would have heard the Minister mention this morning that ILGA undertakes probity and due diligence checks on potential board members before they are appointed. Can you just, I guess, provide the committee a bit more detail just how these probity checks are undertaken and what do they actually entail? What's the criteria?
So there's two different things, I think, that might have got mixed up this morning. One is probity.
Yep.
So when someone came onto ILGA, there's checks and balances and a disclosure obligation in terms of interests, and they were all completed by all members coming onto ILGA. But there's a procurement piece, and that's, I think you're linking the two, the procurement piece of our advisors and experts. So our process is, first of all, if it's accountants or lawyers or any other expert, they need to be on the government panel and therefore paid at government dictated rates. Secondly, they need to have the relevant expertise or critical mass to do the job. And finally, they need to have no conflicts of interest. So in the casino space, that's been quite a challenge in terms of lawyers and accountants, because the casinos are very large companies and they have lots of advisors. So I think probably I'd be fair to say all of the four major accounting firms are doing either audit or some other type of work for at least one, if not both, of the casinos, so they're not available to us. So we've looked around and we search for people that can fulfil those criteria. So we go through a procurement process. You're probably aware, much better than I am, of the procurement process of the public sector. So it's exhaustive, and to the extent that we have to manage any conflicts or potential conflicts. So that to the extent there are any issues regarding a firm we're about to engage, then we handle that within our own operations at ILGA. So I think you mentioned Mr Smith and McGrath-Nicol. The first point is Mr Smith left McGrath-Nicol, I think I'm right, but 8 years ago, maybe 9 years ago, so well before he joined ILGA. He gets no financial benefits from anything they do, but we take the view that he was a partner of that firm some years ago, so he doesn't participate in any discussions about retaining McGrath-Nicol. He leaves the room, and we require declarations of conflicts of interest on any matter, whether it's to do with retaining consultants or whether it's to do with a contentious licensing matter. That's a requirement at the beginning of our meetings, and so he would exclude himself from any discussion around McGrath-Nicol.
And good corporate governance process would dictate that they would be recorded at the commencement of a meeting. So it's...
Well, not only that, to the extent that there is a procurement process, that would be recorded in the procurement documents so that everybody, including the other side, knows that there has been a link there at some past time.
Yeah, okay. And I think the government, there's a pre-approved panel as well for particularly around Probity auditors and...
All of that, yeah, we go through that panel, and to the extent occasionally there's not enough expertise, or the right expertise on that panel, and if we need to go outside the panel, we need to put up a special case to government.
Okay, thanks. So you spoke about Mr. Smith. Mr. Parbury, did he, in the same manner, alert the ILGA board?
Yes, look, Mr. Parbury had retired from his firm and became a consultant, and the firm, when he first came on ILGA, I think that firm then merged with another firm, which merged with another firm. I think there's been 4, maybe 5 iterations, and the firm the last firm he was consulting to was then entered into arrangement with an international firm, Kroll.
Yes, Kroll Associates.
He's had the same process as Mr. Smith. He's had absolutely no involvement in anything we've had to do with Kroll. It's been disclosed in the procurement process, and he excludes himself from any discussions involving if they're going to be retained. Now, what's happened with Kroll, they were actually retained by Crown, but everyone knows, and we disclosed that association, but he has no financial benefit from anything that Kroll does, and it's a very similar process to Mr. Smith. So we manage conflicts. They do arise from time to time. We've got a very rigorous process for it.
When you say they exclude themselves from the decision, does that mean they actually leave the boardroom?
Absolutely.
They're not in the room at all?
Correct. Any declarations made, if there are discussions about, you might know somebody who owns a pub and they've got an application in front of us, you leave the room. And you brought back in once that discussion's completed.
Okay, thank you. And they're recorded in the minutes. Same thing. And so they're in the... Okay. So what's the process for ILGA when you appoint a firm as an independent monitor? We did sort of touch on this, but I just want to get clear in my head. Do you go to the pre-approved panel? Is there a pre-approved panel for this type? It's pretty specialised, isn't it?
Yep, yeah, we go to the government-recommended panels and with the right expertise. Wexted, more recently, we've retained them, but we've retained them because of specific casino expertise.
Yep.
The principal of the firm and also a consultant that the firm engages, both very experienced in the casino space, and we think they're absolutely suitable.
Okay, thank you. I just want to move on now to another area. It's to do with harm minimisation, but specifically in regional New South Wales. Can I just start? So what's actions being taken to make gambling counselling services more accessible in regional New South Wales? And I think this might be Mr. Keon.
Yes, thank you, Mr. Beach. I can handle that one. So the government for this upcoming financial year has allocated $33 million towards gambling support services, and that's delivered through the Office of Responsible Gambling under the Gamble Aware banner.
Yep.
So there were some significant reforms last year to consolidate those services to improve the service delivery. So there's now 10 Gamble Aware providers throughout the state that do outreach into 78 key centres. So that support is multidimensional, so it's through telephone call, Gamble Aware helpline, there's online chats, there's referral to online counsellors, as well as a number of self-help resources that can be accessed. And I can give you some of the figures of the take-up on that if you'd like.
If you want to take them on notice and provide them on notice, that'd be...
Yeah, we've got all those,
okay.
Yeah.
And so do you monitor the gambling losses within each regional community?
Gambling... So yes, certainly through. So the Responsible Gambling Fund is overseen by a board of trustees, and as part of their trustee meetings, they look at gambling trends throughout the state.
Yep. And so, if there was an area identified with high gambling losses, what's the time frame for intervention, or is there intervention into those communities to...
I think there's a couple of different elements to that. So in terms of gaming machine turnover, and there's not necessarily a direct correlation with harm. So we're looking at problem gambling and other associated impacts from that. So in terms of so I'll just separate that out. So in terms of those specific things, when there's an application on foot, Mr. Crawford or previously in his previous role as ILGA, considers all that material, whether they'll grant those, whether it's an extension of trading to allow gaming machines or increased numbers of gaming machines. In terms of the problem gambling help, so each of those Gamble Aware providers has a service delivery plan, and their performance against that is monitored by the Office of Responsible Gambling. So we're looking at wait times, whether there's appropriate level of services in there, as well as we're just about to appoint a new provider for the gambling helpline service for the phone call, and they've got strict KPIs that they need to meet in terms of being answered straight away, minimal callbacks, etc. So it's not the turnover we're looking in terms of the service delivery, it's making sure that the people are calling or seeking help are getting that help relatively quickly.
Okay, thank you. A couple of these next questions you might just want to take on notice, I think, unless you've got the figures there. But how many Gamble Aware staff are located in regional New South Wales?
I'd have to take that one on notice, but there's 10 Gamble Aware providers that provide outreach to 78 centres throughout the state.
And how many are there in Metro New South Wales? So
I'll take that one on notice, yep.
And how many Gamble Aware counsellors? Same thing, located in regional New South Wales. How many are located in Metro New South Wales?
Yep.
Okay, and then I might just go on to drink spiking, if I could.
Yes, and I'll take all those on notice, but just to give you a flavour, so for the last financial year, there were 4,736 clients at Gamble Aware counselling that resulted in 16,728 sessions, just to give you an idea of the volume of the servicing.
Now, with drink spiking, are licensed venues required to keep records of drink spiking incidents that occur on their premises?
So, drink spiking, yes. So licensed premises that trade after midnight are required to keep an incident register. So if a drink spike was reported, then they should be recording that in their incident register. So primarily drink spiking is a criminal offence and something that's regulated by police and would be considered under their framework as an assault.
And is there a requirement then to report those incidents of drink spiking to the police? So putting them in the register is one thing. Do they have to report them to police?
Not under liquor laws, unless they've got a specific condition imposed on their licence, which might be more general in nature, not necessarily related to drink spiking. So some premises have a crime scene preservation condition. So if there's a crime, they need to preserve the crime scene and also report that to police.
Okay. Is there a government body for a licensed venue to report suspected drink spiking to? Like who?
No, so it's a criminal offence, so they should be reporting that to police, yeah.
But if it's not reported to police, is there any other way? So it goes in the register, and you're saying that it should be reported to police if it goes in the register?
No, if they've got a condition, and the general condition or the most common condition that we'd see out there is a crime scene preservation condition. So venues that have that crime scene preservation and some of the high risk precincts also have as a blanket condition anytime there's a crime. So in this case there's an alleged assault through drink spiking, they have to preserve the crime scene if there is one and then report that to police. So in those circumstances they would be required.
Okay, but if it doesn't get reported, you're saying that it should go in the register and then it should go to police. Is there
if they've got that condition, yeah.
But if, say, it is happening and it doesn't, and it's not a condition on their licence, then who else is it getting reported to, or is it just going in the incident register and that's it?
Yes, that would be the case unless the victim, so quite often we might get a victim complaint to us or they'd make a complaint directly to New South Wales Police if it hadn't been, and some of the times there's not that realisation until the day after that they think they've been drink spiking, so the venue's not aware of it at the time. It doesn't get reported because their friends or the like have taken them home, and then the next morning they've said this doesn't add up in terms of what I've drunk. And quite often we've seen that's when it's ordinarily reported to New South Wales Police, but occasionally we get that reported to us and we refer that directly to New South Wales Police.
Okay, but is there any way that, if someone's renewing their liquor licence, or is there any other way that the government checks in to see about how much drink spiking has been occurring, or if it's concentrated in a particular area?
Yeah, look, we certainly do. So we look at alcohol-related harm stats all the time, and any time there's an application, we will look at that, and police will put in a submission based on what they have linked to that venue. So in terms of drink spiking, we have had anecdotal commentary that there has been a spike, but our discussions with police are saying overall the stats are not showing that. But regardless, in conjunction with police, we launched a new campaign 2 weeks ago, Think Safe to Drink Safe. That involved a number of posters and resources both targeted at staff in terms of what they should be doing and also targeted at patrons. So that's gone out through our liquor record network, which is 144 liquor records throughout the state, to distribute to all their member venues. So regardless of whether the stats are supporting that or not, we want to be on the front foot and making sure we're putting out that education material.
Yeah, and it is an incredibly important issue, and that's exactly why you should be doing it. And obviously, the questions of reporting would be the reliability of the reporting data would be questionable. Like, I think we can all accept that. I'm just interested to know, you're saying if there's a fresh application, does that get covered for a renewal of a liquor licence?
So there is no renewal. So licences are issued in perpetuity. But should there be an increasing... So we meet with New South Wales Police and their regional coordinators, I think, every fortnight, where we discuss emerging issues and alcohol trends. So where we've identified, and not just in relation to drink spiking, but any increase in assaults, whether it's related to a specific venue or a specific area, then we look at what we can do from a targeted compliance response, either police-led or through us or through Liquor and Gaming or as a joint operation.
But my question is, I understand that if it is reported, then it goes in the incident register. Is that the end of the story if it doesn't go to police? Do you have any random checking? Do you go and do you track the numbers? Do you ask venues to report into you about if they've had an increase?
Not specifically on drink spiking. We are constantly monitoring alcohol-related harm data as a general in terms of targeting for where we think we need to be, as well as other risk profiling in terms of late trading, concentration of venues. That's how we target our compliance activities.
So there's no requirement on venues to lodge their incident register with Liquor and Gaming?
No, we can ask for that information where we feel it's required, but we're monitoring the reported assaults and reported incidents through the New South Wales Police system through their COPS database.
But basically, they don't have to report that. They don't have to provide that incident.
Yeah, if it's not reported in there, granted you, but then we use other intel sources. So if we're getting a number of complaints, as we have more recently where there's been suggestions of an increase, we've responded in that regard, regardless of the statistics.
Okay. I just want to go into the RGF in the last few minutes of this first session, the Responsible Gaming Fund. So just how much has been paid into the RGF Controlled Community Benefit Fund in the 21-22 financial year? Is it possible?
Yep, 21-22 Community Benefit Fund.
Yeah.
I've got the expenditure.
You can take it on notice?
I might have to, or I can come back to you once I find it.
Yeah, that's okay. You can come back later on this afternoon. That's fine.
Yep.
And then again, you've got how much money has been granted from the fund, sort of in the total. If you've got the breakdown, you can table that too if you want.
Yep, certainly.
Yep. Okay. And so, if you could provide on notice a list of who the successful applicants were for the 21-22 financial year.
Yes.
Yep. Thank you. And the Gamble Aware website only displays successful applicants to the fund from 2019. Is there a plan to update that at all?
So I just want to check we're talking about the same fund, because there's the Community Development Fund, there's the Community Benefit Fund.
This is the Community Benefit Fund.
Yep, so as far as I'm aware, there hasn't been... we're just about to launch a new grant round for the Community Benefit Fund. So we've budgeted about $3.5 million this year, which is the bulk of the funds. So I'll come back and confirm for you, Mr. Veach, but my assumption is that we haven't run that grant program in the last 12 months. Okay. Therefore, there's been no expenditure from it.
Righto. Okay. And liquor licensing fees? So with the impacts of the COVID-19 on the hospitality industry, have you undertaken a review of the existing licensing fee structures?
So we've got a discussion paper coming out next month, which is looking at reforms to the liquor licence scheme, which will also include reforms to the liquor licence fees, but certainly during COVID. So currently most recently we've done an extension to pay, so venues were given till the end of this month, I believe, to pay, so a couple of months extension. And then during COVID, and I'll give you the exact figures, there was a significant number of fee waivers during the COVID period where the fees were waived entirely. I'll just get a sec, I'll get those figures for you. So in comparison, 21-22, there were 18 million and 43,000. Sorry, yeah, 18 million paid in liquor licence fees. During 2021, in the peak of COVID, there were only 2,300,000 in fees collected because of the waivers and support that was provided by government.
Okay, thank you. See how we go. We might come back to some of those a bit later. First.
Thank you. I'll just start with a few questions to Mr. Keon in regards to racing. In November last year, the Thoroughbred Aftercare Welfare Working Group released the final report called The Most Important Participant, and that report's got a comprehensive framework for improving thoroughbred welfare in Australia. Do you know if any steps have been taken within New South Wales to actually address some of the recommendations from that report?
Are you talking about the traceability? Also traceability initiatives?
I mean, I think that there was a whole range of recommendations from that report. So the report I'm referring to is The Most Important Participant. It was done by the TAWWG. So there's quite a few recommendations. I can ask you about one of the key recommendations if you're not able to address all the recommendations. One of the recommendations from the report was that the racing industry should create a national welfare body to drive improved outcomes for thoroughbreds in all stages of their life. Has there been any progress towards establishing that kind of a body in New South Wales?
So sorry, I do have that here. So that report is currently being considered by the racing control bodies in consultation with government. So we're waiting to discuss their positions on those.
And what's the timeline on that, given that that report was released in November?
I'd have to take that on notice. And
yeah, if you could let me know. And so none of the recommendations at this point have been taken on because they're still under consideration. Is that?
I will double check that and confirm with you hopefully later this afternoon.
Yeah, if you could.
Yep.
Oh, okay. Yeah, this afternoon would be great. Racing New South Wales also introduced its minimum standards and guidelines for equine welfare. Can you explain how these standards are being enforced across racing participants in New South Wales? Who's actually watching over those new standards and guidelines?
So Racing New South Wales oversees those standards. Racing New South Wales doesn't come under the direction or control of the New South Wales government.
I understand that.
So they're responsible for enforcing or oversighting those welfare initiatives.
And do you have any information as to how it's working, or is it a completely separate process?
It's a completely separate process.
The Thoroughbred Aftercare Welfare Working Group report also states that Racing New South Wales has spent $33 million buying and upgrading 4 properties designed for caring, retaining and rehoming New South Wales thoroughbreds. Can you tell me, and that's on page 84 of the report, can you tell me how many horses, and it's okay if you take this on notice, but how many horses have benefited from this program since its inception, and how many retired horses are currently living on those properties?
I'll take that one on notice, and I'd say we'll have to get that information from Racing New South Wales, so unlikely this afternoon. I'd have to be a written response to that one.
Yeah, on notice is fine. Thank you. I have some questions. I think Mr. George might be the best one for this one. I think we might have spoken at previous budget estimates about mange at Bundilla. I had previously asked Minister Pavey about the situation in regards to Wombat mange and the research trial that's being funded by Water New South Wales in that location. It was meant to start a long time ago. It was delayed multiple times because of COVID. I'm just wondering if you could give me an update on where the trial is up to and if it's commenced.
Thank you, Ms. Hurst, for your question. Yes, the treatment program actually started in April this year. University of Tasmania is coming out every month for 2 nights to undertake that treatment program. The intent of that program is to last for about 12 months, so until early next year. And in November, we will be reviewing the frequency of that treatment program out there. I might say that the signs of recovery from mange disease have been observed to be treating the wombats and to be effective. And so there's a small handful of wombats every every opportunity, so every month that are being treated. So at this stage, we're seeing a much smaller population that have mange than were originally anticipated at the beginning of the trials.
And do we know when I think you said it was going to be reviewed in November. Will that be when it's concluded, or will it conclude sort of later than November?
It may conclude later than November, so as I said, it may go through to April next year, but the frequency of that treatment program is what's being reviewed, and certainly at that time we'll be considering at what point it would make sense to hand over to the local wildlife carer groups.
And is it still the intention that the results of this trial will be made public so that it can be replicated in other locations?
Yeah, absolutely. That's the case.
Okay, thank you very much for that. I have some questions for Mr. Griffin in regards to GWIC. I wanted to ask about the e-track system that was announced earlier this year. I understand that GWIC was given $3.6 million by the New South Wales government to build the e-track system. Is that correct?
That's correct.
Was that additional or one-off funding specifically for that project, or did it come out of pre-existing industry funding?
No, it was an allocation from the Capital Fund for the Department of Customer Service.
Thank you. And was that the total cost of the projects, or are there further expenses that will need to be funded in the future?
No, that's the total cost of the project.
Total cost. And how will ministers ensure that every greyhound born into the industry will get registered on e-track? How will we make sure that a litter of new puppies will end up on that system and not disappear?
Yeah, that's because every participant, once a litter is born, is required to register that litter with the Commission, and they do that because obviously every greyhound pup is very valuable to participants, and then within 10 to 12 weeks we then microchip and e-brand the greyhound so that we can then identify that greyhound moving forward throughout its life cycle.
And is there an enforcement in place to make sure that that's happening, other than the assumption that people will do it because it's part of the requirements?
Yeah, so it's under the racing rules when we issue a direction, that is a direction having greyhound scanned. If it hasn't been scanned in the calendar year, then that's a breach of those rules, which we can then take action against that participant.
Thank you.
To do so, yeah.
Oh, thank you, Chair. I might raise the first questions with you, Mr. Barnes, if we could, and thank you for your patience today, listening in intently from the back. Can you just give me an indication on the current number of active prosecutions in court that NRA has? I think the last quarterly update was the March one, so I just want an update on that. 7. So it's dropped quite a bit since March. I think it was 15. I understand that you've recently withdrawn from a number of prosecutions. Can you just give us a little bit of information about that?
We brought 34 prosecutions in the 4 years that we've been in existence. Of beg your pardon, Siri. So a number of cases this year have been withdrawn. A number of reasons for that I can go through here if you'd like, Mr. Field.
Give us a top line.
Top line. So I'll give you an example. 2 landholders from the Walgett area were charged with offences for pumping outside the flow conditions and for failing to comply with the direction. Those charges were withdrawn based on logbook inaccuracies and expert advice that I obtained regarding the gauging, and this direction charge was subsequently withdrawn on the basis of the defendant's ability to comply with the direction.
Right, so what we're saying is basically the evidence that was collected using the logbooks to demonstrate breaches of the Act, that wasn't sufficient evidence, if I understand, and there'd been some sort of judgment that led to you coming to that conclusion and withdrawing from those prosecutions, is that right?
The Land and Environment Court had made a judgment earlier that had implications for other cases that NRA had active.
Okay. Now, if I understand correctly, the ones that you withdrew from, or at least a couple of the ones that you withdrew from, were prosecutions that came about as a result of the Four Corners Pump program, is that right?
That's correct.
Can you give us the status of where all of the prosecutions that were initiated as a result of the Four Corners Pump program are at?
So those matters have largely concluded with 2 successful convictions by my colleague, Mr George at Water New South Wales, and 1 by NRA against the defendants Harris and the defendants Barlow. Other matters, those that aren't proceeding, have been subsequently withdrawn.
Right. How many related to Four Corners pump program were withdrawn from?
So 4 withdrawn, 1 was lost.
Okay. I noticed in the May board meetings a reference to a Janbeth prosecution. Is that one of the ones arising from pumped?
Yes.
Yes, and you've withdrawn from that one. Was that a Harris one?
Yes.
Yes, okay. I noticed in the board minutes as well that you've continually raised issues about the duly qualified persons program. These are the people that are implementing and validating metering and equipment. Can you just very quickly outline your concerns with the DQP?
So DQPs provide, the duly qualified persons are central to the implementation of the non-urban metering regulations. They're required by the regulations to either install or supervise the installation of the meters, to validate their accuracy, and then to take the steps where required to install local intelligence devices and have some of those connected to the telemetry system. So it's quite a complex role.
And what's your main concern?
That there is some insufficient supply of DQPs in New South Wales to meet the demand that the non-urban metering regulations require.
You don't control this process at all, do you?
No, I do not control. NRA does not control it. There are 200 DQPs registered at the moment, but we estimate about 50 of those are active in the installation and certification at the moment.
So in these instances where you've had to withdraw from prosecutions as a result of problems with the logbooks and verification of evidence, if a DQP's done the wrong thing or made an error in the installation, that could impact on future prosecutions, right, that you've got to bring.
Well, the prosecutions under the Water Management Act are to the criminal standard, beyond all reasonable doubt. That's appropriately a very high test. And so the evidentiary burden sits with the prosecutor, and it's important that we maintain a robust case that satisfies the magistrate. That's a very hard hurdle to undertake. Some of the elements arising from the Four Corners is the fact that these are cases from conduct of 2016-17. So with the passage of time, it can add a challenge or an additional burden to sustain in that evidential test.
It would be better, though, wouldn't it, that the regulator, NRA, trained, authorised and ensured that the DQP process, the installation and validation of metering was, it wouldn't be better off if you did it, right?
We're a busy regulator.
Do you want to do it?
No.
You don't want to do it?
No, I think the implementation of the rules sits best outside the regulator. Our job is to ensure compliance and that the laws are enforced. We work very closely with our department colleagues and Water New South Wales together to implement what is a very ambitious program of water reform, which will ultimately see most water being taken in New South Wales be via an accurate meter, independently certified and telemetered.
Currently, a private company is paid to deliver the training of DQPs, right? And develop the training do the training for, sign off on their certifications.
Irrigation Australia has a role in verifying the DQP. They can be trained through other RTOs.
Right. And we're relying on DQPs to ensure the metering installation program that is delivered. Where is that at the moment?
What part of the program, Mr. Veal?
Well, if I could just conclude that question, Chair. You used to provide relatively regular updates on where the metering installation at the various stages is up to and the percentage of compliant meters. Could you just give us the top line on the percentage of compliant operators in each of the categories?
So if it helps, I can talk specifically about tranche 1.
Yep.
So that's the greater than 500 millimetre works. So as of 1st of August, over 90% of those works have an accurate meter installed that has been independently certified. So that's from 548 active works.
Yep.
Now, 72%, beg your pardon, of those works are now fully compliant in that they have been connected to the telemetry system. Now, of those 28% of active works not yet fully compliant, most of those are because they are unable to connect at the moment to the telemetry system due to a number of circumstances. I can break it down further if it's helpful.
I might put a series of questions on notice with regards to that. Thank you, Chair.
Thank you. I might just pick up where we left with the Minister. Mr Bentley, has the Minister sought any advice from your department before attending MINCO in terms of where these Sustainable Diversion Limit Adjustment Mechanism projects are up to and how much time he should ask for in terms of an extension?
We've certainly reported to the Minister on where the projects are up to. I think the issue about how much extension of time do we need is a fairly complex one, because some of these projects, they're not all build a piece of kit type of projects. For example, the constraints program, as we used to call it, reconnecting river country, you're talking about many, many landholder negotiations and so on. So some of those things take a very long time. The other thing is, as we were talking about earlier, what was the Menindee Lakes project, which was rescoped because we didn't get community support. Arguably, we were never going to get community support for the program as originally advised. How long will it take us to get community support for what we're putting forward now is a very difficult question to answer. So I don't think my colleagues across the basin collectively have landed on how much more time would guarantee that we would do everything. I don't think, you know, myself and colleagues from other states have got there to be able to advise our ministers accordingly. So he gets regular updates. We're all talking about we need more time. I don't think we've landed on exactly what the number should be.
Okay, so the Minister was pretty hesitant to really answer this question, so I'll put it to you. Sorry?
Or any question.
Yes, well, that's another matter. But he was hesitant to really address this issue. And I'm sure your department's given this some thought. If an extension isn't granted by for any of the states, including New South Wales, what are the options that are available to still meet those water-saving targets that you've agreed to? What are the options available?
Well, there's no simple option, because a change, at least one change, probably multiple changes to the plan would need to be made whatever we do. And I know that the question you were asking earlier, I think, was leading to the topic of potential buybacks, which everybody is concerned about. But there's only so much money that's currently budgeted in the Commonwealth for buybacks, and there's not enough money left in that total to buy back all of the water that would currently be forecast to be a shortfall if we don't extend the timescale. So there's often been conversation that extending the timescale requires a change to the plan, which requires legislation, but actually not extending the time will also require a change, because there isn't currently enough money budgeted for the amount of buyback if we don't make more progress.
How much money would you need?
I can't answer that, because it depends on market values, and it depends also on what the analysis.
Or a rough ballpark figure, like how short are we in that fund?
I'll take that on notice.
Yeah, sure. Can you give us an update in terms of those 5 accelerated projects? Where are we? You gave me an update in March, but how far progressed are we on those?
Shortly, if I may, I'll ask Ms Emery to update us, because she's from my unit, water infrastructure. But just broadly speaking, 45 gigalitres per year of saving is due to come from that program. 15 gigalitres is either about to be or is currently in procurement. So we have progressed beyond the design phase that you were talking about this morning. And that 15 gigalitres is definitely deliverable. Well, when I say definitely, unless some amazing event that we can't foresee occurs, that 15 gigalitres is deliverable before June 2024. So that phase of the projects. There's another 30 gigalitres, half of that soon after 2024, and then the remaining third would be a year or so after 2024. That's the kind of broad overview. We've been discussing that with the Commonwealth. I know the CEO of Water Infrastructure and Ms Emery were down in Canberra talking to Commonwealth colleagues just the other day on that topic. But Ingrid, are you behind me?
Thank you. Just to provide an update, so the Locks 8 and 9 and the Mid-Murray Anna Branches projects are the most advanced of the 5 accelerated projects, with detailed design well progressed and some early works already underway for the Locks 8 and 9 project. The Kundruk Paracuda project and Yanko Creek modernisation, Yanga and Milawa National Park projects are currently completing concept designs, and that includes preparing basis of design reports, preliminary procurement details, delivery and operational plans, as well as obtaining planning approvals for each project component. Completing this stage is a significant milestone and will guide these projects for the next stage of design ahead of construction.
Thank you. And just quickly, in the last 30 seconds, I did ask for those figures as of 9th of March. Do we have an update in terms of those figures too? Just in terms of, have we had more allocated? Have we spent more?
No, so the figures provided in response to your question we took on notice were actually just for the SIDLAM acceleration component. So there has been no further funding allocated. The total expenditure to date is sorry, I did have it, but I had it aggregated. 28.2 million.
Okay, and I did ask before the break for a dissection in terms of where that money has gone to.
We will need to take that one on notice. We can't do it today.
Yeah, no.
Thank you.
That's fine. Opposition?
Thank you. I this morning very briefly touched on regional cemeteries, and so if here we come. Just. Thank you. If I could, probably in a bit more detail than we were going to get from the Minister this morning, but the reality is that a number of local councils in the regions are still concerned. There's a bit of angst about the proposal as it relates to how they operate their cemeteries. Some are saying that they're fundamentally different to private operators and there should be a different category. But can you maybe just provide us with an update as to where this is all at, so it might help further questions, really?
Sure. My pleasure, actually. So we've just closed consultation, thank you, which was the third stage of our consultation, and councils have been involved since the beginning, and we've been working with them to actually understand what their concerns are. We understand that some of them are less, let's say, sophisticated in how they have their systems and processes, and that was feedback we received throughout the consultation process, especially from those regional councils. So we are aware that there's an issue there. So in response to that, we have different categories based on size. So the number of interments that each cemetery does or each operator does.
Sorry, Ms. Hickey, just to clarify, so not population size.
No,
but
number of
the
burials
number of interments.
and yeah, mass interments. So we recognise for the ones that do less, there's less requirements. And in fact, we've also recognised inactive cemeteries now, a caretaker cemetery in effect, which doesn't have to do much at all. So we've tried to, stagger the requirements according to the size of the operator and the volume of interments that they actually do. And then in terms of that feedback, what we're doing to work with them is we've set up some council working groups, and we're getting the councils that actually are a bit more sophisticated to help do a community of practice, so that they can help them through what it is that they do. We're also trying to recognise equivalencies, so where they already report to council on things through their reporting framework, we're just trying to get some of those conditions a bit up to speed so that it's not a massive difference from what they already do. And I guess the other thing is we're also trying to provide explanatory material where we can, and provide templates and guidelines wherever we can. So I'm happy to go and visit any of those councils and take them through it so we really understand where their issues are. We can't get away from the fact that some of them will have to put in some extra work. We know that, and I know staffing's an issue in those cases, but we're doing what we can to help them do that. The other thing that we're doing is we've given those smaller councils more time to get up to speed with the scheme. So full compliance won't be required until October 24 for those councils that have less interments.
I guess the main thing, you're working through the duplication or the potential to prevent duplication?
That's right, the equivalencies, yeah.
Yeah, that's okay.
Yeah.
And the small operators who don't qualify, going to have sort of they're going to be a category for those?
Yeah, so there's 4 categories. Category 4 is the caretaker.
Yep.
And so they're the ones that don't want to do any more interments. They've pretty much closed up shop apart from what they've already sold. Category 3 is less than 50 interments. So the ones that do 50 a year on average have to do less. Yeah, okay. And yeah, category 1's the bigger one, and that is the one with the private operators or the large private operators in it, and the large crown cemeteries and the large councils as well.
Okay, and so what's the time frame? Remind me for all of this to actually be in place.
Yes, so we're asking all of the operators to start applying for their licence from July next year. And that is over a staggered amount, so we're doing it in tranches with the with the categories, the smaller categories to be last on, and then the conditions are also switched on in staggered ways so that they get used to it as they go.
Okay, all right, thank you.
Yeah.
Yeah, thank you very much for that. Now, it would be remiss of me not to ask this because I do at every estimates hearing for Department of Lands or Crown Lands, but can we just get a current status of the number of land claims as at today's date, please?
Yep, thanks. And I'm pleased you asked because we are quite proud of some of the progress that we've made with land claims. There is obviously an enormous number that has remained large, but we've made incredible progress, and this, in the last financial year, signed off more than 500 positive land transfers, many of which went to land councils that have never previously had a land grant. You asked for the current statistic. It is 38,385. That is a statistic, but we are doing work in a number of areas to improve that, not just expediting the claims process, which is a complex statutory process, but more importantly, working in a different way with the land councils to prioritise the claims that they wish for us to prioritise, and to work on negotiated outcomes through Aboriginal land agreements to settle multiple claims and interests and unlock opportunities in that land. So we've fundamentally changed the way we work with the land council network.
38,385, did you say?
That's correct.
Yeah, that's an increase of how many on last year?
I have that here, if you bear with me. A couple of hundred from memory. Can you just bear with me to find that stat? Yep. Thank you. It's grown by 290 from June last year, so we have seen that we're better able to keep pace, but as I said, more importantly, we fundamentally changed the way we work with the Land Council network.
Okay. Can you take on notice for me, what's the 5 longest land claims that have been sitting on the books? What is the length of those claims that are yet to be resolved?
And absolutely, some of them are quite old and date from the initiation of the Act itself, so there's no shying away from that, but they are complex claims for legal reasons that we're working through. I can take on notice the 5 oldest. Is that your question?
That's the ones, yeah.
No problem.
Thanks very much. Can I talk about housing partnerships? As well. That was sort of touched on briefly this morning by the Minister on a couple of occasions. Didn't quite relate to the question that we asked, but that's okay. Under the first action plan, the government's piloting a housing partnership scheme with New South Wales Land and Housing Corporation to build up to 200 homes on Crown land in Cooma, I believe.
Yep.
This is being done under a memorandum of understanding between the two departments with the intention of alleviating housing shortages in rural and regional areas. Can I just ask some questions here, but when will the MOU be made public?
The MOU's a signed instrument between myself as the head of Crown Lands, but also the head of Land and Housing Corporation. It is essentially a public document in that sense.
So is it on the website or?
I'll have to take on notice if it's gone on the website. It's essentially an agreement to work together to... So with Crown Land, because it is public land, we need to be conscious of how the use of that land for the purposes of social and affordable housing delivers public value. So it's a case-by-case assessment to determine which parcels of Crown land would be suitable and to work with Land and Housing as a delivery partner, and very often with Aboriginal interest holders who may have claims in that land to negotiate outcomes that are essentially win-win for different parties.
Okay. If the MOU is a public document, are you able to table it with the committee at some stage?
I don't see why not, but I'll take on notice because it may very well be on the web. So.
Okay, thank you. And you were talking about social and affordable housing. I suspect the pilot will take place and a variation of the pilot will then be rolled out across the state. Is that the plan?
It's probably a little more nuanced than that, in that we're working with Land and Housing Corp and other parties, and I mentioned the land councils, but also native title holders, to determine where there are parcels of land in areas that are experiencing housing stress that might be feasible for a development of this nature. So it's not a blanket approach, it is quite nuanced and site-specific, and so we're looking at a number of sites that could be opportunity sites. Cooma was the first one to be struck as an agreement with the Land Council and with LAC and Crown Lands. There are other sites under consideration, but it's not a blanket approach. It is quite nuanced to the site, the characteristics of the site, and interests and claims on the site.
Okay, thanks. And so at Cooma, how much do we know just yet, just how much will be social and how much will be affordable housing? Is that actually that detail been determined?
Well, the project will deliver as many as 250 social and affordable homes through LAC on what is currently Crown lands.
Okay, yeah. Do you know how many social?
It's 250 homes, my understanding. It's because it's through Land and Housing Corp, they are social housing homes.
Righto. Okay. And so just to be clear, this is not about selling off those homes at some stage? This is actually a part of a process with the Land and Housing Corporation?
Yeah, absolutely. It's recognising that there are areas experiencing acute housing stress and areas that would, benefit greatly from increased social housing, looking at where those sites exist, partnerships that we can interact with land councils and other interest groups and work together with Crown Lands providing the land and the Land and Housing Corp providing the delivery.
Yep. And I guess the last part of questions around this is around monitoring and reporting progress. On this, is there a schedule and a process for making that monitoring public?
We have a project plan, and my colleague here can speak to the LAC side of the business. We have a project plan that we share to monitor progress. There is a reporting approach in place.
Is it Mr. Walker? I can't see. Yep.
Sorry, hiding around the corner. Both LAC and Aboriginal Housing Office may also have interest in this program and would certainly be reporting against it as well.
But that will be made public, though, won't it?
Yes.
Yeah, okay. Thank you. And I'm just going to go on now to the Cemeteries and Crematoria Act 2013 specifies that one position on the board of cemeteries and crematoria is reserved for someone with knowledge and expertise relevant to local government and local government matters. At last budget estimates, that position had been left unfilled by the Minister for 3 years. As I understand it, now I could be wrong, I just want an update, but I suspect it is still unfilled. When will we be filling that position?
So we do have an update. It is in train, and I'll throw to my colleague, Ms Hickey, to talk you through the process for that reappointment.
Thanks, Ms Hickey.
Hi. Yes, we've received nominations from Office of Local Government and also local government professionals, and I've spoken to Local Government New South Wales. They're running an EOI process now, which is closing by the end of this month. So once we have those nominations, we'll put that to the Minister for his decision and then endorsement by Cabinet, hopefully. Yeah.
Okay, and are you working towards a time frame, or is it sort of at this stage not quite known, but you're in the process, just not quite sure when the process is?
Yes, yeah, in the process. So, but I expect that we'll be putting something to the Minister in the next month or two.
Rather than later?
Yeah.
What is the reason for it having taken so long to fill that particular position?
Yeah, so there was a candidate, there was a recruitment process in between that time, and that candidate withdrew at the very end, and so nothing happened since then.
Was there not a second applicant that may have been in the mix that we could have called upon?
I'm not sure. That was just before my time, so I'm not really sure. Yeah.
Okay.
I think the takeout is that it's been refreshed, re-energised, and we hope to appoint someone fairly soon.
Sorry, what's the phrase? Refreshed and re-energised?
Re-energised the process, and we hope to be able to appoint someone soon.
Okay. Oh, I like that phrase. Refreshed and re-energised. Hoping to do a bit of that in March next year myself. I think that might... How much longer do I have? Huh? 6 minutes. Okay. I might...
Can I just jump in?
Yeah,
Sorry, I was a little late coming back from lunch, and I think I just missed, Ms. Hawes, your statement. You said that you were looking into it.
Yes, thanks. There were a couple of things. One was this morning there was some discussion around the appointment of Leader Investments and Ms. Shearer as administrator. And that conversation sort of went down a particular path, but there is nothing unusual for an administrator to be appointed as a corporate entity. Ms. Shearer is the administrator. No other directors under that company holding are able to enact those functions. And it's standard practice to appoint a corporate entity into an administrative role. So there's nothing untoward about that, and I'd like to clarify that for the record. The other point that I made just before after the lunch break was that we can provide evidence as to the transfer of those business names to Rookwood.
And do you have a time frame for the transfer to occur?
It's occurring at the moment, so we'll be able to provide you the documentation to show that that was always the intent and that it's being actioned.
Okay, thanks very much.
Thank you very much. Can I now just start the next round with a couple of questions for Mr. Barnes? Good to see you again, Mr. Barnes. Hopefully Siri doesn't interrupt our conversation like it did your last conversation. Can I just ask, so what's this, as I understand it, there's a bit of either a restructure going on with NRA or there's a change in your staffing profile. Can you explain to the committee just what that looks like and why?
So we've reorganised primarily the executive at NRA. That new structure went live a couple of weeks ago. There was a couple of drivers for that change, Mr. Veitch. One just acknowledging that we're 4 years old as an agency and the landscape in which we work within has changed quite considerably. One notably is a good thing, it's now raining, possibly more in places that is desirable, but we've gone from severe drought into a cycle of certainty in terms of water. That's affected how we deliver our work. No longer are we subject to substantial volumes of complaints from the public making allegations of water theft. In fact, that's dropped off from hundreds a month down to 10 to 15 a month. That's enabled us to reposition ourselves to be more proactive rather than reactive. And as a consequence, we've been able to divert more resources into our regulatory priorities, spending much more of our time, for instance, in the non-urban metering regulation space and ensuring the successful implementation of that program. We're gearing up to support the implementation of floodplain harvesting and so forth. So what we've done is codify all that work under a regulatory initiatives branch, under a new executive. Similarly, we see oftentimes water users, they want to comply, they have the motivation to comply, but as you'll appreciate, the water management framework is very complicated. It's complicated for officials. It certainly is complicated for water users. Often they need assistance. They want a helping hand. They want, when the phone rings, to someone to answer who has knowledge of the legislative framework to give them the right advice. So we've also set up a branch that provides education engagement directly to landholders through cups and tea and biscuits on the farm, building that relationship. So I'm really pleased I've got a new director of education engagement out there as well. Thirdly, what we've also done is consolidate all our investigative functions under one single branch manager. Our new Director of Investigations, a former investigator in ICAC, brings considerable expertise to the agency and will help us to build on the successes of the last 4 years in terms of our enforcement action and our prosecutions. I give you some comfort to the committee that the number of frontline officers that we deploy was 115 prior to the change. It's 115 now, but we're also the beneficiaries of new funding through the Treasury, through the new policy proposal, an additional $12 million over 3 years, which will see us deploying additional frontline staff, upwards of 20 to 25, all regionally based boots on the ground.
Okay, so I'm glad to hear there's a bit of work being done on the education side of this as well, because that's critically important. But just to be certain, 100%, so there's been no reduction in the compliance officers within NRA, and that compliance activity will still operate?
115 before, 115 after. but in a couple of months we'll have a new wave of keen regulators out in the field, about 20 to 25 more, all regionally based staff. We're a growing agency. It's an exciting place to be.
Mr Barnes, does NRAR operate a fleet of drones?
We do.
Yeah, good. How many?
18.
18. And how
many can you fly?
None.
Can I just ask Mr Barnes, so whereabouts did you source those drones from?
I believe they're DJI Matrix drones. So, I mean, it's a very important question you ask, and I think there's a couple of things to give you some assurance that we're doing so in a way that protects the agency, but also that protects.
You know where I'm going with this, don't you?
I do indeed. Would you like me to stop?
Keep going.
Okay. No, clearly, the information that we collect, we need to make sure that we're adherent to the relevant privacy and personal information protection, but also in terms of the integrity of the information that we collect and how that's stored, that has to be done in accordance with the government's cybersecurity requirements. Because we're an enforcement agency, we have an additional layer of protection that ensures that any information that is contained is done so in a highly safe and secure environment, concordant with the State Records Act and so forth.
So the staffing profile we were talking about earlier, does that include a unit that's around looking at your cybersecurity arrangements and, I guess, profiling the risk that may be associated with things such as a fleet of drones?
So I have an intelligence team that helps us to be intelligence-led and knowing where the problems are. But in terms of maintaining the drones and ensuring we comply with the ICT requirements, we are supported by the department and all their skilled ICT staff in that regard.
Okay, thank you.
Thank you. Thank you very much, Chair. I understand the questions were asked by my colleagues in relation to the drink and needle spiking. I just wanted to cover off a couple of final questions on that. So I think that's to you, Mr. Keon. So just firstly, in the Minister's answer earlier, he referred to the sort of numbers of incidents as being steady. Is that your view as well, Mr. Keon?
So to clarify, I believe the Minister was referring to alcohol-related assaults, non-domestic violence, as being steady over the last 2 years and then a slight decline over the last 5 years. In terms of the drink spiking, we have had anecdotal information come to us that they've seen a rise, but we haven't been in discussions with police, and the advice from police is statistically they haven't seen a rise. Notwithstanding that, in the last 2 weeks we've released a new education and awareness campaigning in conjunction with New South Wales Police. So it's Think Safe to Drink Safe.
Yeah.
We released that out through our liquor record network, I believe it was last week. So it's gone to 144 liquor records, and that's two-pronged. So there's a whole lot of resources which are internal facing for staff in terms of what they can do to better identify and support.
Yep, good.
And then there's also a patron education campaign that's associated with that. So a number of posters and resources just reminding people to, not leave drinks unattended and to watch what they're drinking.
Because the first line on that poster is that drink spiking is on the rise. So that was certainly the impression.
So statistically, we're not, or the advice from police is we're not seeing that. But again, when we're getting the information, we still wanted to be proactive, so we've launched that campaign to do that.
Certainly anecdotally, I mean, I think.
Anecdotally, and as some of your colleagues pointed out, that these things are not always reported, so we don't want to just be relying on statistics to say we are going to act or not. There was enough there for us to say we believe we should be doing what we can to help educate and raise awareness.
Okay, so as part of that then, part of that program, there is training. Is there training or is it just sort of an information?
It's not training, it's awareness and resources. So I can give you the specifics of what they are, but it certainly gives prompts as to what people should be doing.
Okay, and how to recognise perpetrators at the bar and that kind of thing?
Let me pull it up and I'll give you the specifics of the campaign. But it was certainly developed in... So the patron's focus on trusting your instincts, looking out for each other and knowing what you're drinking. The venue posters are focusing on knowing what you're serving, monitoring the environment, knowing what to look for, and having up-to-date RSA training and making sure you've done the online refresher training.
And so in the knowing what to look for, that is that just knowing, I guess, not only the sort of impact of the behaviour of the victim, but also the behaviour or potential behaviour of perpetrators?
I'm not sure, but those resources are on our website, so you'd be able to see the specifics of those.
Okay, thank you. A couple of racing questions. Firstly, just in relation to there was this well-publicised case involving the Racing New South Wales investigation and guilty findings against New South Wales racehorse trainer Kim Moore and the jockey as well, resulting from the cruel use and excessive overuse of sharp spurs on the racehorse, I think it's pronounced Tarsus. Do we know in whose care Tarsus has been placed?
No, we don't, because that's the responsibility of Racing New South Wales to monitor that situation and take any appropriate action.
Okay, so it's not something that we get reported back to us in any form?
No, it's not, no.
Okay, thank you. We may need to take this one on notice, but I'll ask it and see. In terms of greyhounds that are turning up at pounds and shelters, are you able to tell me how many greyhounds were impounded as seized or surrendered in New South Wales pounds or shelters in each of the financial years since 2018-19?
I'll just see Mr. Griffin.
I'll have to take that on notice, if you don't mind.
It's quite specific. I totally understand.
I can give you a comparison of certainly of euthanasia, council pounds, RSPCA versus the industry, and that provides an interesting context.
Okay.
Yep, so in terms of, we've done a comparative analysis of, and I think the Deputy Chair here had an inquiry in relation to euthanasias at council pounds and so forth. And we're actually working to change our rehoming policy to prohibit the lodgement of greyhounds at council pounds, just so you're aware of that process. So in the last, the financial year 2021, 471 greyhounds, sort of 92% of which were euthanized due to illness or what other issues, but basically the medical, non-medical euthanasias are very favourable when it comes to greyhounds. Only 4% of greyhounds in New South Wales in the industry were euthanased due to unable to be rehomed, where in council facilities it was 10%. So it's less than a third than you would normally see in council pounds. And those greyhounds that are euthanased due to unsuitability as a domestic pet is quite significantly high in council pounds, 51%, RSPCA facilities 75%, and the greyhound racing industry is only 4%. So comparatively, the euthanasias due to unsuitability for rehoming is very, very low within the greyhound racing industry.
Thank you. Just while I have you there, Mr. Griffin, you're probably aware of, I'm sure you are aware of the recent live baiting exposure in South Australia.
Yes.
Which has led so far to 3 participants having their licences suspended. Can you confirm if any of those South Australian participants had greyhounds that had been transferred from New South Wales?
Can't confirm that. I'll have to make inquiries and take that on notice.
Thank you. That would be very useful. Oh, I'm out. Thank you.
Thank you, Chair. Mr. Barnes, might come back to you if I could, and just to finish off in the previous line of questioning. With regards to those prosecutions that you've withdrawn from, is NRA currently considering civil action?
With respect to the withdrawn cases?
Yeah. You've got the powers under the Act to pursue civil action where you're not able to meet the criminal level of proof, I assume. Well, we know.
my reluctance here is I think in general it's best that I don't describe in an open setting like this what may well be, Mr. Field.
But NRA's got no barriers to pursuing civil action where it sees that as a a useful avenue without going into specifics.
Yeah, so generally we have a full suite of tools available, both criminal remedies and civil.
Okay, no worries. I think just before the ministerial changeover, Minister Pavey proclaimed the section of the Water Management Act that switched on the requirement to have floodplain harvesting licences to be able to engage in that form of take. It remains a little unclear to me exactly what the effect of that proclamation is on the legality of floodplain harvesting, particularly now in those valleys other than the Gwydir and the border rivers where licences have been issued. Can you clear that up?
Well, I won't give you legal advice. I'll be consistent there, Mr. Field, but what I can say is to take water in New South Wales under the Water Management Act, you must do so in accordance with the terms and conditions of the licence or approval, unless it's exempt or part of a basic landholder right. Now, what do we do when it comes to floodplain harvesting? We actively surveil those events. We use considerable smarts and satellite technology and so forth, and we're able to detect where water moves, where it's abstracted, stored and subsequently used. We have active investigations underway at the moment stemming from a number of floodplain harvesting events. Where it's licensed, it's a much easier situation for us to pursue from a regulatory standpoint than where it is unlicensed.
Okay, so we've had a number of those events in particularly 2021, 2022. You've been conducting surveillance over that time. Have you got a sense of how much water is being taken through the process of floodplain harvesting across those different events?
I can speak to events in 2020 and 2021 through a series of surveillance. We were able to detect ones in the March-April period where it would appear from our surveillance water was being taken unusually. That was an event where the department and ourselves determined about 200 gigalitres of water was abstracted through the flood event, of which we're investigating now as a result of that around 26 instances where water taken was quite considerable. And would be in excess of what might be or what has been granted through a floodplain harvesting licence entitlement.
So given that at that stage the licences hadn't been granted, are you talking about in excess of what that landholder may have expected to have been entitled to once the process had been finished, or the fact that they didn't have licences sort of triggered that for you?
The former.
Right, okay. So in excess of what they would likely have been issued in terms of a licence once this process is concluded?
Now subject of active investigation.
26 instances?
26 instances, and we have currently deployed out on site in 7 of the highest.
Are any prosecutions being commenced with regards to this, or are you still investigating?
Still investigating. It's extraordinarily complex where we are at the moment with deploying staff in the field to collect information. I say to you that all options are on the table, both criminal and civil.
Do you have a breakdown for each of those different flood events, the volumes of water in each of the valleys that you've identified that are suspicious?
Do we have access? Yes, we have the ability to monitor those situations.
But are you able to provide a valley-by-valley breakdown of the volumes of water that were taken in those different events that you think reflect floodplain harvesting take?
So the most recent one we have is the one just mentioned, where it was calculated around about 200 gigalitres. That was before the storages had all full.
Yeah.
You find in some cases now it's mostly full.
Yeah, okay.
So that was around 200 gigalitres.
Okay, that's understandable. The other question that I just wanted to follow up was, actually, I might move on. I might come back later if I can, Mr. Barnes. Mr. George, for you, the status of the preferred infrastructure report and response to submissions for the Warragamba Dam raising proposal. Taking your time, you must be nearly finished.
We're very close, Mr. Field.
What does close mean?
So we're hoping to complete both of those documents by the end of this month, subject to then the assurance reviews that we undertake, and we hope to be submitting those documents to planning next month.
Submitting the documents to planning next month. Have you had to seek additional budget for the additional work that needed to be done on the preferred infrastructure report?
No.
No, so that was under existing budget. I think that there'd been money taken from the Climate Change Fund initially, which had been used for the preparation of the EIS.
Correct.
Was it coming out of that, or was it just other money that Water New South Wales made available for this project?
No. So we're delivering the concept design and EIS under contract to Infrastructure New South Wales, and that funding via Infrastructure New South Wales is from the Climate Change Fund, as you say.
Was any other field analysis done to do the additional work required on the preferred infrastructure report?
Yes, quite a bit of additional fieldwork has been undertaken. That is what has taken us some time. We've done a number of different studies. We have been delayed because of the floods, most recently in July.
Sure.
So, for example, we were out doing additional studies downstream at Long Neck Lagoon. We've been undertaking some geomorphological studies. They were delayed by about 6 weeks as a result of the flooding. So that's why we're a little bit later than what we had planned.
Okay.
There's quite a number of new studies being done.
Have any of your fundamental assumptions changed about upstream impacts as a result of the recent flood events? Obviously, the biodiversity impacts that were going to be addressed through the EIS were based on assumptions about the likely impact of a flood event, and any additional impacts would be offset if those events eventuated. We've now seen some of those very events eventuate. Have your assumptions with regards to biodiversity impacts upstream changed?
They have. So as a result of the flooding both in southeast Queensland and New South Wales, we have been able to do comparative studies to see the direct impacts of inundation and flooding on the ecology. Those reports will be available as part of the preferred infrastructure report. They do indicate that there is not as much impact as the conservative approach we took in the EIS. We're providing that information as more scientifically robust information, given at the time of the EIS we didn't have as much information because the EIS was developed, frankly, during what was predominantly a drought. However, that is then informing the measures that we'll be proposing for land management and managing those impacts as part of the EIS.
Okay, thank you. Thank you, Chair.
Thank you. Just turning back to Mr. Griffin, and I might just ask a couple of follow-up questions from the topics that were discussed with Ms. Abigail Boyd in regards to the euthanasia. To your awareness, do you know if the target date for achieving zero unnecessary euthanasia is still 1st of July 2023?
Yeah, that's a requirement of the Greyhound Racing New South Wales to establish that as part of their operating licence.
And do you know what their definition of unnecessary euthanasia would mean? I'm just, I know that line can be quite blurred when you talk to councils. I'm not sure if you have any insight.
Yeah, I think that's still to be worked out. I've just had some recent discussions with the new CEO of Greyhound Racing New South Wales, because that needs to be developed fairly quickly, so that we can then have some consultation with stakeholders in the industry and also get to make sure everyone's satisfied with that definition.
And will that be public once that definition's made? Yeah, great, thank you. Just back onto the e-tracking system. Do you know at what point the dogs will be registered on the e-track? Will that be required at birth or when microchipped? Is there a specific time?
Yeah, so e-tracking is obviously every time we come in contact with the greyhound, as I said, when we first microchip and e-brand it, it's recorded. And every time it's taken to a vet or it's taken to training, it's scanned. We have these scanning touch points throughout the state, and also when they're racing. So really the only outbound notifications that we send to participants are where obviously greyhounds are retired and still residing with participants. The notification to say, look, your greyhound has not been scanned or checked in and we haven't received any information notification about that greyhound for the past 12 months, please take it to one of these touch points to be scanned.
Okay. But when will they actually be registered on the e-track system? Is there a requirement that, I mean, can you take a dog that's 2 years old that you suddenly decide to get into racing, or is there a requirement like at birth, or is it something that, the first point of time which they'd go on there is microchipping, would it? Or?
Yeah, it's as soon as they're 10 or 12 weeks, when they're microchipped, they're automatically placed on the New South Wales Greyhound register, and that makes it a requirement to have them tracked throughout the greyhound's life cycle within the industry.
And so there's a requirement for that, for like a touch point when they're training or racing. So that's kind of how you'll make sure that there's no kind of invisible class of dogs that are kind of not on the e-track system. Is that?
That's right. So they're all on the register. Those that are actively training, racing, obviously the scanning touch points track those greyhounds every day. But there's a certain cohort of greyhounds that are retired or pre-racing, unless they're going to the vet, where the vet would scan them, then they would be the ones that we'd push out notifications to the owners of those greyhounds and say, please get them scanned so we can verify that they're still alive and well.
Yeah. And in regards to when they are retired from the system, and I know that this is like a long-term problem that's been around for a long time, is, that kind of change from being a dog in industry to a companion animal. How will we track those dogs and make sure that they're properly rehomed and not killed or abandoned at any point after their time in the racing industry?
Yeah, I've stated this at another inquiry, but so as a greyhound's rehomed, we place that greyhound on the companion animals register. We then ring the new owner and check their bona fides, that they're a bona fide real person. If they've never had a greyhound before, we send them literature on how to care for a greyhound, because they're a little bit of a different breed. And then we also monitor that individuals aren't receiving an inordinate number of greyhounds, obviously that could be a problem. So, but once they're on the companion animal register, then obviously that becomes, in terms of the welfare of the greyhound, falls into the province of the RSPCA, Animal Welfare League, and local councils.
So once the greyhound's kind of out of the industry, and obviously there's that, you've got the tracking for that first stage, but following that, then the animal could potentially get lost and we don't know then what's happened. But that's a separate system, is that?
It certainly won't be on our e-tracking system. So yes, it comes off our register because it's placed on the companion animal register. So obviously we don't want to be duplicating it, but under the legislation, once the greyhound comes off the register, and it's placed in companion animals register, it no longer falls within the compliance regime of the Commission.
Yeah, and the pet registry is undergoing some major upgrades, which is it's going to take quite some time, unfortunately. But do you know if the new e-tracking system will actually interact in some kind of useful way with the pet registry, or are we going to make sure that the two systems are designed in tandem so they can seamlessly interact?
Yeah, that was always part of the business case and the plan. When we had the business case at the beginning of 2021, that was at the same time I think the Office of Local Government was putting forward a business plan for funding for the new companion animals and pet register. And we were hoping to reach a delta at the same time, but unfortunately that hasn't happened. But we still have plans and we're liaising with them that hopefully the two, I understand that we could be using the same platform, technology platform, which will make it simpler and easier for the two systems to talk to each other.
Excellent. We'll now break a little bit early for afternoon tea, returning at 3:40. But can I indicate the committee members have informed me that they'll no longer require Mr. Darren Cleary or Miss Jen Hickey for the remainder of the session. So you are free, in the committee's view, to have an early mark. And I do envisage that there may be a few quick dismissals after the end of afternoon tea. So,
as in departures from
departures,
not dismissal.
No, I don't have that power.
Yeah. Not terminations. We just.
No.
Pleased to hear that.
Actually,
Welcome back after that short break. Before I do throw to opposition, I think, Mr. Bentley, you had a correction to make.
That's right. I just wanted to correct the figure for the SIDLAM acceleration money spent to the 30 June 2022 was actually 37 million. I said 28, but...
Thank you. Over to the opposition.
Thank you.
Mr. Crawford. Sorry, I've got the answer to some of those earlier questions when you're ready as well. If you want to just take those now. So in terms of the gamble-aware staffing, so for Metro, there's 92 gamble-aware staff and there's 48 regional staff. And then as a subset of that, in terms of counsellors, there's 66 in Metropolitan and 28 in regional. And then in relation to the Community Development Fund, and I just want to be clear about this because there's two similarly named funds. There's the Community Development Fund and the Community Benefit Fund. In terms of the Community Development Fund, there was 1.4 million in revenue for the 21-22 period. There was 76,000 paid out of that, which was a carryover from the previous year's grants, which have been published on the New South Wales Grants Hub.
Okay. Thank you.
I'm sorry, Mr. Mitchell. So I've got the 5 oldest land claims if you want me to go through them now, or I can take it on notice and
take it on notice, thanks. Yeah. Thank you, though. Mr. Crawford, I just want to come back to a couple of things to clarify around the disclosure of interests. Now, I may have this wrong, but so hence I'm asking for the clarification. So when someone declares, a member of the ILGA board declared an interest or pecuniary or conflict of interest, recorded at the start of the meeting in the minutes, is that publicly available, such disclosures? Or is there a book that you record them in?
I think so. I think that's right. I'd have to double check that, but that's the second item on our agenda at every meeting. Okay, because I'm being advised here that the Act says that particulars of any disclosure made under this clause must be recorded by the members of the authority in a book kept for the purpose, and that book must be open at all reasonable hours to inspection by any person on payment of the fee determined by the members of the authority. Now, that's been sent to me, so is there a book for conflicts or pecuniary interests, or is it just recorded in the minutes? Certainly recorded in the minutes, and whether the book is now being kept, I'm not sure.
Can you take that on notice and
I will, absolutely, yes.
And it also says there's a fee. As a matter of interest, if you could take on notice, just what is that fee?
Yeah, look, I'll have to take that on notice.
Okay. Thank you very much. So this morning, this is for Sydney Water, Dr. Bentley. So this morning, I was talking to the Minister about Tarana Estate in Austral. Is it Tarana or Tarana? Tarana. I don't know. It's a radio.
Got one more follow-up on that question, Mr. Crawford. Are the minutes available publicly?
The minutes are published on our website every month.
Okay, thanks very much.
Thank you. This morning when we were discussing this with the Minister, he went through, essentially it's about the delay, and he indicated that the resolution with the developer is in train. My word is imminent. That's not quite what the Minister said, so I don't want anyone to think I'm putting words in his... So are we able to find out just what is the time frame we can expect for this to be resolved?
Yes, absolutely. The solution is actually on the table and has been on the table for a few months now, and the solution is for the developers to take up. So at this stage, the developer has refused to take up the solution that is on the table, which is the interim operating procedure, which gives a possibility for the developer to connect to the network now. So that's what the Minister was saying, where the solution exists, it's on the table, and it's now the developer to accept the solution and to implement the solution.
Whilst we wait for the developer, then these poor people have no resolution really to this issue.
Absolutely, and that's a situation that we are following very closely, because we do understand what situation these people are in, and we're trying to convince the developer that they have to do something. But at this stage, the developer has not moved.
And is there so do we have a time frame at all? I mean, we're talking about, Sydney Water, so the installation of the system may be as late as June 2023. Is in my notes here.
So you're talking about the Tarana estate?
Yeah.
For the Tarana estate, the solution is on the table. So there is a possibility to have an interim operating procedure for the developer to implement. So this solution has been on the table for a few months. The problem we have is that the developer doesn't want to play ball. They don't want to implement the solution.
So there's a stalemate.
Well, until we get the developers to accept that they have to do something for their customers.
And in the interim, they don't have water.
No, but there's no houses on the development at this stage.
But you're not going to build and move into a place until this is resolved.
They're not allowed to.
They're not allowed to.
They're not allowed to. No, absolutely. And that's where we are in a situation where this Tarana estate was far away enough from our network so that they have to wait for the network to be built. But in the meantime, if a developer, wherever it is in the Greater Sydney area, if a developer wants to move on with developing a piece of land that is far from the existing network, they can do it, but then they have to discuss with Sydney Water so that we can find an interim, what we call an interim solution, which is connecting this piece of land to the network until development will reach this piece of land that they're developing.
So is there an additional cost to the developer as a result of the interim solution?
Absolutely.
What's the total cost?
I have to take that on notice, but...
Give us a rough ballpark figure. Is it tens of millions of dollars?
No,
is it $100,000?
No. We're not talking 10 millions of dollars. I'll get back to you with the cost, but just to be completely clear about what it is, we're talking about, for Tarana Estate, we're talking about a situation where we have a piece of land that is far from the existing network that the developer has decided to develop. Technically, they can do that, but we can't ask for all the customers in the Greater Sydney area to pay for the connection of this piece of land to the main network. That would be completely unfair. So in that sort of situation, when it happens, the developer has to fund the connection between their development and the existing network. And this is exactly the situation that we are in with Tarana Estate. So what we do in this sort of situation, we say, okay, there is an interim solution, which is building a pipe here, using another one that is existing there, etc. But then the developer has to pay for the price of the connection, which is fair, because if they don't, then it means that all our customers would have to pay for it.
Has the government stepped in any other circumstances? Sorry, let me go back a step. How many of these interim solutions have you actually put into practice before?
Many.
Okay.
Many.
And is there a situation where the government's ever stepped in to pay for them?
No.
Always been met by the developer?
Yeah, well, we don't get any money from the government, to be clear. The Sydney Water is a corporation.
I understand that.
So all the money that we have is coming from the money that our customers give us. So the government is not giving us money to do these sort of things.
No, I appreciate that, but obviously we're aware of the plight of homeowners who have been waiting and waiting and waiting, and that's certainly who we're asking the questions on behalf of. And I know our Shadow Minister has asked questions in previous budget estimates hearings about this. This is an ongoing issue. We want to see an outcome. We want to know what's the cost, and we want to know what the logjam is. So if you can come back to us this afternoon, that would be really helpful.
Yep.
Thanks.
And as you would have put, they can't reach to their land. Without this,
absolutely.
This is the impediment. Like without reaching land, they can't build on their land.
We are absolutely, we understand absolutely the situation that they are in. We have offered in this very specific situation actually to develop, to start constructing. They need what is called a Section 73 certificate.
Yep.
We have accepted actually to give this certificate or to bond this Section 73 certificate 6 months in advance, and that's that's the maximum we can do. But in terms of interim operating solution, then the developer has to come to the table.
Okay.
Sorry, can I just ask then, when are the works due to commence? If you don't do the interim solution, sorry, did you say that?
So if they don't do the interim solution, then the works for the overall connection have started and will be completed in December 23.
December 23, okay.
More than 12 months away.
Sorry?
More than 12 months away.
Yes, yeah.
Okay. So the Section 73 certificates then couldn't be issued until at least June next year?
No, because that's correct. We can give 6 months because we know that that's about the time that it will take to construct the house, and we can't give more because then we would get into a situation where it's a public health issue.
Okay, that's it.
Okay,
Yeah.
thank you. Mr. Crawford.
I've got a few. I could feel a bit more on the questions you asked me. So if I could, for the record, we don't have a book.
You don't have a book?
No, we don't charge a fee, but we do record the conflicts, as I indicated before. But there's no book. But there is no fee charged. And in my time there, I've never seen the book and I've never heard of a charge being made.
Okay, thank you.
And just in terms of what we do publish a document each month after our meetings, but it covers off all of our decisions at the meeting.
And that document's publicly available?
On our website.
They don't disclose, from what I can see, we've just had a quick look at the notices.
They don't disclose
minutes. They also don't disclose interests that are declared. Is that correct?
Well, no, but what I said before was in terms of the procurement, these conflicts arise in the context of a procurement of an external advisor, and any conflicts are identified in that documentation, which is prescribed by regulation.
We might come back to this.
Yeah, but they're not publicly available, I guess is where we're getting to. Yeah, so they might disclose them, they might leave the room, but there's nowhere where it's publicly available where you can actually go and see if that has happened.
No, in terms of, well, first of all, if it's a matter we're dealing with a liquor or any type of matter in the normal course of our business, that we record that conflict and that they're not in the room, but it's not publicly available. To the extent it's but to the extent it's to do with a procurement of an external provider, then that's our procurement team. The documentation discloses any conflicts, and it's made known to them in the documentation we submit it through the procurement process.
Okay. Just going to reflect on that for a moment.
Well, I think you would be probably entitled to access the procurement process through GIPA.
Yeah.
But it's on the record in terms of any procurement of a third party.
Yeah. Just going to reflect on that for a moment. Well, whilst we do, I mean, I just want to go back very quickly. This morning we were talking, Dr. Bentley, about Dubbo's boiled water, which was for a period of a month. And I think I posed at the time how many other instances has this occurred. Over lunch, I've had a moment to reflect. That's a big ask, but you did say you were going to get some information for me, so I'm wondering whether you've actually undertaken that.
I have a very good team who, while we were having lunch, have found out the answer. So 63 boil water alerts have been put in place since January 2019. And our estimation in terms of my local water utilities support team is that 37 of those should have been unavoidable. So 37 of 63 means the equipment should have been capable of preventing the poor quality water being put into supply, so there would have been a procedure or a training or some kind of operational issue. The encouraging thing is we have a thing called the Town Water Risk Reduction Program. Everyone talks understandably about the big dollars in Safe and Secure Water Program, but our approach over the last few years has been there's no point in just building kit. We've also got to build institutional capability and so on. So that program is working with councils to understand training requirements. We're putting in place training for councillors, training for operators, trying to make sure that we're getting the sort of human capital in the right place as well as the kit. And my team were with Dubbo Council in the last couple of days working through what can we do to ensure that these kind of problems don't happen again in terms of training requirements and so on.
Okay, and Dr. Bentley, but it's not unusual to have to boil water in some communities. There are circumstances that lead to this. It's, I mean, you know, I do it at home. In Tumut over the summer months, it was issues that cause that, but it's not for a month.
Yeah, indeed. I mean, some of that would be how complex your network is and how long the exceedance of whatever water quality parameter it was. So if you put water that's outside of spec, for want of a better description, into a long and complex network, it takes a long time for that to flush through. So that would be why there would be, and you will be aware, I'm sure, of the media, some of the media commentary that raised some eyebrows, shall we say. You know, I was concerned that, you know, the Mayor is questioning the health advice. Well, you know, the Mayor's the representative of the people, and who am I to say he shouldn't do that? But on the other hand, the health advice is provided by New South Wales Health because of the complexity of the network and the time it takes to flush it through. So it's not unheard of, it's not unusual, but it's concerning that it should be for that length of time, because the longer the boil water alert is in place, the greater the chance is that people will be ignoring it. The other thing I should say is that those numbers didn't include what happened in the flood situation, where there were some obviously unavoidable problems.
Yep.
Can you just provide us with the list of the 63 and the 37 and the period of time that they were required, that the boil water alert was in place for, please?
Great though my team is, I probably won't do that this afternoon.
On notice,
but we
sorry,
will get
I
back to you very soon.
No,
Yes,
that's good, and thank them for that. The only other thing I want to ask about this, Dr. Bentley, is, so is there sort of a national benchmark for this type of event? That you know, New South Wales would be benchmarked against other jurisdictions to see how we are comparing?
There is a national performance report produced by the BOM that compares water utilities of different types and sizes for a range of quality and volumetric and pricing parameters. Whether this is specifically one of them, I'll take on notice and come back to you.
Okay, if you could.
But that BOM report, the National Performance Report by the BOM, is produced every year. It has a lot of useful data in it, but I will come back to you on that particular point.
Okay, thank you. Can I just ask, at the last estimates, Water New South Wales said the Aboriginal water strategy would be delivered, and I quote, by the end of the year. Is it possible to get an update on just where that is at?
I think that would have been the department, not Water New South Wales. But
okay.
Unless you're talking about Water New South Wales is
that's
reconciliation action plan.
My notes here say at last estimates, Water New South Wales said.
Well, the department is funding us as under the state water strategy, the New South Wales water strategy. We have funding for the Aboriginal water strategy, and we've stood up a team led by an Aboriginal director that's working with First Nations and other groups to develop that. It's going to take a couple of years to get that in place because it's a lengthy and collaborative kind of co-designed process. But the work has started, the team is in place and is funded, and the same team will be working on such matters as the closing the gap targets and how we're going to achieve those.
Yep. Okay. I think that's much where I am at. Can I just indicate, Chair?
Sorry, Mr. Veach, could I just say the New South Wales Health website does list boil water alerts, so we'll happily answer your question, but in the meantime, if you wanted that, it's there.
Yeah. So there's poor water, but does that include boiling?
Boil water alerts.
Boil water alerts. Okay, thank you. And Chair, I just want to indicate Sydney Water. They took something on notice, and we're going to get back to us this afternoon. But if they don't, they could just take it on notice and get back to us in the normal course of events. I'd have finished with Sydney Water, and Mr. Chirac could probably go if he doesn't want to hang around.
Thank you very much. Response to your question, 1.4 million.
1.4 million.
For the interim procedure, yeah.
And how many, sorry, we've probably got this somewhere, but do you know how many lots there are? I
think it's about 17.
17?
Yeah, 70.
70.
70.
Okay,
yeah.
All right. Thank you very much.
Thank you. And I'm not sure whether Mr. Field had any more questions for Mr. Crawford, but I think we've rounded out our questions.
Oh, it's okay, Mr. Crawford. Thank you. Thank you for all your work.
Yep. So on that basis, I reckon he could probably go too.
I'm just looking at Ms. Hurst. You don't have any questions? No?
That would be good. And how long do I have left?
About a minute now. Do you want to...
Excellent. I just want to go back to, if I could, to NRA and Mr. Barnes. In response to a couple of the questioning, or a couple of lines of questioning from Mr. Field, you were talking about not progressing with prosecutions and the like. Can I just? I'm not sure whether you were asked this, but what is the cost to the department of actually withdrawing those prosecutions?
If I can just clarify this, there's no intent for INRA to withdraw itself from the use of prosecutions as an appropriate enforcement tool. 35 prosecutions to date compares to 2 in the Land Environment Court in the previous 18 years. So we've demonstrated quite a fine track record, I may say, about using that particular tool.
I fought very hard for NRA, so I'm not being critical at all. Read the Minister's second reading speech. He actually said, because of this bloke. So, yeah.
But to your particular question, when matters are withdrawn, it does subject the prosecutor to potential costs, and costs have been incurred by the Crown in some of those instances.
Are you able to take on notice and let us know how much?
To date, costs incurred by the Crown is $511,502.80.
Okay, thank you.
Sorry if I could. That's on those cases you've withdrawn from?
Correct.
Yeah, okay.
That compares with over or close to $2.5 million that's been forthcoming to the Crown through penalties, fines and other cost orders. So the ledger is looking positive in that regard.
Okay, thank you.
I've just got a couple of tidy-ups and then I'll hand back over to the other crossbench members. This might go to you, Mr. George. In February this year, my colleague Roy Butler wrote to the Water Minister with concerns from the Menindee and Lower Darling community about the inaccuracy of operational updates. It seems like they have a meeting with Water New South Wales, DPI Water, and then there's an agreed set of actions that are going to occur, and then there's been subsequent changes, and they've listened about 5 times this has occurred, and it's obviously caused them some inconvenience and some costs because of stock movement and etc. Can you, well, first of all, did the Minister seek some advice off you as to what was happening there?
Thank you, Mr. Benaziac. Yes, I recall the initial inquiry at the time and the difference of information, and I can explain what that difference in information was.
Yeah, that would be great.
So we, in terms of providing our operational information, our local team out of Menindee collect that data. That some of that data is collected manually. That team collects and puts that into a spreadsheet before providing that for data verification. So the data that we make publicly available through our Water Live website or our Water Insights portal does go through a data verification process. In an effort to provide very timely information to the local community, that often go to our local staff members at Menindee and get that information before it's been through a data verification process. So there are sometimes differences in the information that we're making publicly available and to that community firsthand. So we've now undertaken, we're still providing that information for a period of time to our community, but we're making sure that they understand that it's not verified data and that if they want reliable verified data, they should take that from our website.
Okay, thank you for that. Mr. Bentley, last estimates I was asking about some Commonwealth funding programs that obviously New South Wales can access, and you took on notice to tell me how much money New South Wales had been allocated through on the off-farm efficiency program, and you said you just certainly could tell me what had been allocated, and then the answer I got back was the off-farm efficiency program is an Australian government funding program with no actual figure as to what New South Wales...
Wanted something somewhat more detailed than that.
Yeah, I do. Yeah. Well, a figure. If it's zero, well, that's fine, but... Well,
let me find my appropriate page. So in the off-farm program,
I know we hadn't received any funding for the on-farm.
No, so
program,
in the off-farm program, we received on behalf of Murrumbidgee Irrigation, who actually deliver the works and therefore received the funding from us, $126 million.
Yep.
We've received $5 million for feasibility studies that Ms Emery's team are carrying out to identify other projects that we can take forward. We've just announced another program. Correct me, Ingrid, is it $4 million, I think.
2.4 million.
2.4 million. I knew there was a 4 in it. So $2.4 million has just been announced for another project. So thus far, 126 plus 5 million plus 2.4. We have 2 other projects currently being considered for putting forward to the Commonwealth for funding as well.
Yeah, and I'm sure there'd be some significant oversight by your department on that $126 million in terms of delivery.
Indeed.
On notice, could you provide some detail in terms of what that oversight looks like?
What it looks like? Yes, we'll take that on notice.
Oh, Miss Emery's putting her hand up. She can maybe save you some homework.
I think you might get a more fulsome answer than you got from me last time. Apologies for that.
No, it's all good. Wasn't sure whether the minister was playing silly buggers.
So of the 126.48 million, 124 million is being provided to Murrumbidgee Irrigation, and 2.48 million is to cover the cost of program administration and grants administration.
Okay, and just the level of just oversight, like what does that look like? Is there regular progress reports that they need to submit?
Yes, there is. So we have a funding agreement in place both with the Commonwealth Government and then with the Murrumbidgee Irrigation. Murrumbidgee Irrigation has several milestones they must meet under their funding agreement. We also have a project control group that meets monthly, which includes representatives from my team who will work with Murrumbidgee Irrigation to understand the progress they're making. They also have mandatory requirements to report any workplace health and safety incidents, and there's other reporting conditions set out in their funding agreement.
I imagine it's not just, it's like other funding agreements where they submit, a scope of works, and that might be for 10 million or 5 million, and then only that money's released, and they've got to show another set of, I guess...
There are milestone payments. Milestones, yeah.
Exactly. Yeah. Thank you. I think that's...
Could I add, Chair, sorry, just quickly, the projects that we currently either have in play or under consideration in that off-farm program will deliver something like 30 gigalitres of that, the 450 gigalitre recovery target that's often talked about, and it's been reported that only 2 gigalitres has so far been recovered. Well, New South Wales currently has approximately 30 gigalitres in play with more to come.
Okay, thank you.
Chair, sorry to interject, just not wishing to be outdone by my esteemed colleagues here. I'm able to answer a question I took earlier on notice from Ms Boyd. Would you like me to give a response to that now? Related to greyhounds that have lodged with at Council Pounds over the past 4 financial years. The number of greyhounds lodged at Council Pounds in 2018-19 was 3. 2019-20 was 14. 2020-21 was 45, and the last financial year, 2021-22, was 14. I'm advised that the majority of those greyhounds were subsequently moved to rehoming facilities, taken from Council Pounds and relocated to rehoming organisations, rather.
Okay, thank you. I'll throw to Ms Hurst.
And I'm still with you, Mr Griffin.
Segue.
I've just got some questions around disciplinary action, and if you don't have these data to hand, then I'm happy for you to take them on notice. I'm just wondering how many disciplinary action matters involving specifically animal welfare breaches by either owners or trainers have been investigated since GWIC was established.
I'll take that on notice. We have given that information previously to the Select Committee inquiry into GWIC, but I'm more than happy to provide
Thank you.
that to you.
Yeah, I'm not on that inquiry, but thank you. And also, if you could let me know, so one would be investigated, and then if you could also let me know which ones, how many were actually proven animal welfare breaches as well. And then also, and I assume this one might have to also be on notice, in terms of disciplinary action about animal welfare, what the average length of suspension or disqualification was in those cases.
Thank you. I'll take that on notice and get that back to you.
Thank you. I've got some questions as well about pin firing. I note that Local Rule 92A was introduced in December last year, banning any greyhound who's been subject to a firing procedure from competing in a race or trial. I'm just wondering if you could give me some background as to why that rule was brought in. Was there a concern that there was an increase or a high prevalence of pin firing in the New South Wales greyhound racing industry?
No, pin firings are illegal in New South Wales and under the Prevention of Cruelty to Animals Act, as you're aware. We're the only state that has pin firing as illegal, which I find quite strange. But so we operate under national rules. So the nationals don't necessarily rely upon, mention pin firing. So we would need a specific local rule. But we also need a local rule that encapsulated new innovative techniques in veterinary science. In that sense, it was called thermal capsular shrinkage, which we believe to be akin to pin firing. So we reduced the local rule, we consulted the local rule with industry, and it's now part of the local rules that we apply in New South Wales that, I guess, broaden the definition of what pin firing is, makes it broader than what the definition that is in the Prevention of Cruelty to Animals Act, which we think is very fair and reasonable, and also makes it more prevalent in the industry to make sure they're aware that they need to ask the vet what sort of procedure they're going to be conducting before it's conducted.
And do you feel that, I know that obviously the POCTA Act currently being reviewed into the new Animal Welfare Act, should the broader definition be included in this new Animal Welfare Act? Like, is it something that is missing from POCTA if it's too narrow of a definition as it currently stands?
I think that's certainly a matter for government policy, but it's in terms of how the racing rules operate, it operates effectively given that we've now created a local rule.
And do you know how many industry participants have actually been investigated or charged with that offence under Section 21A of POCTA? Is it something that's common or...?
No, thankfully it's not common. And so we did come across 5 cases that you would be aware of from last year. In each of those instances, we've issued warnings to the participants. We're still looking at the actual veterinary surgeon who undertook the procedures, along with the Veterinary Practitioners Board. But we issued warnings to those participants because they advised us they weren't aware of the actual nature of the veterinary process that was going to be undertaken. That was akin to pin firing.
Mm-hmm. And how will the new local rule be enforced? Is it something where we'll see greyhounds examined during inspections and race events, or is it?
Yeah, absolutely. So that's how this all came about, was through a veterinary inspection by one of our on-track veterinary surgeons at a race meeting, and we'll continue to do that through our own kennel inspections and race meeting inspections.
Thank you. I also wanted to ask about surgical artificial insemination. It's estimated that 80% of greyhound breeders in New South Wales use surgical artificial insemination, and there's significant veterinary and community concern around this procedure. And I note that it's also, the frozen version is actually banned in several countries overseas, and it was proposed to be banned in early drafts of the New South Wales proposed animal welfare bill. Do you know if there's any work that's been done within the greyhound industry to actually shift away from this procedure at all?
I understand there's some research work being done by Greyhound Australasia, because the greyhound industry operates under national rules, and if they were going to move in a different direction in this sense, they believe there should be a national approach, which makes sense. So I think at the moment Greyhound Australasia is conducting that research to determine whether there should be a change in policy across the country.
Okay, great, thank you. Another concern that's been raised with me by animal protection groups is around footage of greyhound races where an animal is injured or killed, and then the footage is actually quickly edited on racing sites to actually hide the injury. So in effect, they're actually sanitising what occurs to the public. I wanted to ask if this was an issue that's been raised with GWIC at all.
Yes, it has, and in other forums, and the actual footage is not GWIC's, it belongs to Greyhound Racing New South Wales with their proprietary and commercial arrangements with various service providers. So yeah, GWIC doesn't have any control of that vision.
And so you have no way of actually accessing the footage. What if you needed it, like for enforcement or investigation?
Sorry, should have made myself clear. We certainly we do access the footage to when we do a race injury review. We review all the major and catastrophic injuries to looking for causations, and so we do have access to that footage. It's just that it's not provided publicly.
Thank you. I just wanted to go back. Mr. Keon, I think you took a few questions for me, and you said you might have something in the afternoon.
So in relation to the TAWWG report, in relation to recommendations coming out of that, the recommendation in relation to creating a national welfare standard, that's currently being considered by the Department of Primary Industries. So the Minister for Agriculture would be the responsible minister in relation to that. In relation to the National Traceability Register, there's been a national working group formed which is being led by the Victorian Department of Jobs, Precincts and Regions. That working group's been consulting with the industry about a property identification code and the potential use of microchipping. And the latest advice we have is that they'll bring a report to the upcoming Agricultural Ministers' Conference in a couple of months. And then the balance of the recommendations, I'm advised, are a matter for Racing New South Wales to consider.
Thank you.
Thank you, Chair. And if I could, Mr. Barnes, just to clarify something from your last evidence, of those 26 instances currently under investigation, these are of potential floodplain harvesting irregularities in events over the last couple of years. Are you able to break down which of the valleys these investigations are condensed in? Any idea of the numbers in each of the valleys?
We've prioritised those 26 to be 7 that we are on farm at the moment, and they are in the Gwydir and the Border Rivers.
All of them in the Gwydir and the Border Rivers? 7
are in the Gwydir and the Border Rivers.
Right. Is the reason that you focused there is because that's where the licences have been issued, or that's just where the take has been
one of the determinants that have led us to prioritise those cases.
Okay, thank you very much. Mr. Keon, I've got a couple of questions for you, if I could. You'd be aware of this joint investigation that was conducted, law enforcement agencies, I think ILGA, Liquor and Gaming were involved, the Crime Commission were involved into money laundering and pubs and clubs. There was a report that was, I think it was leaked to the Daily Telegraph, described as the overview of findings relating to COVID reopening anti-money laundering investigations at New South Wales pubs and clubs. You're aware of that?
Yep, certainly.
Report, it's out there now. I know it's probably not what you'd like to have out there. You'd be aware that report states in the section that says implications and considerations, evidence collected leaves little doubt that electronic gaming machines are being used for large-scale money laundering by organised criminal groups in New South Wales?
Yes, I am. That report states that, yes.
Yeah. Has there been any ongoing data tracking and surveillance activities since that report was published?
Yes, so as you're aware and as you point out, the Independent Liquor and Gaming Authority and the New South Wales Crime Commission have set up an inquiry. Liquor and Gaming New South Wales, as well as other regulatory agencies, are part of a joint task force helping assist that. So, as part of our activities, we have issued 189 notices to 39 premises seeking further information, and that information is then supplied to the Crime Commission for their consideration.
Right.
So, it's important to note that we don't directly regulate money laundering. It's largely a police matter and AUSTRAC.
Understand.
So our involvement is really from a intelligence or assisting where required in relation to that.
Those notices to those venues, is that as a result of this particular investigation? I understand there is ongoing data tracking through the CMS, Liquor and Gaming, and monitoring suspicious transactions. It gets raised in this report there might be some constraints around resourcing to continue to do that sort of monitoring. So I'm trying to get a sense if you're still doing that data analysis, still forwarding those suspicious transactions on for investigation.
Yeah, there's quite a few things we've done. So at the start of the year, we actually increased our resourcing in our intelligence team. So we put on 3 new intelligence officers. As part of that, we've also improved through the CMS provider the reporting available directly to venues to try to tackle that. So in the last, I think it was about 5 weeks ago, we released a suspicious transaction report to industry. The CMS made that now freely available for each venue to be able to help detect that. And now we're awaiting the Crime Commission's report to see how else we can assist and what we need to do going forward, bearing in mind we are not the experts in this space, so we're looking for their guidance in terms of what they want. In addition to that, we're developing a data lake and a data warehouse. At the moment, the way that we can get into the CMS data and evaluate that is quite challenging and quite clunky. So through the development of the data lake and the data warehouse, we will be able to better interrogate that data and then support our regulatory partners.
You might not be the expert, but you're the keepers of the data, right? You receive it and you're the ones that are able to interrogate it.
We can, and we can also make that available to other regulatory agencies as well.
Yeah. But the CMS system reports back to your people.
We can access the CMS data, yes, that's correct.
You'd be aware of the public statements made by Mr. Troy Stoltz about the compliance levels at New South Wales clubs with regards to their anti-money laundering.
I've read some of those media articles, yes.
My understanding is that those documents raising concerns, these were internal Clubs New South Wales board documents, were provided to Liquor and Gaming at the time, before your time, I might add. Were they ever investigated by Liquor and Gaming?
I'd have to take that on notice because it was prior to my time.
Sure. I mean, these issues are live at the moment. I mean, subsequent to that, we've had this reporting which shows that there's, well, I think as
what I would say is that
little doubt that electronic gaming machines are being used for large-scale money laundering by organised criminal groups in New South Wales. I mean, they were exactly the concerns sort of flagged in these board reports about compliance with money laundering. So you must be aware of this.
I'm aware of those media reports, but we have no enforcement powers in relation to that. So if they're not complying with the AML-CTF requirements, that's a matter for AUSTRAC to enforce.
So my understanding is Liquor and Gaming received these reports at the time that they were being made public through the Parliament and the like. They were provided by Mr. Stoltz. You're saying Liquor and Gaming has no obligations at all in the event that clubs that it regulates aren't complying with their obligations with regards to anti-money laundering and organised crime. You've got absolutely no interest in that?
No, I didn't say we had no interest. I said we had no enforcement powers. So the general process should be that they would be then referred through either through the current Crime Commission inquiry or to AUSTRAC.
Well, this all occurred before that.
Yeah, that's my point. And that's what I'm saying. So I can take, in terms of what we specifically did with it, I can take that on notice and come back to you and confirm that. But what I was saying, in terms of our ability to then take action coming out of that, in terms of direct enforcement action, we have no legislative basis to that. So anything that we could do with it should be appropriately referring it to those agencies that can take that action.
Okay. If I could, Chair, just one last one on that. Are you okay with that, Mick? Yeah, I think it was before you. Are you aware that just today it's been made public, because the suppression order's not been made by a court today, that Clubs New South Wales are bringing criminal contempt proceedings against Mr. Stoltz for making this information about low levels of compliance with anti-money laundering and organised crime obligations by clubs in New South Wales into the public arena. Are you aware of that?
No, I wasn't aware of that.
It seems like a really strange approach for Clubs New South Wales to take when there's literally a Crime Commission investigation into these very issues at the moment.
And that's something you'd have to take up with Clubs New South Wales.
Only I could invite them to estimates, Mr. Keogh.
I know, and I don't think it's appropriate for me to comment on their
Sure, but you can understand why I tried.
Yes.
Thank you, Chair.
Thank you. Just before I go back to the opposition, they have indicated they no longer require the services of Mr. Barnes, but I am looking to you, Mr. Field, to see whether you still have further questions.
I'll survive.
You sure?
Sure.
Okay. Well, Mr. Barnes, you are free to leave as well. Thank you for your time.
Thanks.
I'll throw it back to the opposition.
Thanks very much. I just wanted to, Mr. Griffin, I just wanted to ask you about this Greyhound Racing New South Wales survey, which the Minister referenced that you knew about it as well, or you'd been part of the discussions about it as well. Are you able to tell us, I mean, and I say at the outset, I understand I'm a member of the GWIC inquiry. I understand the relationship between Greyhound Racing New South Wales. I've read those questions and I understand that some of those questions went to the heart of some of those issues between the two organisations. I'm just merely wanting to understand, when did you first find out about the Greyhound Racing New South Wales survey?
I think it was on about the day I notified the Minister's Office of the survey.
Okay, and so that was, so according to the questions that he's provided me, or the answers he's provided to my questions on notice, that was on the 12th of November. Does that sound about right?
Sounds right. No, I think there was a Section 52 order in relation to it where all the documentation, emails exchanged between myself and the Minister's Office and others. So I think if I rely upon those documents as the accuracy of that.
So it's safe to say you notified the Minister's Office?
I did. I notified the Minister's Office of the survey.
Yeah.
I'd been sent the survey or snippets of the survey by industry participants.
Yeah.
Yep. And given the nature that there was a telephone survey that had been done number of months earlier that I wasn't really happy about. I wrote to the Minister's office.
And do you want to tell us why you weren't happy with the telephone survey?
Well, it actually was a survey that canvassed participants' views about the role of the Commission and how it was performing. And I did not believe that was the right of the GNSW to canvass those views. This is not its charter.
And so do you, is it your understanding that that telephone survey had similar questions to what was in the online survey?
No, it had probably more. The telephone survey had more in-depth, GWIC specific, and other. They were certainly non-political. The telephone survey was certainly more about GWIC and participants' views about racing generally, and some aspects of GNSW services as well. But no, the actual online survey was somewhat about GWIC, but also obviously about political views as well.
Yeah, canvassing political favourabilities on leaders, which is not really the right thing for government organisations to be doing. But I understand the Minister communicated that to Greyhound Racing New South Wales. Have you ever received any information about the outcome of the survey? Has that ever been communicated to you?
Not formally. No.
Yeah, okay. I didn't expect it would be, just wanted to check. I wanted to come back, Dr. Bentley, I'm not sure if you're the right person to be asking this Cooks River issue about the steel pilings. Do you know is there anyone who can answer some questions about that for me?
Aware that it's a water department issue, for want of a better name, but I will find out for you. We will do it.
Of course. No, I understand. Dr. Bentley, I just had one final question, which is obviously the Warragamba Dam is a big issue, the raising the wall. Who is your understanding of the minister responsible for that?
My understanding is that it's the Infrastructure Minister.
Okay.
That's 2 out of 4 for him now, is it?
Yeah.
2 bids
It's
for
been
Rob.
an interesting ongoing question in estimates, which you've probably been following, but that's I think that's all we have. Can I just say thank you very much to everyone for all your assistance today?
Thank you.
So opposition is finished with their questioning, so I think we're done, are we? Oh, no.
You can send them all home other than Dr. Bentley, eh?
Mr. Field, you have the floor.
Thank you, Chair. Dr. Bentley, I wanted to go to this email that I referred to earlier in the day, if I could, from Dan Connor to yourself. And it was from back in February, and I do appreciate that things have moved on a little bit. You may or may not be aware of it. You don't really need to have the specific details in front of you, other than that in making an argument for how to sort of move forward with getting a resolution on, or progressing floodplain harvesting reforms, as he's put it, he suggested the establishment of downstream flow targets, which at that stage they hadn't been part of the discussion. And he specifically says this would include rules that prevent floodplain harvesting access when there are downstream critical human and environmental needs. Of course, that's what they're about. And then goes on, we would propose using the draft Section 324 triggers now published on our website. Then says, FYI, this is to you, Angus has developed alternative targets that do not have a strong technical basis and that we consider will not address stakeholder concerns or the inquiry recommendations. That was the upper house inquiry that had been conducted. I assume he would have been speaking of Angus Mackey from the Minister's office here, would you know?
I haven't got the email, but that's not an unreasonable assumption.
Do you know which of those target options are the ones that ultimately have been pursued?
No, particularly not having the...
Yeah, sure.
It's some months ago and it's not in front of me. But I think, given what you said before this morning, Mr. Field, you used the phrase, I think you said, well, it's not a subjective thing, it's a legislative thing.
I think we all realise it's pretty subjective.
Well, it's very hard to, when you look at the whole system, it's very hard to say how much of each of these things should you do. I mean, fundamentally, what these reforms are doing, according to the modelling which the MDBA has now verified is appropriate for Murray-Darling Basin Plan use for...
Which has nothing to do with the priority of use provisions of the New South Wales Act, though, you would agree. Whether or not it meets Murray-Darling Basin Plan limits, that is not a measure of meeting the legislative requirements of the New South Wales Act.
It's a pretty important fact, though.
But it is
when our numbers have been challenged about what we're saying floodplain harvesting would achieve, which they have been repeatedly, and the modelling has been questioned, it's really helpful. But anyway, whether we believe the modelling whether you believe the modelling or not, we're saying for those two valleys, 45, 46 gigalitres per year on average would be removed from the amount that is being harvested off the floodplain. So to me, it's really hard to argue that that is not in itself satisfying to quite some degree our responsibilities under the principles of the Act, because we are the ecosystems.
Then why would Dan Connor say at the end of this, it will strengthen the case that the Minister is taking all reasonable steps to comply with the Water Management Act? I agree, because I remember in December last year I was raising this as an issue, and the fact it couldn't meet priority abuse provisions because you weren't making these efforts. Now he's acknowledging that if we make put downstream targets in, we can help address this requirement under the Act. I get that. It is a step towards that, somewhat subjective. He's saying a legal challenge on these grounds is considered likely. Do you have legal advice to suggest that it's a bit shaky, the floodplain? What would he have been referring to there? A legal challenge is likely. Why would he have thought a legal challenge was likely?
Well, you would be aware that in other aspects of the work that we're doing, water sharing plans, for example, legal challenge is there. That doesn't mean that we think we're on shaky ground, but thank goodness we live in an environment where people have the opportunity to challenge things legally, and they have done and they do. When I'm talking about subjectivity from our point of view, Mr. Field, it's not about whether or not we believe numerically this is making an improvement. Clearly, if you want to minimise the chance that anyone's going to challenge you, you say, well, if we did this and this and this, that would minimise that chance. Does that mean that to satisfy the principles of the Act you have to do all of those things? Our argument would be no, and the subjectivity is, well, how many of them is it reasonable to do, given that I know you don't like the balance word, and we've discussed some of those
Not
matters.
in the Act.
Well,
the Act is pretty clear. It says meet the environmental needs, which are based on water-dependent ecosystems, meet critical needs, and sharing for other users should not prejudice those two things. It's actually it's not a question of balance at all, according to the Act.
I provided you before with the legal advice that I was provided with by our former General Counsel, but...
That's a question of whether or not the take is legal according to has someone used a licence in the right way and are they entitled to that take? That is not actually in any way, shape and answer of whether or not
I think, Mr. Field,
you've met the requirements of the Act with regards to priority of use.
I think I provided you with advice from our former General Counsel that said that to satisfy those principles under the Act, you don't have to do everything for the ecosystem before you consider doing anything for the next order. And that's where we have differed before, Mr. Field, and we clearly will differ going forward. What we're putting forward is the fact that we're leaving 45, 46 gigalitres per year from those two valleys to do environmental good in the floodplain. That water sharing is enhancing the ecosystem. Now, you might argue, and it's not an unreasonable argument, yes, but you could do more value. But that water sharing change we're making is improving the ecosystem. It's really hard to argue that it's not. So I'm saying the subjectivity comes in when you say, well, how much more improvement do you need to do before you also make other considerations? But we're not actually making more water available for industry. We're making less water available for industry and more water available for the environment. So I don't see how that doesn't satisfy
It depends on what baseline you're starting from, of course. And the argument that has been made around using downstream triggers built around the environmental watering requirements, not just my argument. The argument made by the Environment Department, the EHG officials, very clearly in these documents to the Minister, your targets are too low, may not comply with the Act. If you're not grounding them on the environmental water requirements set up by the Environment Department, when the Act specifies deliver on the the needs of the river ecosystems, what are you basing it on? Like, you have an objective measure available to you. It's work by the government. So I don't understand how you then say, well, it's a matter of balance, we're doing a bit better anyway. If the river doesn't get the drink it needs at the time it needs, certain ecosystem functions just don't happen. This is supposed to be some of the it's an opportunity take, and what you're doing by licensing it now is making it some of the most secure take, actually. And what we are arguing is not that it shouldn't happen, nor should it be licensed, but that when required to meet the ecosystem needs and critical human needs, the water should be allowed to get downstream. It's the same argument being made by the Environment Group. You're taking a different view quite clearly. And I don't think that the documents that you've put out, the various tables which show now, or you're trying to show how you're delivering against the principles of the Act, they don't actually show how that's delivering the environmental functions. It's just saying that it's doing that because we are... we're operating according to the Basin plan or the sustainable diversion limits or the long-term average annual take. But as you well know, the NRC have criticised that approach on an ongoing basis. And I note the minister's seeming disdain for the NRC's advice on this morning.
I'm not sure I heard any disdain, but I didn't hear him say anything.
The NRC would have heard it, but...
Well, I meet with the NRC. I met with Professor Hugh Durrant-White and his team and some of my team just a few weeks ago to discuss, in their view, what should we be doing to improve the water sharing plans for all those reasons that they have that oversight. So we take that very seriously, and I think, it would be amazing if we lived in an environment where an independent body like the NRC reviewed what we were doing in such a complex field as water sharing planning and didn't find improvements for us to make. They also, incidentally, find some things that are working quite well. We don't give much attention to those. But some things are working well, some things need to be improved, and we take into account the advice of the NRC as we consult with communities over all the improvements we make to water sharing plans as they're reviewed. So that system, and when I first started this job, you were quite rightly critical of the fact that we were behind on those reviews. We're doing well on those reviews now, and we're taking the advice of the NRC whenever we can, and we're certainly taking into account in consultation. Could I just add as well, Mr. Field, we're not just saying we're saving that amount or reducing that amount of floodplain harvesting. If you look as well the changes we've made in the Bowen-Darling water sharing plan and in that system, the frequency of low flow events and no flow events will be reduced as a result of the changes that we've made.
I agree.
So when you know
it's been a very long and drawn-out process to get to the point of acknowledging the problems with regards to those plans. And when they last for a decade, I don't want to belabor this point, and if you can indulge me for a second, Chair, I can finish off this line of questioning very quickly, and then we might be able to... Have you got more?
No.
Emma, have you got more? Oh, okay. Well, do you mind if I just just a few more minutes? Yeah. But I acknowledge that.
Thank you.
There is a requirement in the Act to do Section 10 reviews.
Yes.
ICAC. It's not just me. It's ICAC saying...
I'm agreeing with you.
Yes.
I agree with you.
And we've had this debate before. Okay. The government acknowledged and said that they would do this Section 10 review to address this issue of, systemic non-compliance in the views of ICAC with the priority of use provisions of the Act. That's now been pushed off from...
No, it started.
Well, it was supposed to be delivered by March 22, right?
It started.
It started. When will it report?
June 23.
Okay, right. That's just after the election. Oh, geez, that's convenient. When was the last one?
I think you know the answer, but it's...
I do know the answer.
Shall I say it? 2011.
Please. 2011. So this government has never done one of the 5-year reviews that are required. The language, I think I wrote it down here. The language in Section 10, the Minister is to ensure that the work and activities of the department are reviewed at intervals of not more than 5 years for the purpose of determining whether they have been effective in giving effect to the water management principles of this Act and the State Water Management Outcomes Plan. This government, since it got elected in 2011, has never done that, has they? Until now.
It's a matter of fact that the last one was 2011, so I'm not arguing with that. All I can be accountable for is what I have done since I came into this post just over 3 years ago. And in our response to the ICAC report, one of the things that we've done in the interim while getting this review now underway is that review of policies that we discussed.
You and I are in here having a debate right now about whether or not you've been effective in giving effect to the water management principles of the Act, and the review that's supposed to decide whether or not you've been effective in delivering and giving effect to the water management principles of the Acts have never been done. This is a frustrating process, right?
It's now underway, and I wouldn't say that review is the only thing that determines, right? That's one thing. You asked me last time, we had some to and fro over the number of our policies that have been reviewed to show that they're compliant. 10 out of 14 is a yes, 1 isn't relevant, 3 are partially so. So those things we committed to in the ICAC response, we have been delivering on, and those are improving our understanding of the extent to which we are complying with the principles of the Act. I accept that, some of these things should have been done quicker, but, was it ever put to a minister sometime in the last 5 years, hey, we've never done one of these, maybe you should, and the minister went, no, I don't want to do that? In the last 3 years and 2 months, I can certainly say to you, I've never heard a minister say that to me about any such thing, and I have not recommended that we do this and the minister said no. I think whatever we think of, the fact that the MDBA have verified our modelling, Mr. Field, I think that, again, is another important step towards saying at least there's a basis for some of the decisions that we've been making, and it's not all as subjective as it sounds. Yeah, okay. How much technical knowledge have you got on the new redrafted Greater Metropolitan Region Unregulated Water Sharing Plan? If I was to ask you quite a specific question about the Tarana Dam and environmental releases, would you have a clue? Well, I'd have a clue what they're about. So the NRC reviewed the water sharing plan and made recommendations to review the environmental release regime for the Shoalhaven River, I think by 2025, or I think by 2025 or 2027. In the redraft that's been done now by the department that's out for consultation, you've proposed what I see as quite substantial changes to the environmental flow regime for the Shoalhaven River without having done that review, and we'll see more water transferred from Tarana Dam, I think, but also provide for less environmental releases. What they're doing is going to make the releases from Tarana downstream into the Shoalhaven. It's going to be linked to the storages in the Greater Sydney area for the first time. So what that seems to mean that if the storages are falling, then less water is released from Tarana Dam into the Shoalhaven. And I want to know what modelling has been done about how that's going to change the environmental flows in the Shoalhaven over the cycle. I was really hoping, as you were asking that, we were going to get to something I would know the answer to, but I will be taking that bit on notice. No, that's fine. But can I say, when you said more water will be transferred, you're talking about from Tarana to the Sydney system? Well, I get the sense that that's what it's being set up for. It's to make sure that there's more water in Tarana, but when it's needed in Sydney, it can be transferred. I know it's not transferred at the moment until you hit 75%, but hey, it's pretty clear in the strategy just released that you're looking at changing the regime for transfer. It's not spelt out. It sort of makes mention of this draft water sharing plan. If I could, because I know a little bit about this. Yeah. My colleague probably knows more than I do, but let me just say, the approach of the Greater Sydney Water Strategy, and this is something I did inherit when I came into this job, was the Metropolitan Water Plan that preceded it. And there were rules and triggers in there that when we were facing the last drought, it turned out they weren't fit for purpose. And the government did the right thing in deciding, well, we need to look at those rules. This is a good opportunity before the next drought comes along, while we still have a lot of water, to say, are these things we're recommending the right things? And that's really where we are. Well, can I get an undertaking? Because I appreciate that you might want to change the triggers where you start transfers. I get that it was built for that purpose, but can you please do the review on the environmental flow regime for the Shoalhaven when you do that, instead of just changing the triggers without having done the review that's been recommended by the NRC? Because at the moment changes are being proposed, but we haven't actually looked at the
outcomes for the river downstream of the dam.
Let me look at the totality of your question and give you a reasoned and considered answer. But could I say, as you mentioned, the Greater Sydney Water Strategy, I think we should be acknowledging it has the biggest focus on conservation, demand management, leakage reduction, and making the best use of it than we have ever had before.
It's been a decade wasted.
But it's come.
But yeah.
It's come, and it's a blooming good piece of work, I think. I'm a little bit biased, but I'm proud of the fact that we are putting first, right up there, conservation and demand management and efficient use of this precious resource. But it does show, as we were talking about earlier, some more augmentation will be needed in the future, but it comes off the back of let's make the most of demand management.
I acknowledge that. Thank you, Mr. Chairman.
Thanks, Mr. Field.
Yeah.
Thanks, Chair.
All right. I'll hand over to Mr. Taylor Martin to...
Are you the lead for the government today?
Thank you, Chair. Dr. Bentley, if we can just go back a few minutes there to the exchange you had with Mr. Field in regard to floodplain harvesting. I heard you mention in regards to the modelling. How can the public have confidence in the veracity of the modelling and also the accreditation of it?
How can they have confidence in it? Because it's been independently verified multiple times, including now by people appointed by the Murray-Darling Basin Authority. And you know, sometimes I think people have a misconception that my department and the Murray-Darling Basin Authority are sort of working hand in glove. And seriously, you know, that's why it's a challenge to get our water resource plans accredited, because we're not all just like backing each other in. We are seriously challenging. And for a body like that to say that their experts have reviewed the modelling and it's appropriate, I think the public should have confidence in it on that basis.
Right. Thank you, Dr. Bentley. I'm convinced.
That's pleasing to hear. That's a good note to end on. So I guess unless people want to clear the decks in terms of things that they've taken on notice but they've got here ready to go, we can call it a day. But
one quick one, Chair.
Yeah, sure.
Mr. Veitch, I think you asked me about the Safe and Secure Water Programme and numbers. It's the paper I have here. There is nothing left that's unallocated.
All allocated?
It is all allocated of the billion. And in the budget that was just completed, we were given another 90 million, and that money will be used to be shovel ready for all the remaining high risk schemes, whether it's water security, water quality or wastewater. So we've got 2 years to be shovel ready for everything that's left to be done to clear those high risks, which will still be a high investment requirement following that, but I'm really pleased that that's where we've got to.
Okay. Well, that concludes today's hearing. All the obviously remaining questions that are still on notice, you have 21 days and the committee secretariat will be in touch with those for you. So once again, thank you all for your time, and we'll see you next time.
Thank you. Thank you very much.
Thank you.